Morena koutou. Ko Jamie Lee tūtu toku iwa he paurehita o te whakamana o te tiriti o Waitangi. Just a quick housekeeping before we start. As you know, it's pretty packed down here. We will be having some media. We've asked them strictly to be non-intrusive during our day today. I just want to point out a couple of things. So we have a screen and also speakers in this room as a breakout. On level 7, we'll also have the live streaming in the bigger room with seating that is available. Upstairs also there are facilities, toilets and whatnot up there, and also down here, and there's some signage here too. We will start soon, but if you have any questions, let me know. Thank you.
Check one, check one. Check one, check one.
Mōrena koutou, I ngā pō, ka pauri taka nākau I rongo kei te mauiwi ahorangi pau temara. Nō reira, ka tuaki nei ki te mihi. He mihi tuatahi ki a koe pau, he mihi aroha ki a koe, ka piki te ora pau. Tuatahi mawai, he karakia, he whakatūwhera tā tātou nohoanga I nāia nei. Kia ora. Tuatahi, he mihi tēnei ki a koe tū, nau I whakakākahu tā tātou nohoanga ki te koro ai o te atua. Nō reira tēnā koe. me ki he huihui tangata ka hokinga mahara nō reira ka huri aku whakaro oku whakaro ki ngā tātou tini mate kua wehi atu nei ki tua i te arai nō reira ki a rātou haere atu rā ki te wāhi whakamutunga mō te tangata tai pau rātou tai awatia tātou tihei mauri ora. Ka mihi hoki ki te haukainga, te ati awa, tai atu hoki ki Ngāti Toa, tēnā koutou. Nā kānohi katia ka huihui mai nei, ki runga i te kaupapa o te rā, tēnā koutou. He kaupapa nui tēnei, he te horapaki o te mahi tapahi, te hongonga o ngā Tamariki ki ngā whānau me ngā whakapapa hoki. Nō reira, he kaupapa nui, he kaupapa roa. Nō reira, tēnei te mihi atu ki a koutou, ka huhui mai nei, ki runga i te kaupapa o te rā. Ngā roia, o ngā kaikareimi, ngā roia ki te korona, tēnā koutou katoa. Nō reira, he rā nui, nō reira, kaue kumiroa taku kōrero i nāia nei. Tēnā koutou, tēnā tātou katoa. Nei, te manu ti ori o te rōpu whakamana i te tiriti, tēnā koe. Mōrena anō. Just before I take appearances, I just want to introduce the panel and to firstly acknowledge, as I said in my mihi, the absence of Ahorangi Pou Temara, who is unfortunately unwell. We keenly feel his absence and his wisdom, and we wish him well. To my immediate right is Professor Rawania Higgins, and to my left, Ms. Kim Narimu. We're also assisted today by Ms. Orpha Cassidy, who is counsel assisting the tribunal, and she is seated behind the lectern to my left. All right, I'll go through appearances by a list of counsel, and I think, Ms. Mason, I'll come to you last. I understand you're on Fiji. All right. Mr. Stone.
Te kai whakawā me tō kāhui, tēnā koe, tēnā koutou. Tōku tuakana Conrad, kei roto te pāka whakapākia te tuakana, whae te tika. Te whare, ngā kahurangi, tēnā kōrua. Kōrua me ki koutou katoa, ko haramai, kei runga te karanga, te mamai o rātou ngā whānau Māori. Haramai, koutou katoa ko haramai, hei whakakaha a mātou tuara. Koutou ko haramai, hei whakakaha ngā whānau e tangi ana. Tēnā koutou. Haramai, e tika rawa te mihi o tātou kai whakawā. Ko te kaupapa o tara, te tapahitanga o rātou, te kāwana, te honua o te mokopuna Tamariki, te whānau. Nō reira, haramai ka runga te karanga pauri, te mamai hoki o rātou. Tēnā koutou. Sir, my client today, Auntie Jean Tahuia, she gives her apologies. She's in the South Island today. Her wide number 2823. Sir, my other client, Mr. Rex Timu, he's here. He's at the back there with his wife, and he's assisted by Mr. Johnny Nepiapatu. Tēnā koutou. It's good to have you here. I'm just glad to be here, sir, and I'm glad that we're finally getting things started. I look forward to today and tomorrow. Kia ora.
Thank you, Mr. Stone. Kia ora. Tēnā korua to your clients as well. Ms. Sykes.
Kia ora te tēpu, kia ora tātou i hui hui mai nei, kei raro i te maru o tēnei kaupapa whakahirihira e pāna ki tō tātou nei taonga, ko tā tātou nei mokopuna Tamariki. I runga i taua tūmanako, kei te mihi atu au kia koutou, i tai mai tawhiti, i tai mai tata, ki te aki tēnei kaupapa i mua i te tribunera, kia whai te huarahi tōtika mō tātou te iwi Māori. May it please the tribunal, I appear today for two claims. The first one is Y2494. It's been listed as a claim as an interested party, but it was one of the first applicants. It's claimed by Mrs. Donna Awatere Huata, supported by many survivors of abuse who are also participating in the Royal Commission on Abuse in State Care and Religious Institutions. Paula Moyle, who's the principal witness, is listening in Australia because of COVID, can't be here, and offers her apologies to the tribunal, but she is avidly listening, and we have placed a brief of evidence for her on the record. The second claim is a significant claim, was one of those that was part of those which enabled urgency to be granted. It's a claim by Dr. Rawiri Waratini Karena, Dr. Alison Green, and Ms. Kerry Nuku, Y2891. It's a claim that brings together all of the parties who are at the coalface of practice in Oranga Tamariki, social workers, nurses, health workers, academics. I also can say that two of my principal claimants were victims of abuse in state care, and so we are very aware of the intergenerational issues arising from this particular matter. Kia ora.
Kia ora, Ms. Sykes. Thank you. Mr. Benyon.
E te rōpū whakamani te treaty o Waitangi, tēnā koutou. E pau, e mihi aroha ki aia. Ngā kaimahi mō ngā whānau Māori, piepi Māori, tēnā koutou katoa. Appearing here, sir, today on behalf of Mr. Aaron Smale and Tony Jarvis, who are in the Abuse and State Care Inquiry. They're Y1911, and Mr. Jarvis, I'm asked to give his apologies, or the fact that he wished to be here but couldn't be. I understand Mr. Smale is listening on the live stream. And the other claim is 2408, and that's for the Aporo whānau, Tesa Aporo in particular.
All right.
Kia ora.
Thank you, Mr. Benyon. Ms. Downs, and, kia ora.
Tēnā koe te kai whakawā, ngā me mō te tribunera, te krauna, aku hoa mahi, tēnā koutou katoa. Council's name is Ms. Jamison. I appear with my friends Ms. Downs and Ms. Tere on behalf of Ngāti Hine, which is Y682, Te Kapotai, Y1464 and Y1546, and Ngai Te Rangi, which is Y2955. Kia ora koutou.
Kia ora. Kia ora koutou. Thank you. Ms. Smale?
E te rōpū whakamana I te tiriti tēnā koutou. Council's name is Ms. Smale. I appear with Ms. James for the Y2941 claim.
Tēnā koe. Dixon and Co. Ms. Dixon? Is Kelly Dixon, Aroha Herewini or Alicia Castle present? Carl? Mr. Naden, Tamariki Legal?
Microphone, please.
I appear on behalf of Tamariki Legal today. Counsel's name is Ms. Sudaka. I'm appearing on behalf of our clients, Ms. Tienga Harris, Ms. Lee Harris, and the Harris whānau, which is Y1531, Ms. Mona Virko Cliff, and the Cliff whānau of Nāmaihi, Y2863, Ms. Tasilofa Huirama, on behalf of the late Zipora Huirama and her whānau, who are members of Ngāti Ue Oneone and Ngāti Tautahi, Y2890.
Thank you, Ms.
Tēnā.
Sudaka.
Tēnā koe, sir.
Napo Lipscomb Lawyers?
Tēnā koe, Your Honour. Council's name is Ms. Ramika. Today we are appearing on behalf of Denise Mesera, who's appearing on behalf of the Te Whairiki Manawahine o Hauraki, Y2938. Also Vanessa Taupaki, Y2939. Also Y2895, a claim by Nicola Deli Paki. Y2940, a claim by Cara Lindsay and whānau. And Y2937, a claim by Nolan Hughes and whānau. Kia ora, Your Honour.
Kia ora. Thank you. Mahoney Horner Lawyers, Dr. Gilling.
Tēnā koe, sir. It's Mahoney Horner Lawyers. It's Irish.
Sorry, I should know that. Sorry.
Yeah, Dr. Gilling sends his apologies. He is away at another hui. But may it please the tribunal, counsel's name is Ms. Soriano, and I appear on behalf of Y2916, claimed by Mr. Piripi Gray for the children of Ngāti Toa, Ngāti Raukawa, and Ngāti Kaupata who have been placed in state and or faith-based care. Kia ora, sir.
Thank you. Could I just have your name again, please?
Ms. Soriano, sir.
Soriano. Kia ora. Thank you. Ranfurly Chambers, Mr. Hirschfeld. Woodward Law, Ms. Hall.
Tēnā koe te kai whakawā, te rōpe whakamane i te tiriti o Waitangi. Tēnā koutou I ngā kākareme, tēnā koutou I ngā hoi mahi hoki. Ko Rogers tōku ingoa, nei whai Donna Hall, e tuana mātou I te ingoa te kanuhira Māori o Aotearoa, ko te number Y2957. Ngā mihi o te ata.
Kia ora, Mr. Rogers, Ms. Hall. Ms. Mason.
Tēnā koe, sir, and tēnā koe, tribunal. I'm appearing for a number of district Māori councils led by Mr. Des Ratama, Mr. Manu Pō, Mrs. Titawhai Harawira, Mr. Rihari Dargaville, and Mr. Raymond Hall, and then some other clients, Ruiha Collier from Ngāpoi, David Potter from Ngāti Rangihi, Te Amohia and Albert McQueen from the Waikato, Henare O'Keefe from Hastings, Mrs. Jane Brooker on behalf of Waitaha Grandmothers Council, and Beverly Rewati, and also the mother of the pepe that was uplifted in the Hastings case, and 20 other mothers whose pepe were uplifted by Oranga Tamariki on without notice applications. And Sir, I'd like to say thank you to you for allowing me to appear from abroad by ABL. Thank you.
If
kia
Your
ora.
Honour
Thank you,
pleases,
Ms.
sir,
Mason.
may I just follow Ms Mason? The New Zealand Māori Council, to complete our introduction, comprises 16 district Māori councils. And you have heard Ms Mason name 5 that are splintered, but they do not represent in any way the position of the New Zealand Māori Council. And if that can be recorded, we didn't go into that detail, we didn't expect to have to. Thank you.
All right, Ms. Hall. The Tribunal is aware of those ongoing issues, but I don't think they need detain us for today's purposes. Thank you. Thank you, Ms. Mason. Crown Council, and sorry, before Ms. Hardy, I was remiss in my mihi in not acknowledging Ta John Clark, who is with you. Tēnā koe, John. Welcome back to the place of your former mahi. Thank you. Sorry, Ms. Hardy.
E te kaiwhakawā, tēnā koe, e ngā mema, tēnā koutou. Appearing with me, Sir, is Mr. Tyson and Ms. Tukapua, and we acknowledge to Ta John Clark.
Kia ora.
Ka ti au e te waka nei, kei tako rangatira, kai whakawā te hono re koe tēnā, ai atu ki ngā mana tike. Koutou e whakahaere nei i tēnei kau take nui, take hohonu, take taumaha, kei moi a tātou. Engari me hoki ngā mihi ki tō tātou kai karakia, nāna i whakatūwhera o tātou hui, no reira kei te rangatira. Tēnā koe. Tika noat, me tuku atu e karakia ki te wāhi ngaro, koe e hoki te tīmatanga me te tūtakitanga o ngā mea katoa, koe e he ara taki a tātou, i roto i ngā putaku ke tanga, i ngā tini pāheketanga o tēnei ao mate mate, kei te mihi ati ki a koe. Mihi ati ki a tātou tini mate, rātou ko huri tuara nei, ki o rātou maunga, ki o rātou awa. Ko tātou e nei, ngā waihotanga o rātou, hei kawe ngā kawenga i mahue mai rātou. No reira ngā mate, haere mai rā koutou, haere hot, hotu ki te mātu tarutanga o te tangata. Mā muri nei koutou e kōrero, mā muri nei koutou e whakaaro. Ka te hoki mai ki te kaupapa e te rangatira. Koutou e nā e whai ake nei ngā tapu ai, ki te atu i ngā kanohi, a ko te wharihui a tērā, a ko manuhui a pēneti, a ko te ahi kā, kai ata, ko hone tūrei tērā, me te nui no atu a rātou. Tai atu i kawa tātou whaia, kia Elena Manuel, kia Kate Walker mā koina katoa atu. Ko rātou i paratuhua rahi, a ko koutou e nei, e kawe nei, te kaupapa i tīmata mai roto i ngā tau ko mahu ake nei. E tika nā tō kōrero e te kai whakawā. E take tino taumaha tēnei, tino taumaha rawāt. E nui tonu ngā take haere mai i mua te aroro te tribunal. A haunga ngā take pāna ki ngā muru raupatu. O tēnā iwi, o tēnā iwi, ngā mahi mo, ngā take o te kai, o te takutai moana, ngā take o te reo. Engari, ko tēnei te take tino aroha rawāt. Ko tēnei take e pāna ki te kaponga me te wehenga o a tātou tamariki mokopuna. Mai i o rātou whānau, i o rātou iwi. Nō reira, ko te hehia, ka kitea, he oranga, he kaupapa, hei whakatika i tēnei mahi. E whakararu nei i te iwi Māori. Nō reira, kei te mihi ati ki a koutou. Mihi ati ki a koutou i haere mai nei i te nuku te whenua, ki te kōrero, ki te moananga i tēnei take nui. Tēnā koutou, tēnā tātou, e tau ana.
Tēnā koe tā John. Mō tō mihi. just on behalf of the tribunal, acknowledge the mahi of all of those who have gone before us, and we hope that their legacy can help us with this most important taki. So before we begin, and just largely for the benefit of those who may be watching and who may not have been following as keenly as the lawyers all of our procedural stuff, I'm just going to very briefly summarize why we're here, because there are some unusual aspects to the way we've convened. And I just want everybody to be aware of why we've called these hearings, what we're calling context hearings, and what we hope to achieve. So we were given, as an urgency, a very specific issue, and that was having regard to the rising and disproportionately high number of Tamariki Māori being taken into state care under the auspices of Oranga Tamariki, is Crown legislation, policy and practice inconsistent with the principles of the treaty and the Crown's treaty duties to Māori? If so, what changes to Crown legislation, policy and practice are required to ensure treaty compliance? Through a process of conferences with all the parties and Crown Council, and after considering a range of evidence filed with us, for which we are very grateful, we have called these hearings and set 3 questions. And those questions are as follows. First, why has there been such a significant and consistent disparity between the number of Tamariki Māori and non-Māori children being taken into state care under the auspices of Oranga Tamariki and its predecessors? Our particular focus is on the period from 2015 to the present, but that is the first question. The second question is, to what extent will the legislative, policy and practice changes introduced since 2017 and currently being implemented change this disparity for the better? And the third and final question is, what, if any, additional changes to Crown legislation, policy and practice might be required in order to secure outcomes consistent with Te Tiriti, the treaty and its principles? They are, while they read at one level as reasonably straightforward questions, they give rise to a very complex set of issues. We are indebted to the parties and their counsel for preparing a comprehensive chronology from 1983 to the present. And we have called these hearings largely for the purpose of hearing from a range of witnesses who have expertise, experience, insights to offer, and including agencies who have recently carried out and completed significant mahi and research on some of these very issues. So we're privileged to be able to hear from the range of witnesses we're going to hear from today and tomorrow. And also next week, on Friday, we will hear from a range of experts from the Crown. So the process we're going to follow is that we will hear from the witnesses, and we as a tribunal will ask questions. Time permitting, we will also offer an opportunity for Crown Counsel and for Mr. Benyon on behalf of Claimant Counsel to ask any questions that might also arise. But the primary purpose of these hearings is for us as a tribunal to try and gain a a high-level understanding of some of the very, if I can put it simply, the big picture issues before we move on to more detailed hearings in October, where we will consider a range of evidence the parties wish to bring before us. All right. So we have a big day. I'm relying on staff to keep me on time, so unless there are any matters, we'll start. And Ms. Smale, I'll hand over to you. Thank you.
I call Lady Tudati Moxon to the stand. Lady Tudati, if you could please present the summary of your evidence and then answer questions as the tribunal has indicated. Tēnā koe.
Tēnā koe.
Tēnā koutou katoa i ngā rangatira o te rōpū whakamana i te tiriti o Waitangi. Ka nui te mihi ki te krauna, ki ngā roia, ki ngā kai kremi, ngā whānau katoa i raro i te maru o tēnei tikanga, tēnei kaupapa i tēnei wā. Ko Tūreiti Moxon tōku ingoa no Ngāti Pāhauera, Ngāti Kahununu me Kaitahu Ahau. Ko au te tiamana o te National Urban Māori Authority me te tumuaki o te hauora o te kōhau. Nō reira, tēnā koutou katoa. I'm here today with the executive members of the National Urban Māori Authority, which are named in our claim, and the Whānau Ora Commissioning Agency, Oranga Tamariki panel or members of, who I'd like to introduce to the tribunal. We have Maria Mino Kapakingi, Chair of Te Kōhau Health, Kirikiriro Hamilton. Bill Kaua, Chair of Te Rōpū Āwhina no Porirua. Rangi McLean, former Chair of the Manukau Urban Māori Authority, Tamaki Makaurau, Auckland. Bernie O'Donnell, current Chair of the Manukau Urban Māori Authority. And Ray Hall, current Chair of the Manukau Urban Māori Authority. Raymond Hall, Chair of Waipareira, Henderson in West Auckland. You will be hearing from Dame Iritana Tawhiwhirangi a bit later tomorrow. Mere Pekaro Kawa Tate, our Chair for the Whānau Ora Commissioning Agency, is due to arrive at some point today, and she is also a member of the panel, and we have here Dame Tariana Turia, who is also a member of the Whānau Ora Oranga Tamariki panel. The tribunal will hear a lot of evidence in this inquiry about inequitable, discriminatory and punitive approach of Oranga Tamariki to the removal of Tamariki Māori. It is our view that Oranga Tamariki is broken and is beyond repair. It has had a devastating impact on our people, and it undermines the very core foundations of Māori society, which is whānau, hapu, and iwi. The harm and irreversible damage that it has done to so many tamariki mokopuna and whānau over generations is akin to the stolen generations of our Aboriginal cousins in Australia. Removing tamariki from the breasts of their mothers is not only inhumane. Oranga Tamariki is doing to Māori what the Tohunga Suppression Act and the Native Schools Act have done, which is to exert the dominance of Pākehā culture and language in Aotearoa, New Zealand, in order to colonise and assimilate Māori. Māori have the capacity and capability to do better than Oranga Tamariki, based on a Māori worldview. In this view, whakapapa provides us with our identity and gives us a place to stand. It connects us with our tipuna, whānau, hapu, iwi, whenua, maunga, awa, marae. It is the core of mātauranga Māori. A by Māori, for Māori, with Māori solutions are the key to changing the intergenerational trauma experienced by too many of our people. What we are looking for e ngā rangatira is the realisation and implementation of Māori mana motuhake and tino rangatiratanga as a true partner to the Crown, as originally intended by Te Tiriti o Waitangi. It is not what we currently have, which is a master-servant relationship or a contract. What we want is for iwi and Māori to look after ourselves in our own way, based on our own tikanga practices. The Oranga Tamariki approach is to reprimand parents, focus on wrongdoing, and then remove tamariki from the care of their parents. Not just once, but every other baby born to that mother. For example, Oranga Tamariki often removes Māori babies if their mother doesn't have permanent housing because of poverty. Oranga Tamariki then gives the baby to foster parents and gives them extra allowances for clothing, education, and entertainment that the mother or grandparents can't get. A by Māori, for Māori, with Māori approach would support the mother to find housing. We would spend our energy on keeping the whānau together instead of punishing them for being poor. A mother with a drug addiction would most likely have their baby removed. A by Māori, for Māori, with Māori approach would focus on her rehabilitation and healing. We would work with her to place her baby somewhere safe with whānau while she healed. The focus would be on empowering her to be a good parent and supporting her to look after herself so she can in turn look after her own baby. A by Māori, for Māori, with Māori approach would work to support the whānau, to empower and support Māori parents to be the best parents they can be, so they can look after their own children. In a by Māori, for Māori, with Māori approach, where tamariki may need to be removed for their own safety, this would be on a provisional basis only, to enable holistic and intensive work to be done to strengthen the parents so they can reconnect with their tamariki in the future, rather than punishing her by removing her tamariki. We ask the tribunal not to accept the Oranga Tamariki way of seeing tamariki as isolated beings. Their whakapapa connects them to whānau, hapu and iwi. The other day, a 15-year-old found her way to a home of a colleague from Te Koho Health. She was sitting on the doorstep, wet from the rain, in pyjamas and a bathrobe. She had escaped a party where a fistfight had broken out. She lived with a family who were not connected to her by whakapapa. Although they treated her well, she never felt as though she belonged. She was taken into Oranga Tamariki care with 3 other siblings, but she never knew where they were placed, and all she wanted was to be with her own whānau. A whānau order navigator engaged the assistance of the nannies, who spoke to the whānau, and they in turn discovered her whānau were living in Taupo, where she has now been reunited after 1 year. A by Māori, for Māori approach returned her to the place with her own whānau. So, a by Māori, for Māori, with Māori approach would not have allowed her to be displaced like this. The tribunal's recommendation in terms of the Māori Health Authority in the Y2575 Hauora claim is concrete recognition of Māori capability and capacity to care for our own people. It recognises our mana motuhake and Te Treaty principles the tribunal described as the guarantee of tino rangatiratanga, partnership, active protection, equity and options. We want the tribunal to know that the solutions already exist. The urban Māori authorities are an example of Māori capacity and capability. Māori midwives and nurses have made sure this inquiry happened. The whānau order commissioning agencies have a proven track record as a funder and enabler of iwi and Māori services and Māori service providers and communities throughout Aotearoa. The Hauora report recognised Māori GP clinics as the benchmark for all GP clinics. There are many examples, and I'm sure you're going to hear many of those today, showing that we can do better than the Crown. Currently, the Crown does not recognise a treaty partnership as intended by Te Treaty o Waitangi, and nor does it recognise mana motuhake or even understand it in our view. The relationship Māori have with the Crown is one of subservience, whereby the Crown dictates the terms and we must comply or otherwise be barred from participation. In the Hauora report, the Tribunal acknowledged our call for self-determination through a standalone Māori Health Authority, and we are advocating the same from this Tribunal in relation to a fully funded, standalone, independent Māori Tamariki Mokopuna Authority that is legislatively protected. We therefore ask the Tribunal to be courageous and brave, to bring about the changes we are asking for. Kei a tātou anō te aratika. The answers lie within us. Nō reira, tēnā koutou, tēnā koutou, tēnā tātou katoa.
Tēnā koe, Lady Moxon. First, just wish to acknowledge you and those from the Whānau Ora Commissioning Agency who are here today, and also want to acknowledge on behalf of the Tribunal the debt we owe to the work of the Commissioning Agency in the report released late last year, I think it was. We have found that of immense assistance, and we of course will have a number of questions arising from that. And I'm just going to, I blocked my bag and I just need to try and open it, so please forgive me if it looks a bit rude, but my materials are in there, and I'm going to hand over to my colleague, Professor Lawinia Higgins, to start the questioning. Thank you.
Great boy. Tēnā koe, o tira tēnā koe te katoa. Lady Moxon, so forgive me if I sound a little bit ignorant, but I'd like us to have a conversation about your evidence, just to understand it a little bit better. In your brief of evidence, you talk about the discrepancies in funding between whānau and foster families. Is there a funding framework that is used to measure the level of funding given to whānau or to foster families?
Well, 9 times out of 10, a lot of our whānau are on the benefit. So whether it's a solo mother's benefit or whatnot, they're on benefits. And as we know, the benefit does not stretch enough to really cover the costs, the basic costs of whānau living costs. So rents, power, and they're expected to look after their children on that piddly little bit of money that they call a benefit. And so and that's been one of the biggest issues that a lot of our families have faced, our whānau face, is that when their children go with somebody else in a foster home or with foster people who are going to look after them before they decide what they're going to do with them, they are given a lot more benefits. They're given a lot more support financially, because at the end of the day, lots of our families have no kai. And we already know that a lot of those agencies that provide food and provide kai are overwhelmed. And so the truth of the matter is our people are suffering greatly because of it.
And so there's no official document that has a funding framework for whānau to be able to apply to that, in the same way that foster families clearly must be applying?
Well, not in the same way, not for free. A lot, if they do apply to WINS or work and income, sometimes they have to repay. So it's a loan in many cases, and a lot of those who are on benefits have actually got loans, and from here to kingdom come. So they're in a lot of debt.
I just want to just unpack a little bit of the intergenerational trauma and that disconnection from whānau, clearly over subsequent generations. In your role, particularly in the urban authority, and whether you're offered support to be able to provide whānau with connecting disconnected whānau members in any way.
I think Whānau Ora Commissioning Agency has been instrumental in actually supporting Māori communities and Māori providers in particular, including our Numa providers, in supporting whānau in need through financial support as well. But there is no, unless you have a contract with, say, Oranga Tamariki, or you have a contract with MSD, there is no other funding regime, if you like. So a lot of the Whānau Ora agencies or providers are actually supporting in every single way, because it's a wraparound service, and that actually helps them, each of their whānau, to support each other better. So with the urban Māori authorities, everyone is different. Some are providing food. So they've got kai parcels and everything, and people go there. So everyone has different strengths and different focus.
Kia ora. If I can draw your attention to paragraph 32, where you talk about section 7AA and the practical commitments and that, and more notably under the three duties of the Chief Executive Officer, is there any formal relationship or strategic partnership, I suppose, under those duties with Whānau Ora or the National Urban Māori Authority?
I understand that there is one with Whānau Ora at this moment in time. We don't really understand and know what that actually means for the moment. But you've got to remember, these are strategic partnerships. They're still a master-servant relationship. These are still a contract. They're not at all what it should be. It doesn't mention in there, for example, mana motuhake, rangatiratanga, or Māori looking after their own. It doesn't have any of that kind of thing, and it's actually left up to the interpretation of the people who are interpreting it and putting it out there to the cosmos. Anyway, so my thing is that unless Māori are in charge, unless Māori are driving it, and unless Māori are in the driver's seat, it's always going to be left up to interpretation for the majority population to tell us what it means.
Tēnā koe, Lady Moxon.
Kia ora.
Tēnā koe, Lady Moxon. You've talked to us quite a bit about what you would like to see happen. I'm just wondering, in the various roles that you hold, have you seen examples of good practice like you're describing?
Well, I think that there's lots and lots of examples, particularly in the whānau ora realm. I'm very, very much an advocate of whānau ora because it's the first time in the history of this country, in any kind of contracting, if you like, where we can actually meet the needs of our communities, and where we've been resourced enough to be able to support them in the way they need to be supported. So yes, I've seen that happen time and time again.
And what about in your professional capacity? Have you seen good practice occurring in Oranga Tamariki in terms of removal of children and care and protection processes?
Well, to be honest, no, I haven't. But I'm not saying there aren't some good news stories. But the issue that we have with if you have seen the report that was put out by the Oranga, the Whānau Ora Commissioning Agency, and apparently, it was some news to me, but apparently it's the first time that they actually heard the voices of whānau, and because it's a very powerful expression of their pain and their trauma and their struggles. So they are saying these things, and Oranga Tamariki are well, there hasn't been a lot of success, and they have failed, many different reviews. I think there's been 14 reviews, and they've failed them all. So, I mean, how much more failure do we have to accept to say, oh, it's okay now? But it's not okay, and it can't be okay, and we mustn't allow it to continue. Kia ora.
Kia ora. I have been able to break into my bag, so I've got my papers. So one of the things that has struck us when we have been reading a number of the background papers and reports is just how long-standing these issues are, they go back before the 1980s, but the Puau Te Atatu report, just how much of that remains strikingly relevant and pertinent. So I just want to start from there. One of the issues that report highlighted, or among the many insights it offers, was the need to build capacity in Māori communities who had been damaged by the very long history and effects of colonisation, but to build that capacity so that the level or the need for the kind of coercive state intervention, could be done away with. And it appears that in the late 80s, early 90s, there was some progress made before the statistics started to return to the current dire trend. So my first question really relates to this question of capacity, and you said that there are many examples of that capacity all in play, and we're well aware of the mahi that the Waipareira Trust has done over many, many years. So how and in what kind of time frame, in your view, could that kind of capacity be established or supported throughout all rohi? Because it seems that at the moment it's uneven. Would that be fair?
Yes, it would be fair. But like any good idea. It starts from the beginning, and we have to build. And in some places, we will have to put more resources and more focus than in other areas.
Right.
But I think that we have enough capacity to get the ball rolling. And they will, each iwi, of course, will need to be a part of that. And but I think, Judge, I think the issue for us is the Crown willing to share the resources? Is the Crown willing to give over power to Māori? Is the Crown willing to stand by its decision in being a true partner to our iwi? Are they? Because that's where it starts. And the other issue that I have around that is around different governments that come and go, because every government has a different idea of how fabulous they are, and then they implement a whole lot of things that are often, in terms of the report that you said in Poata too, they implement a whole lot of things that are negative, that actually drive us into the ground. And that's been true since Mairanō, since the beginning of time. So we can never ever be complacent about the place of Māori in this country, but constantly we're thrown around like a political football.
Right. So in terms of securing, if I can put it this way, a more stable platform for resourcing, because that's a critical issue, if we're, for capacity to be built and sustained. You're pointing to the whānau ora model as the best that has been developed yet? Is that what you're...
Well, it's the only Māori commissioning agency there is.
Yeah.
We don't have any other ones. We'd like more, but we haven't quite got to that point yet. But certainly it's a good example. Look, we've got iwi who have capacity. They've had many of them have settled and whatnot. So there's lots of grunt, if you like, in Te Ao Māori to make this happen.
All right. And just looking at the Whānau Ora Commissioning Agency report at page 75, which is towards the summarising, it just says the overall conclusion from this inquiry is that the state care of Tamariki and Pepe Māori, and in particular the uplift practices used by the state, are never appropriate for the long-term well-being of Māori. What is needed from Oranga, Tamariki or any other state agency to ensure the well-being of young Māori is the reallocation of resources to be available for high-quality whānau-centred kaupapa Māori services in every rohe of Aotearoa. So, just to be clear, from your understanding, because I know there are other witnesses who will speak on behalf of the agency, what's being sought or recommended by the agency is a fairly fundamental paradigm shift from the assumption that has been in legislation and policy for a very long time, that it is in fact the state's right to intervene in that way in a whānau. The clear conclusion as I read it from the agency is, well, actually that assumption is fundamentally wrong, needs to be reset, and the state needs to reallocate resources to enable Māori to claim back essentially the inalienable right to care for their own.
Absolutely.
All right.
And I absolutely agree with that. And you know, I don't understand really how a Crown can think of themselves as a better parent than the parents themselves. And I don't see how the Crown can take the position, which it always has done, that they know better. They know better what's good for us as Māori. But Māori are ready. We've been ready for a long time, and we are ready to to take back our tamariki, and they need to give them back with the full resources and empowerment that it takes for us to do this mahi for ourselves.
Kia ora, thank you.
Kia ora.
Crown Counsel, I understand that from a memoranda recently filed, you may not seek to question witnesses during these 2 days, but reserve the need if the need arises. Is that correct?
That's right, Your Honour, in relation to Lady Moxon's evidence, and I acknowledge your evidence, thank you. The only point that I wanted to make was to elaborate on paragraph 35 of Lady Moxon's evidence, which is a reference to material in the health kaupapa inquiry, and just to draw the tribunal's attention to the fact that the heads of agreement, which is about a process there, was filed by the Crown in that proceeding. I could give you, Your Honour, the document number if that is helpful.
So that's on the record of that inquiry?
That's correct, and
Right.
it would be possible for us to file it just as a matter of elaborating Lady Moxon's evidence
That would
in
be
this
helpful.
inquiry.
Although I think it would be more straightforward probably for staff to retrieve it off our record and
Okay. The document number is 3.2.209A.
A. Thank you.
But your general point, Judge, is that the Crown is treating this day and tomorrow as a contextual inquiry for the tribunal to explore the evidence with the witnesses, and unless there's something particularly material that's new, the Crown is content not to question over those days.
All right, thank you, Ms Hardy, for that indication, and I'll simply leave it with you to indicate as and when the urge to question might arise.
Thank you, Judge.
I'm not encouraging it, I'm just saying. Thank you.
Thank you.
Mr Bennion, did you have any questions?
Just, sir, 3 quick matters arising. Lady Moxon, thank you for your evidence and for your work in this area. Extraordinary work. Just to clarify, the comment you made in the presentation about uplifts occurring in situations where mothers might not be able to afford housing, that is what you're saying, that can be a central factor in uplift?
It can.
Is an inability to pay their rent? Okay.
Or they don't have a place to stay, for whatever reason that might be.
All right. That seems slightly outrageous, but we'll explore that with others, I think, in terms of information. But thank you for that. On the question of the nannies that you talked about and finding out what local links are, is there any requirement for essentially a sort of a whakapapa report, or let's say a nanny's report that Oranga Tamariki has to produce or think about before it makes the uplift?
Actually, I'm not 100% sure about that. I know that happens in corrections, but I can't say whether it's asked for. But we have never been asked to provide one.
All right. And just lastly, a number of other witnesses have brought this up, and I thought I'd raise it quickly with you. Your experience of COVID-19, when the state had to shut down pretty quickly and needed to get resources to whānau, what was your experience there? Other witnesses have talked about a change in demeanour from the state and a more free-flowing situation. Do you have any experience with that?
Absolutely, and that's exactly what happened to us. Money just came, from all areas, from Ministry of Health and everything. Usually it takes us forever to get anything through, and here we had it. And not only that, decisions were made just like that, and we can we can do that. The Crown can do that, and that's what that raised with us. But certainly, I can tell you, it was a far more free-flowing operation than we ever experience in normal times.
And do you think the Crown in that situation was actually relying on the networks that you have to make the country safe?
Absolutely. And do you know, in the Waikato alone, we put out 45,000 hygiene boxes to whānau all over the Waikato, Maniapoto, Raukawa and Hauraki regions. It was just phenomenal. And it was a really good example, thank you for bringing it up, a good example of how Māori can mobilise and look after our own. And that was the same with kai boxes, that was and parcels. The only slow thing was the PPE gear. You know, and that was slow. That was very slow coming out. But the rest, we were out there amongst our people, working with our people through the whole thing.
And just lastly then, do you regard the current situation with Uplift as something of an emergency?
Absolutely. And it's great that we're having this urgent hearing now. It cannot carry on. The voices of our people are saying it cannot carry on. They have been so hurt by it, and not only are they hurt by it, many of them never recover from it. And you know, we seem to think that they should just carry on like normal, but that's not what they want. That's not what we want, and it's time for change.
Thank you, Lady Mox.
Kia ora.
Thank you, Mr. Binion. Lady Mox and I omitted in my order of asking council questions to check with our council assisting, Ms. Orfa Cassidy. So I'm just going to quickly refer to her now.
Tēnā koe te mārei kura. Ngā mihi nui kia koe mō tau mahi rangatira. Kua mahi tia e koe ngā tau kua pahure ake nei. Nā reira, nōku me ki te whiwhi te honore ki te whakarongo ki au kōrero i tēnei ata. I raro i te maru o tēnei o te rōpu whakamana i te tiriti o Waitangi. Lady Mox, and I had two points that I just wanted to ask you about that you've already been brought up from the questions from the panel. And the first one goes to power. And really, when we're talking about power and power sharing, it's about resourcing, particularly for our people. So we know that there are some iwi already that have settled. They've settled with the Crown. And so for them, they have the infrastructure and resourcing to be able to assist our people, but more importantly, our tamariki. But then we have those iwi that aren't in that position. So I'm interested to hear from you in terms of that resourcing, say, for those iwi, where do you think that funding, should the funding come from as a means of treaty settlements, or should it be coming directly from another source, i.e. the Crown?
Well, the billions and billions of dollars that the Crown gives to itself, it should come from there. The amount of money that's been going to Oranga Tamariki should come from there. We got 50% of our, more than 50, half of those babies that are in care, more than half of them are ours. So we should get 50% of whatever's going on there. But that's the thing, is because we're, 10%, like Te Ohu Kaimona, I'll just throw that in the middle. But anyway, we only get 10% of the pūtea. So there is a disparity beyond all disparities here when it comes to sharing, power sharing and resource sharing.
Kia ora. I just want to refer you to paragraph 15 of your brief, but just while you're turning to there, I think one of the fundamental issues that we really need to consider when we talk about our tamariki being removed from whānau, hapu and iwi is that disconnect.
Yes.
And we know how important whakapapa, whanaungatanga, and our connection is back to our homeland, back to our tūranga waiwai. I think Professor Rawini Higgins put a question to you around in terms of the urban authority. Do you, because disconnection, that's really at the heart of this issue, and a lot of our children and people find themselves in this position. Is the urban authority, your organisation, are there any strategies that you currently know of that are in place in terms of reconnecting, for example, our tamariki that have been disconnected back to their whānau, hapu and iwi?
Absolutely, there are, and they all have really good examples of that. And one of the biggest issues that a lot of our whānau have is that they are disconnected from culture. They are disconnected from where they belong. But there are so many more positive things happening now where they are trying to find where they belong, who they belong to, and a lot of the Māori, the Whānau Order Commissioning Agency collectives are doing exactly that, and so is Numa. And as you heard earlier, these are big organisations and they've been around for a long time. And that certainly has been very much a part of everything that we do in terms of Māori embracing ourselves and believing in ourselves.
And I suppose it makes me think about matua whāngai back in the day when we had them throughout the motu. You know, and that was part of their mahi really was being within the whānau hapu and iwi and having that connection. Do you have any remarks to make about that?
Yes, it was, what we need is more of that. And I think we need more of that everywhere. And the issue that we have is that the government giveth and then the government taketh away. And we have this constantly. That's why it's so important for Māori to stand on our own, where we're making our own decisions in our own way, within our own mana motuhake. Because if we keep doing things the way that they are now, we will never be able to realise and resolve the kinds of issues that are plaguing our people right now.
Just one final question. When you say they take it, they give it, and then they take it. Were you? I assume you would have been working in your mahi around the time of matua whāngai.
I was around matua whāngai, but and I know of their work. Yes.
So when it was disestablished, were you aware of like any rationale behind the reasoning why, other than they taketh?
They taketh. No, I don't know all the ins and outs of it, but what I do know is that all the best ideas we've ever had don't last long. And when we are successful, our success doesn't last long because resources are taken from us. You know, in the health arena, it's a constant movement all the time because things are changing all the time. And that's the same as every other government department. Someone gets a bright idea and then we're all going that way. Someone else gets another bright idea, we're all going that way. So in order to survive in this, in any realm, when you're dealing with government, you actually have to diversify and try and be bigger than what you, otherwise you just get swallowed up, it's a fact.
A tēnā koe. E te mārei kura, I have no further questions, sir.
Kia ora.
Thank you, Ms. Cassidy. Thank you again, Lady Moxon. Thank you very much for your evidence.
Kia ora.
Kia ora.
Kia ora.
I'll now just pass the rākau to our counsel assisting to lead the next witness. Kia ora, Ms Cassidy.
Te mea tuatahi ki te tukumihi ki a koe te kaiwhakawā. Korua ko ngā māreikura e noho ana me ki runga i te taumata. A koutou ko te rōpū whakamana i te tiriti o Waitangi. Ka rere taku mihi ki a koe e rangi nau anō i whakatuwheratia i tō tātou nei rā. I runga i te rangi Māori, te aroha, nā reira he mihi anō tēnei ki a koe. E tika ana ka mihi atu ki ngā māreikura, ngā kahurangi. Koutou ngā rangatira e noho i raro i te tuanui o tēnei whare. Nō mātou te whiwhi, nō mātou te honore kua tai mai koutou ki te tautoko i tēnei kaupapa. Me ki ngā tūkinotanga kua pā ki runga i o tātou tamariki mokopuna. Nā reira e tika ana me mihi atu ki a koutou. Tēnā koutou e aku rangatira. A huri no ki a tātou i roto i tēnei whare rangatira i tēnei wā me ki aku hoa hoki e noho ana, tautoko ana i tēnei kaupapa. Nā reira, ka karanga atu au ki te kai kōrero tuarua mo te rānei. I call Tanya Williams-Blythe to the stand.
Kia ora.
Tēnā koutou katoa, tēnā koutou, tēnā koutou. Tēnā koutou i te tribunera, tēnā koutou i ngā roia, tēnā koutou hoki ki te whānau, e mātakitaki mai ana pea. Tēnā koutou katoa. Tēnei a Ngāti Pūkenga e mihi atu ki a koutou i raro i te kaupapa o te rānei, te kaupapa whakahirihira, te kaupapa o a tātou whānau, a tātou tamariki hoki. Tēnā koutou katoa. Morena.
Kia ora.
Tēnā koe, Ms Blythe. Could you state your full name for the record, please?
My name is Tanya Williams-Blythe.
And you have provided and filed with the tribunal a brief dated the 20th of July of this year, is that correct?
Yes, it is.
And you have a copy of that brief in front of you, Ms Blythe?
I do.
And can you confirm that the information or the evidence contained in that brief is true and correct to the best of your knowledge?
Yes, it is.
And just before I get you to talk to some of the main points in your brief, can I just get you to confirm for everybody in the room that may not have had the ability to read it, exactly what experience and the roles that you've had that bring you to this inquiry?
I've been a family lawyer for the last 20 or so years. I've, probably more relevant to today, I'm a director of Te Kōpū Education and Research Limited. As a family lawyer, I act for children and vulnerable adults predominantly now. I've also appeared as counsel before the Waitangi Tribunal, Youth Court and the District Court. I was a District Inspector for Mental Health for 9 years. That ended in 2017. I now sit on the Parole Board as a panel convener and member and have been since 2014. But the biggest mahi I do is the mahi in the community, in the education and research. Family law appears to be just a minute part of my day job now.
Can I just confirm, though, that in terms of your role as a family court lawyer, you are appointed as lawyer for children in the family court, is that correct?
Yes, it is. And
particularly children that may have been uplifted by way of a order in favour of Oranga Tamariki?
Yes.
Ms Blythe, I want to turn you now to your brief, and perhaps if I can get you to turn just to, well, perhaps I'll get you to make some introductory remarks, because in the start of your brief you talk about that revolutionary and transformative document that we know as Puao Te Atatu, that was released in 1988 and was spearheaded by the late Sir John Rangiho. So do you want to make some opening remarks about that report?
Okay. Firstly, the opening comments I would like to make, apart from Puao Tatatu, is our whānau are awesome. Our communities are awesome. They just need a bit of help. So that's the starting point for us. And the other bit in terms of our mahi is, it's the law that was used to take away the land. It's the law that's being used to take away our tamariki. We need to understand, and our whānau need to understand, and I don't mean to minimise in any way the rules of the game. They need to understand the laws that are being imposed on them in order that they can work through and get better outcomes. So my focus has been, and the focus of Te Koremako has been about the law, because it is the law that allows the removal of our children.
And just in reference to further to that, to provide some context around, once again, that report, are there any comments you'd like to make about that? Because perhaps I'd refer you to paragraph 21 of your brief.
Sadly, and I've heard Your Honour say this, Puao Te Atatu is as relevant today as it was back in 1988. The statement that says at the heart of the issue is a profound misunderstanding or ignorance of the place of the child in Māori society and its relationship with whānau, hapu and iwi structures is as alive today. That misunderstanding or ignorance is as alive today as it was back then. And that is probably in terms of the court and Oranga Tamariki, possibly until recently, that is alive and well.
And Ms Blythe, I know that you've prepared a PowerPoint, because we're now going to turn to the Act itself, the Oranga Tamariki Act 1989.
Yeah.
Is that correct?
Yes, it is. There is a... But have I got a... read anything? No?
Yes. So perhaps if I just, can we just?
I'm a wee bit fussy. That's not quite how it's done. So we've been presenting around the country, so just needed to change it. Can I have a thingy?
Maybe just.
Okay, I'm just gonna explain it. And whānau, sorry, I move my hands a lot because it's quite difficult to explain something. So firstly, it's important to understand, and I think it's important for the tribunal to understand how difficult the legislation is for our whānau to come up against. And so on 1 July, new legislative provisions for subsequent children and special guardianship came into force. Can I? Nope. Okay. No. Okay. So that's not going to work. So new legislation came into force. They were designed at a time to... they were designed at a time where it looked like we were following the UK. The idea that you have special guardianship provisions, that you have 26 weeks from go to woe, and by the end of that time in the UK, they were looking at adoption. So for New Zealand, I suspect that if we tried to do that here in New Zealand, in terms of promoting adoption as an option, it would not have gone anywhere. So we then got the subsequent children legislation and the special guardianship. Subsequent children is about early removal. It's about getting in early and removing the child, which I suspect and was always going to lead to what we have now, which is the early removal of Māori babies. Special guardianship is designed to provide legal authority to the permanent caregivers, so that it's very similar to adoption. It's legal authority very similar to adoption. Not quite the same, but very similar. In terms of the process, that's fine. That's all good. Aroha mai whānau. I'm not really apologising to lawyers, because... So, what the subsequent children legislation introduced was this two-step process to remove babies. But the problem is, so the two steps are, the first step is when you go to an FGC for the first child, and they ask you if the child is in need of care and protection, if you agree about your first child, you are actually agreeing about, and you meet the criteria, you are talking about all of your children. So if Mr. Stone and I have a child, and the whānau are talking about our child, we're not talking about just that one, we're talking about every child we are going to have. And whānau don't understand that, nor is it explained to our whānau when they go to the FGC. And that is huge. So, one, if the whānau agree that the child is in need of care and protection, or a care and protection order is made, you've ticked off step one. And that happens a lot. That happens a lot because, yes, whānau, the child needs protecting, don't they? The child needs a safe place, don't they? And that's what happens. So that's ticked off really easily. The fact that an order is made, custody order, additional guardianship, those are made really relatively regularly in the courts. If you can tick those 3 boxes off on your first child, then you are now in the subsequent children realm. But nobody tells our whānau when they go to the FGC for the first child that they are talking about all of their babies. When the subsequent children legislation came in, a person from Wellington described it to me as the trauma approach, which is what they all talk about, as cut away the disease, that is the whānau, and the child will thrive. When you're talking about early removal, then that is where you are going. So when you get to the next step, so whānau have made the decision on the first baby, they turn up with the second baby and the baby's removed. What happens at the second one, the social worker is supposed to follow a whole lot of things. So the social worker, the whānau have to prove, unlike the first child where Oranga Tamariki have to prove that they can't provide safe care, the whānau now have to prove that they can care for their subsequent children. The problem is that the child will probably be removed at birth, which is what has been happening. I have to say that the legislation is doing what it was designed to do. There's no surprises in the fact that the number of Māori babies being removed. It was designed to provide for early removal. So when the baby is removed, the whānau then have to convince Oranga Tamariki that actually, no, we're all good. That process from the bottom of the step to where Oranga Tamariki is, that could take 6 months. That could take a year, 8 months. It could take a long time. So that process could take a long time where our whānau are trying to say, no, we've done this, but the whānau's with the caregivers. I mean, the baby is with the caregiver. That baby is attaching to the caregiver. So, one, that is the first thing. The baby is usually with non-whānau caregivers. It will take time. There will be delay in working with Oranga Tamariki. Getting an FGC can take 3 to 6 months sometimes. In the meantime, there might be access with the baby, but it will be 1 hour once a week. And you can't build a relationship with your baby in 1 hour once a week. And the other thing is, it's only mum and dad who might be getting the contact or the access, not the whānau. Not nan, not koro, not any of those. The focus will be on mum and dad. And it's that monocultural, profound misunderstanding or ignorance of the place of the child. So there's that. You've also got, by the time you get to Oranga Tamariki and they decide what they're going to do, do I agree with it? Do I accept what the whānau are saying that they've changed, or do I not accept that? They then have to apply to the court and say, I want to apply for a confirmation that the whānau are all good, or actually I'm applying for a care or protection order because they're not all good. The court doesn't have to hear from whānau when that application is made. Whānau have to receive the application, but the court doesn't have to hear from them. So the judge can decide whether to accept or decline that application with no whānau presence or iwi presence in the room, and that is wrong. I mean, apart from all the other hurdles that they're not seeing their baby, that it's taking time, it's wrong. So then if the court decides that they decline, they don't believe the social worker, or they don't accept what the social worker says, then that will follow a pathway of an application for a care or protection order. Then the whānau are served again. That process from the bottom of the steps to the top, you could be looking at 1 to 2 years, and that baby is not coming home. The only thing, by the time you get to the top of the stairs, you are talking about attachment. It isn't so much about what mum and dad have done. Have you done the alcohol and drug court? Have you got your mental health under control? Have you completed the anger management program? Those types of things, which are really important. By the time you get to the top of the steps, the court is looking at attachment. The court will say the well-being and best interests of this child, because they are attached to these people, will mean that the baby doesn't come home. Not only does the baby not come home, but the relationship is whether there's going to be any access is a whole different ballgame. And that's why I say it works hand in hand, or why we say it works hand in hand with special guardianship, is because special guardianship, which came in those 2016 provisions, says that caregivers can get an order, permanent caregivers can get an order for custody, which is the possession of the child, exclusive guardianship rights, and they control access. Very similar to closed adoptions, they'll control access. So exclusive guardianship rights. It may be that the caregiver wants to know about the health of their baby. So they'll say, yep, we can share. We can share the decisions about health, the key ones, if baby needs an operation, because I might actually need to know about, baby's health whakapapa. But things like, where is baby going to live? Where is baby going to go to school? All of those things. And changing baby's name, because perhaps they don't want baby to have a name like Te Whareiro, Weremu. Maybe they don't want baby to have that name. They want baby to have Paul Smith, or, with the rest of the whānau. Special guardianship can give them the right to change that, and there is no challenge. There is no ability for the whānau to challenge that once the court has granted them special guardianship rights. So there are exclusive guardianship rights, and there are shared. The shared ones will, I'd be really surprised if they're not extremely limited. So that will secure the legal authority of the permanent caregivers. And then the access. The access is determined at the time the special guardianship order is made. If that guardianship order is made when baby is 6 months old, then those are the arrangements. If it's 1 hour 4 times a year, or 2 hours 4 times a year, then that is what it is. And there is limited opportunity for whānau to come back. One, it focuses on the existing guardians, and it will always cancel mum. Mum will always be an existing guardian by virtue of birth, giving birth to the baby. So mum's rights are almost, she has the greater struggle because she will be an existing guardian, and the rights of existing guardians will be suspended. Dad may or may not be, depending on whether he's a guardian. But that only focuses, it doesn't focus on the extended whānau. So the extended whānau are nowhere to be seen. And no matter that the legislation in terms of Pu Aotearoa and the impact it had on the legislation, Children, Young Persons and Their Families Act, as I think there's a, Judge Beecroft has said, it's like the courts ignored it. And that continued. And that's that profound misunderstanding or ignorance that keeps coming through loud and clear, both for Oranga Tamariki and the family court. So that creates issues. That relationship with the baby, with our baby and all our tamariki that have been uplifted, that will be gone, because no baby is going to want to come and visit whānau for an hour 4 times a year and they don't know you. And they're going to get really upset. Just at a practical level, it is not going to work. So that secures the permanent caregivers, but it does not secure whānau, hapu, iwi, or the whakapapa and connectedness of that child.
Ms Blythe, just before you move on to the next part that you're going to talk about, I'll just bring you back to the subsequent children and the sections under the Act. Now, that particular legislation, changes to legislation, was brought in June of 2016, is that correct? So it was brought in earlier, because we know that there were changes made in July of 2019, which we will discuss later on. But these two particular sections, subsequent children and special guardianship, actually came in at an earlier time, didn't they? And with there wasn't too much opposition, or there wasn't, not much was said about it. Can you make some comment about that?
It appears that over time, when you, and I sort of mean no disrespect really, but I can't remember what colour the papers were, pink, green.
Green and white, the green and white paper.
So there was the green paper, the white paper, or whatever order they were in, and then there was the EAP. It was on a pathway to remove the strength, the Māori provisions in the legislation. It was on a pathway to move it a different direction. And that was clear in the EAP report. There is a section in the EAP report which sort of says, acknowledges Māori and says, but we've decided to go a different way. And that was sort of the different way, was about removal of the things Māori, the brown content, the Māori content of the Act was to be removed. That was the discussion, and that's what the bill reflected. And we would have all seen that at the time. So all of that was a pathway to do that. There was just a huge hiccup when they tried to, around 2017. From a Crown perspective, there seemed to be a bit of a hiccup for them.
Right, because in your maybe analysis of that those particular sections, subsequent children and special guardianship, were really about disconnecting the child from the whānau hapu iwi. Is that essentially what you're saying?
The provisions were about, and it also shows that, because there were a number of provisions amended in that legislation. So the place of the permanent caregiver was lifted in that legislation. The subsequent children, the special guardianship, and the highlighting of the child as an individual, welfare and best interests of the relevant child. That was lifted, all to run together. And they run together and have achieved what they wanted to achieve, which has basically been the early removal and breaking of connections for whānau.
And then I'll hand it over to you. I'll lead you to now talking about the new changes that came in into force in July of 2019, and any remarks or highlight anything that you want to say about that.
So the bill removed all the brown content. Basically, it removed the priority of placement of Māori children. It strengthened the caregivers. There were a number of things, and the New Zealand community didn't accept it. There were Māori didn't accept it, and there were a number of submissions made on behalf of Māori organisations and whānau, but also mainstream New Zealand made a number of submissions as well. And I don't quite know how the politics works, it's a bit beyond me, but it does seem that then there were a number of conversations about, okay, so where are we going to? And so there were a number of, I'm sure that many were involved in a number of meetings about that. But it resulted in the introduction of mana tamaiti, or mana tamariki, in accordance with tikanga Māori, whakapapa and whanaungatanga. Those provisions came in, the Section 7AA provisions came in, which are good. I'm just hang on. What I'm trying to find. Sorry. What it has created is basically dichotomy, or it's a huge tension now in the Act, because you've got subsequent children's special guardianship, which is about early removal and strengthening or disconnection from whānau, as against mana tamariki, whakapapa and whanaungatanga. If you maintain that the misunderstanding and ignorance of the place of the child in Te Ao Māori, this is a huge problem. This is a huge problem for iwi and for Māori children. If you take the view, it doesn't need to be, but if you take the view that if it is accepted that the best interests of a Māori child will always be, to some extent or other, an attachment to the kin matrix, this is probably not such a huge issue. But we're not there yet. We are nowhere near that. We still have the idea that the child is an individual and an entity on its own, as separate from its whānau hapu and iwi. no matter the rhetoric, no matter the sound bites, when the rubber hits the road, that misunderstanding and ignorance is alive and well.
Ms Blythe, do you want to make any further comment about, in particular, section 7AA?
7AA, and I mean, I was part of, or there were a number of people who were having discussions, I'm sure, all around that time. 7AA was never going to be a cure-all. The changes after Pōtata 2 were brilliant, and they were strong, and they had what we needed. And history shows that while there was a reprieve and a drop in the number of children who were removed around that time and more focus on working with whānau, that did not hold. In fact, very shortly thereafter, it went back up. So we've got the same problem now, because right now, and I have to say, while OT was looking at those things, and yes, and we're going to work with whānau and all of those things, the huge impetus for change has to have been the kahungunu attempt at uplift, because once that went across the media, the drive by Oranga Tamariki to change its practices sped up considerably. So yes, the number of children being removed from whānau now is dropping, but how do we hold that? How do we actually maintain that? Because we'll have that for maybe a year or two, and then the system will do what it's, we all go back to what we know, and the system is likely to do that too. How do we stop that from happening? And I guess in part for me, that has to come from the Independent Children's Monitor. If not iwi Māori ourselves, it has to come from the Independent Children's Monitor. Because if that organisation, and I'm sure, because all government organisations right now have a recognition, or we acknowledge the Te Tiriti o Waitangi, and we have a practical commitment. But if that organisation isn't going to monitor the Chief Executive of Oranga Tamariki upholding her duties, then that monitoring body will be of limited to no use to Māori. And I don't see the point of having a monitoring body if that organisation isn't explicitly looking at the place of Māori children and the 7AA commitments. I have heard for others that don't worry, because we're going to look at it because it's part of the Oranga Tamariki Act. That trust me, I've got you. Trust me, Māori, I've got you, it's all good, has never worked, and we have no basis upon which to trust the Crown to do it. So, we need to get past the trust me plan and actually, have something a bit more solid.
Kia ora. I just, Ms Blythe, if I can just refer you to, towards the end of your brief at paragraph 72, you talk about other unexpected pathways for our whānau hapu iwi to Oranga Tamariki in those paragraphs there. Did you want to make any comment about that or highlight anything for the panel, the tribunal?
Yeah, I would. But before I do that, there are a number of our children, our Tamariki Māori, who are in the care of Dingwall Trust, Open Home Foundation, and Bernardo's. We have no idea, as a community, as Māori, we have no idea how many of our children are in 396 care, because those aren't Māori organisations. 396 care, are they obliged? Who are they accountable to? Who ensures that they respect and honour the child's whakapapa? How do they make these decisions about placement? Do they see themselves bound by the law? What role does the Oranga Tamariki have, the Chief Executive, in overseeing that or holding them to account? There are, I think there's somewhere between 500 and 600 children in care. So it's under the Act, but it's to the left or the right of Oranga Tamariki. So they are not seen. Nobody is overseeing what's happening with those tamariki. And it's really important, because the more we the more Oranga Tamariki delegates its powers, the more our tamariki are going to go into those organisations. And we need, they need to be held to account if that's where our tamariki go. And I haven't seen anything that does that. So in terms of the other pathways, there are some really, some other pathways designed to keep whānau safe, and I get that. But if you're going to the court because you want a protection order, or you want protection and a custody order of your baby, and you turn up and you say to the judge, please give me this, and you've written down things have not been good at home, then you and your partner decide to work things through. What whānau don't understand is that when they go back to court, their babies could end up in care by the end of that time. So you turn up in court and the judge is unhappy about the fact that you've reconciled or anything like that, and a Section 78 order can be made. Our whānau don't know that. Our whānau don't know that when they make these decisions to reconcile and to do, that they need to work and build a plan, a safety plan. They need to do these things because when they go back to court, somebody else is going to make the decision about where their children are. There are huge information sharing provisions now between, Oranga Tamariki has always had a considerable amount of power, but there are now, they've been strengthened, information sharing powers and that, information sharing powers and family violence. Our whānau don't realise that when they come under scrutiny by any of these services, their information, and I know this sounds loose and it's not strictly correct, becomes available to a number of organisations. So the scrutiny on them becomes even more intense, because if I turn up at the anger management program, then basically all of those organisations can access that information. If I turn up in Oranga Tamariki, then the other organisations. So it's basically, I'm describing it as a free-for-all, it's not that loose, but there is the opportunity to share whānau information across the board if you come to the attention of any of these organisations. And our whānau have no idea about that. And I think they should. And I think they should be given the opportunity to plan. And I think, I think they should be far more empowered than they currently are.
A lot of your mahi, as you said before, has been really around the research. I think it's being in that care and protection space and seeing what's happened. So we have on the record of inquiry a paper that you were a co-author in, Care and Protection of Tamariki Māori in the Family Court System. And also, more recently, you've released a report, Te Taniwha I Te Ao Ture a Whānau, Experiences of Care and Protection in the Family Court. Can I hand it over to you now just to make some comments about your research in those papers and findings?
Okay. When I opened, I basically said, it was the law that removed the land from Māori, and it is the law that is removing, was used to remove Tamariki Māori. It is the courts that make the decision about whether orders are made, Section 101 orders or removal of children. To date, the court has not been, the family court has not been part of the solution. In terms of holding Oranga Tamariki to account, if you're the social, if you were the social worker and you're applying to me for orders, and I grant your applications for the last 30 years 95% of the time or 98% of the time, why would you change your practice? If I'm the decision maker and I'm saying you're doing a great job, and you apply, I grant, why would you change what you are doing? And yet I, if I'm the judge, I have the same obligations to strengthen relationships, maintain whakapapa, whānau hapu iwi. I have the same obligations, but I allow you to continually disconnect, allow you to file plans that say nothing. I allow you to get away with poor practice. If I'm not holding you to account as the court, who's going to? Because I'm the one that makes the decision. So I think in terms of the components we need whānau hapu and iwi and the community on board. We need Oranga Tamariki moving in the right direction, but we also need the decision maker, which is the family court. And in large part, that is why we did the report, to ask whānau what their experience of the family court was. And it's extremely, not a surprise, but it's really disappointing. Our whānau are ignored, dismissed. I mean, you know, they're a huge disadvantage going into a courtroom, and the research showed that, you know, they are disrespected, they have no idea what's happening, and there is nowhere for them to get any assistance. So if we're looking for a long-term solution, and I know the tribunal doesn't look at the family court per se, all of the significant players need to be moving in the same direction. The family court needs to decide that it wants to be part of the solution. And that can't be about procedural changes. It can't be about what processes they apply in the back room. It has to be about engaging with whānau. Find out from the whānau what's going to work, and let's move it. And currently we don't have that. So yes, Oranga Tamariki is rightly under a lot of pressure and needs to change what it's doing. But the family court has largely escaped scrutiny, and that needs to stop, because they are the decision maker.
Kia ora. Sorry to interrupt, Ms. Cassidy. Ms. Byth, we might just break now to give everybody a chance to, because we started quite early this morning, so we'll have a 20-minute break now, if you don't mind, and we'll come back at 10 to 11. Kia ora, thank you.
The panel will return.
Kia ora anō koutou. Back over to you, Ms. Cassidy. Thank you.
Kia ora anō, Ms. Williams-Blythe. So I'll just get you, we've actually come to the end of your brief, so really I'm just wanting to ask you if there are any final remarks or comments that you want to make to the panel and the tribunal. Just push the button.
There's a little button just in the...
I guess probably I'd like to say some closing comments regarding Oranga Tamariki and some closing comments regarding the family court. Firstly, 7AA is a platform, but it's only the start. It is designed to provide the opportunity. What we do with that opportunity is I guess what we, in part, what we hear about. That opportunity in terms of Oranga Tamariki, if they do not change their approach in terms of, I mean, they're calling it procurement or contracting, whatever, if they continue to decide the parameters of what the focus needs to be on or the strategy and then go to Māori and say, we'd like to co-design with you, nothing has changed. Using the words co-design means nothing. If someone else has already decided the parameters or the game or the rules and controls the funding and then decides, yes, well, Māori, how are we going to deliver what we've decided needs to be delivered? That is a continuation of the status quo, which is what I believe Lady Moxon was talking about. That needs to be completely rethought. And you cannot keep saying, well, they do, but you cannot keep saying that you are committed to to Te Tiriti o Waitangi or the principles when you continue to maintain your power and your place in the world. That's a huge contradiction. Likewise, the family court can't continue to say we are committed to the principles of the Treaty of Waitangi and then continue to decide that they, or decide what should be done. In terms of a response, and I'm taking this opportunity to say this, is that the responses to the report in terms of the whānau views, and they were really clear, was a number of procedural things that the court is going to do. Reviews being conducted in court, Section 78 is being taken off a platform, Pickwick hearings, which are urgent. Yeah, those are fine, but they're procedural. And if you don't tell a community that you're changing the way you're doing things, they will be of no use whatsoever. So the practical commitment to the Treaty of Waitangi means you engage with the community. You ask them, you talk to them. What can we do better? So this idea that we need to move away from, and it's both Oranga Tamariki and the Crown, that they know what's best, has to stop, because they clearly don't. and it hasn't worked for some time. We appear to have learnt nothing. That's probably where we're at.
Thank you, Ms Williams-Blythe. I'll hand it over to the panel first to see if they have any questions.
Tēnā koe, Ms Williams-Blythe, thank you very much. I'll start some questions on behalf of the panel. First, I'd also like to thank you and your colleagues for Te Kore Mako manual. That has been of considerable assistance to us, as well as the evidence you have now provided. So I just want to acknowledge that. Had only limited time to have a look at the recently published report on the family court, Te Taniwha I Te Ao Ture a Whānau, but we will certainly be considering that in some detail going forward. So thank you. My questions really relate to the second and third of the questions we posed. So are the changes introduced in 2017 likely to reduce the disparity for the better, and if not, or what additional changes might be necessary? And you have touched on a number of suggested points of change, but I just want to again start with the big picture. And at paragraph 48 and following in your brief, you talk about this tension in the law, and you discussed it briefly with Ms Cassidy. And you talked about that fundamental misconception or profound misunderstanding of the place of the child in Māori society. So right back from Puaoteata to today. And at paragraph 49, there's an extract from your whanaunga, Justice Williams, and he's pointing to the individual child versus the whānau being at tension in the law, but it need not be so. If it's accepted that the best interests of a Māori child will always be, to some extent or other, an attachment to the kin matrix, if that is accepted, the real challenge for the law is how to achieve continued attachment if a whānau is genuinely dysfunctional, and not whether to do so. So that, if we take that starting point, and I just want to first ask you about that overall conclusion from the Whānau Ora Commissioning Agency report, the extract that I discussed with Lady Moxon, which was that the overwhelming conclusion of that report was that in regard to uplift practices in particular, it's never appropriate for the long-term well-being of Māori, and what's needed from Oranga, Tamariki or other state agencies to ensure the well-being of young Māori is the reallocation of resources for high-quality whānau-centred kaupapa Māori services in every rohe of Aotearoa. So I just wanted to first be clear, would that be your view as well?
Yes, it's important that all the three significant players, firstly Māori, the capacity for Māori, iwi, whānau hapua and iwi, the capacity needs to be built.
Yes.
Capacity, capability and confidence. And the confidence to be able to do that just in terms of systems. But yes, I think it's really important that that is done. But you can't do that, in my view, you can't do that independent of the decision maker, because on occasion you will get Oranga, Tamariki and the Māori organisations together on the same page, and we will be in court and the judge will say no. No, I don't accept that because this individual child is attached to this whānau and they will go. So the order will, so unless you have all the significant players working in the same direction, or moving in the same direction, it will be difficult.
Right. So, in order to get the players moving in the same direction. And I know at the end of your brief you talk about a number of specific amendments you would seek. Are they the key amendments that you see, or it's a big question, and
They are the
Yeah.
start.
Right.
They're as a starting point to basically reset, to try and reset the platform. But the capacity and capability has to be built up in the community. The structure for iwi to be able to respond, all of those things has to be strengthened. But so too, the platform has to be. If there is a negative way to interpret something, then it is likely that's how it will be interpreted in terms of the subsequent children legislation. And I know that that there are not many applications identifying a child as a subsequent child, but the practices are still the same. The uplift is still the same, the time it takes, the delay, the practices are still the same. I think in terms of subsequent children, it just needs to go. It's of no value to whānau hapu and iwi. It is of no value to Oranga Tamariki or the Māori or the community, the New Zealand community.
All right. You mentioned the impetus for change that has arisen from the Hastings case and the risk that that momentum might be lost or is likely to be lost after a time. One of the aspects of that particular example, which is echoed in a very strong way in a considerable range of evidence before us, including the Whānau Ora Commissioning report and the report of the Children's Commissioner, is the tremendous power imbalance at play when whānau come to the attention of Oranga Tamariki.
Yes.
And also, and I think you do mention this, the very substantial breakdown of trust in the system itself. And could you elaborate a little bit more on that issue of how you see the system currently operating in terms of that trust issue? You mentioned, I note that one example you gave was if someone seeks anger management counselling, that might be a factor brought to the attention of other agencies that could lead to further or compound the harm. So perhaps if you could just speak a little bit about that problem and how that might be, how do you work from a base of such low trust and restore or reset a system going forward?
I guess in part that's what Te Koremako was attempting to do. What we currently have is whānau don't trust Oranga Tamariki, the family court, or Oranga Tamariki. Oranga Tamariki don't trust the whānau or the family court really, but they're required. They're legally required to follow the processes. The family court don't really trust the whānau or Oranga Tamariki, but in a competition between the two, they'll go with Oranga Tamariki. So there's this terrible sort of context that whānau are having to operate in. What Te Koremako was designed to do was to basically teach whānau the rules to the game, the rules of the game, the right words to say, the planning, do all of the planning, so that they can front up and have iwi standing beside them, lend the strength of the iwi beside them, or the organisation, say Te Kōhao or Te Whānau Waipareira, beside them, so that they can stand and say, no, you don't need to do this because we are doing A, B and C, and trying to get better outcomes, try and build some respect, but it's slow going. It's slow going, and in part that's probably why I say, one, I think the platform for the change in Oranga Tamariki is there, but it is very brittle. It's a bit shaky, so we need to try and lock that in. But we also need the family court to come along, and if, as we say in our report, establish a board. It might be similar to yourselves. Sit down and have a conversation with the whānau. Whānau, you know, what's the plan? How are you going? What are you up to? You know, te kohau, how's this whānau going? You need, the whānau need to feel that you give a damn. Needs to feel that the system gives a damn in order to respond. And so you've got places like that, you know, the district court have the alcohol and drug court, family violence court, sexual violence court. There are probably about 10, te pai oranga, all of those at their most basic level are about engagement and saying, whānau, we care. We care, we want to make a change. And so if we can have the family court on board and actually, you know, we care and move along and reflect the community, and we have Oranga Tamariki with the children's monitor keeping them accountable, and we have building capacity for whānau, the possibility that we can move in a direction that gets better outcomes for us all is higher.
Kia ora. What do you see as the factors that make the commitment of Oranga Tamariki to change brittle at the moment?
Because what you talk about in Wellington and what the communities do are two completely different things. So while I'm a member of the Māori Design Group for Oranga Tamariki, while we have these conversations about structural change and what needs to happen, and you know, some of them are quite positive, what happens out in the communities might be two different things. So I've recently been to an FGC, and you know, and whānau, they've currently employed a number of Māori FGC coordinators. Now, please, I don't really mean this to sound disrespectful, but it's going to sound that way. So they've been browning up the FGC coordinators. Okay, so, and that's not necessarily a bad thing, because, you know, but if you don't teach our whānau FGC coordinators the rules of the game, they will be asking our whānau, and in many instances convincing our whānau to agree to things. They have no idea what they're asking them. So is a child in need of care and protection? If our whānau, as I'd said before, and I've been to one recently, you know, brilliant guy, you know, saying, whānau, is our baby in need of care and protection? And the whānau don't really have a clue, but what they also don't know is if they say yes, this young mama and every baby she has is going to be come under the subsequent children legislation. But he doesn't know that because he hasn't been taught that. He doesn't even realise what he's asking the whānau. So those sorts of, when I say it's brittle, that's what I mean. It's a bit shaky. So we're hoping that they all come to the Koremako legal education program, because they need to stop doing this to our whānau. And if you're going to ask our whānau, then you be upfront with them about what it is you're asking them, or asking them to answer. So that's what I mean by it's a bit shaky. I mean, there's the other thing. Well, Oranga Tamariki have obligations, mana tamariki, whakapapa whanaungatanga. They will be paying for the legal fees of the lawyer for the permanent caregiver who's seeking to disconnect that baby. So on the one hand, they're saying, yes, we support it and, you know, we really want it. And then they're paying the other one on the other side to say, no, 1 hour, 4 times a year. That's a huge contradiction. You can't have it both ways. You're either with the kaupapa and with Te Tiriti o Waitangi and your obligations to the principles, you're either with that or you're not. Which is it? You can't keep doing that. And you're doing it to our whānau.
In terms of the building capacity, do you have any particular views on approaches, for example, the mātua whāngai? You mentioned the post, or the late 80s post Po Te Atatu and the improvements then that I think you said they were brilliant, but they didn't last. Mm-hmm. Are there aspects or parts of that could and should be picked up and re-implemented?
I'm not sure about whether they could be picked up. The mātua whāngai kaupapa could be picked up, those. But we need some way to sustain, you need the oversight to sustain them. Because in that time, what I understand happened is, I think Anne Herkis, who was then the minister, then left or was not, maybe the government didn't get in. And so the world changed again. So it lost its momentum. I think I think we have a huge number of Māori organisations, both iwi and urban Māori organisations. So I think it's there. The building blocks are there. The same as we had back then. We just need to strengthen them, and we need to shift the power. And that means across the board.
Right. And just going back to this, this tension in the law that you discuss between the primacy of the child and then the place of a child in the whakapapa network. One of the points that is apparent to us from Mr. Cook's evidence, the statistician, and from the Children's Commissioner's report and some other evidence is the quite, well, I was going to say partial or poor quality of the data. But, and I'm not sure whether I'm properly asking you something in your expertise or not, but so just say so. But as you understand it, and from your time in the field, what, if any, data is collected about the outcomes for Tamariki of uplift and state care? I mean, aside from all the negative stats that we know, I'm talking about measurements of, is it considered a net improvement or a net benefit for that particular child? Because if you're following that trauma approach, the assumption there is the child will thrive if you remove the harming circumstance being the whānau. So if that's the assumption the system is applying, is the system measuring the outcome of that premise, to your knowledge?
I'd like to say my delay in responding is because there are other alternative answers, but it's no. There is no, as far as I'm aware, there is no evaluation of practice or anything that would measure that. Likewise, there isn't in the family court either in terms of the orders that have. I mean, there's probably about 500 special guardianship orders made that have just disconnected at least 500 children from their whānau. So, in what way is that? Yeah, in what way is that in the best interest of the child? But how is that being measured in terms of long term? So no, my best, my only way of measuring that is on the parole board. I sit on the parole board and have for a number of years, and there will be a significant number of Māori men, not so much Māori women, but Māori men who will say, I was in care, I have no contact, I have nowhere to go. And they are trying to find their way home. And you know, it's a pretty impossible task if you've been disconnected really early.
Thank you. I'll just check with my fellow panel members.
Tēnā koe, thank you for your evidence. I've just got a couple of things I'd just like to explore with you a little bit, and they're around some of the presumptions that are at play in this process. So just from your experience in working in this area, can you just tell me about when you're observing people either exercising their responsibilities or decision-making roles, whether it's Oranga Tamariki workers or in the courts or third-party organisations, have you ever observed the presumption that the connection of the child to the kin is being recognised as an important protective factor and important to the well-being of the child? Do you ever see that presumption playing out?
Probably more in a cursory way, and that's more probably prior to kahungunu, the attempted kahungunu uplift. No, and it's usually window dressing.
Okay.
it's usually saying, oh yes, you know, whakapapa is important, and oh, actually they don't say that. You know, family connection is important, things like that. But we're going a different way. But the best interest and welfare of the child mean we need to do this. So that would happen a lot. For Oranga Tamariki, they just seem so focused on the mum or the dad or the, you know, so any discussion about extending that or looking at other whānau seriously, and it seems the organisation can only look at one person at a time. So if we're talking about delay and things, if the child's been uplifted, they might look at Nan, but there might be 5 other people, but it'll take a couple of months, 3 months to look at Nan, and then they'll say, oh no, wait for the FGC, and then they might look at the others. But by the time they do all of that, the child is, you know, basically the younger the child is, they'll be attached to the caregivers, and then they'll say we can't move the baby because the baby's attached to the caregivers. And then the court will reinforce that. On occasion, when Oranga Tamariki has tried to move the child back, because now there is a focus on whakapapa and whanaungatanga, I have experienced the court saying, no, you will not do that. It's my job, and you know, the well-being and best interest of this child mean they will stay over there. So, yeah, I haven't experienced that as a regular thing or as a normal thing. You might get the odd really good Māori social worker, or the really good Pāhia social worker as well, who might look at that. But it doesn't hold.
Okay.
It doesn't last.
Okay. On the subsequent children, again, when those provisions are being exercised, have you ever sort of seen the underlying presumption that actually our starting point is that this parent may have changed rather than our starting point is this child should go?
Yeah, no, not so much. Not so much really, and that's part of the problem between what happens here in Wellington and what happens out in the regions, because Wellington might talk about that and say, yes, we'd look at that, and, you know, presumption should be, you know, or, you know, if mum's good. But when you go out to the regions, it's not so much. The FGC I attended recently, everybody agreed that mum and the baby were doing brilliantly. Brilliant, not an issue. The question was, is this child in need of care and protection? Why are you asking? Why are you asking that if we all accept that baby and mum are doing awesome? And so you see that sort of presumption thing is still there. And so that requires a shift in thinking. And a shift in training, which I'm hoping will happen soon.
Thank you.
Just a follow-up question from those of Ms. Nadimu. In your experience, the practice within Oranga Tamariki around various rohi is quite variable or inconsistent? Is that a fair way to put it? Very
inconsistent. I mean, I've only ever been in the Waikato Bay, hugely different just from Taupo, from the Tuwharetoa region to Rotorua, hugely different. Yeah, and that's the shakiness of the foundation that contributes to that.
I think in both, or at least in Tuwharetoa, possibly, I'm not sure, but I know there are some recently developed memoranda of understanding with iwi. Have you seen any benefit arising from those instruments in terms of practice?
I have for Waikato Tainui and their partnership with Oranga Tamariki. It's because I at least got to see that at the beginning. And I have for Tuwharetoa. They've got some really good things going. Rotorua, not so much. Other regions, not so much.
All right. For those, I can't recall the dates for those particular instruments, but I understand they're probably within the last 4 to 5 years. Just from the examples you're aware of, are they still at a stage where capacity is being built and established, or are they, possibly it's a question I need to put to at a later time to those who can speak to it, but
Yeah, sorry, sir, I
I'll leave that
wouldn't.
there.
I mean, I know they still need to build, but I don't know exactly where they are at.
All right, thank you. Ms. Cassidy, anything further arising? Okay, thank you. Ms. Hardy?
No questions, thank you. Judge.
Thank you. Mr. Bennion?
Yes, just a few short questions. Ms. Blythe, thanks for your evidence and your education work, which looks phenomenal. Thank you for that. Just firstly, I want to put to you a proposition which perhaps encapsulates some of the questions you've been given about the quote from Justice Williams. Do you agree that the continued existence of Indigenous Māori culture depends on Tamariki being raised within it?
Yes.
Okay. Sorry, your answer is?
Sorry, yes.
Does the concept of mana tamaiti incorporate that? Do you understand it incorporates that?
Does which?
Does it incorporate the idea that for Māori culture to continue, tamariki need to be raised within it?
Yes.
Okay.
Mana tamariki, whakapapa and whanaungatanga, they all encapsulate that.
All right. I just want to move now to data issues. The Acts have, I think it's been pointed out by Judge Beecroft that there's about 50 principles in these statutes. Might be too many, but is there any data principle that you're aware of? Any principle around collecting data?
No.
Right. Do you think it would be wise to think about a data principle which requires best practice in collection of data to understand the impacts of the policies and practices of Oranga Tamariki?
Yes, I think that there should be, but it should also apply to the family court as well.
Okay. And then just moving on to the section 18A to 18D and subsequent children legislation or amendments. Were you aware, were they red flagged by any government agency at the time as to their potential effects for the Māori population or number of children being taken into care?
My slightly dropping my head sort of indicates some degree of whakamā, because what happened was, for us, in terms of the profession, is we were so busy looking after ourselves and our own interests because the family justice system was being introduced and risked taking us, us colleagues, out of the picture. We were so self-interested that the provisions for subsequent children, and they all came in at the same time, and we completely missed them. And it was self-interest. So there would have been about a 12-month difference. But everything I read about at that time, because once we did become aware of it, and there is some whakamā, because we did nothing. We were so busy watching the pebble underneath this cup, we actually missed that significant legislation, which always had the ability to remove a generation of kids. But all of the paperwork at that time, none of the papers written acknowledged any impact on Māori at all.
Did you see any, so you didn't see any specific analysis in terms of the treaty and potential impacts?
No.
Did you see any analysis in terms of, for example, the Bill of Rights Act and the right to enjoy culture?
No.
Those sorts of matters?
No.
Okay, thank you. I just want to ask one more question on that issue. I see a lot of orders are being made under section 1102B of the Oranga Tamariki Act, and this is subsequent or secondary guardians. I see hundreds of orders.
Additional guardianship.
Additional guardians. So, but it seems there's many orders being made there, hundreds of orders, but less orders for special guardians. Can you explain what's going on there, as you understand it?
The profession, and I'm saying recently there's been an article in one of our magazines saying, this is how you do it. This is how you apply for special guardianship. This is how you do it. So the profession haven't really understood the impact or how to use those provisions, because there's two pathways. There's one that can occur at the time, right at the time that the child goes into permanent caregiver's care, and you can, and that test from the permanent caregiver, from the whānau to the permanent caregivers is really simple. You want to provide a safe, loving home. There's no issue about, you don't have to have any issue about the whānau or anything, being upset or anything. That test is easy. It's a straightforward test. The other test is after you've got Care of Children Act orders and the relationship, there's a pattern of behaviour, and you're saying that the whānau are being hoha and they won't let me provide a safe, loving home for this child. So then you can apply. The profession is just coming to grips with that. We have I think you will find that over the next period, probably over the next couple of years, there will be a significant number of applications for special guardianship. As the profession comes to grips with it, as the community does too.
So, are you seeing problems with the orders under the extra guardian orders under 1102B?
No, no. The idea, and I know there was a lot of publicity about this at the time, the special guardianship, and that came through post. The idea that whānau are always, on the doorstep kicking up a stink and not preventing caregivers from doing stuff and all of that, that is not the norm. Our whānau generally don't know where the caregivers live in any event, but the idea that they are constantly battering down the door of the permanent caregivers and are unsettling the placement, and that justifies their complete disconnection, I've not experienced that at all, not in 20 years.
All right, just two more matters. One, you mentioned that Oranga Tamariki is paying legal fees for I think it's guardians, and may not for others. Is there some sort of have you ever seen a funding analysis that thinks about who's being paid for what and what the implications might be for policies and practices and outcomes?
No.
All right, and just lastly, you've talked about a board, 50-50 board as a proposal, but you also reference in your Taniwha report the Korowai report, which talks about practices more akin to the Māori land court practices being used in the family court. So should I understand you're supportive of, I think there's a discussion about, in the Korowai report about Māori land court, family court judges looking in on the Māori land court and possibly Māori land court judges coming across.
I'm not sure I'd
What's
like
your
the
view on
Māori
those
land court
proposals?
judges across, so I'll leave that with them. But the idea of having, the old time where they had assessors and things like that alongside. However we do it, if we're going to have assessors or if we're going to have iwi, we're going to have the community alongside, the power base has to be the same. It can't be that the judge in the middle makes the decisions and the other two have to just go yes. That's just not how it should work.
I think there's been discussion in those reports about the formality or informality and approach of the Māori land court. You supportive of that?
Yes. The same, I've been to a few Māori land court hearings over the years, and the same sort of whānau approach would work, but I just would like the power base to be spread a little bit more.
All right, thank you. Thank you, sir.
Your Honour, Mr Stone here. Mr Binion has been elected as the person to give cross-examination on behalf of council, but I was also asked to be second chair to potentially ask any questions should they get through the gap. I seek Your Honour's leave to ask a few questions for the witness.
All right. Just let me check, Mr Stone, where we are on our timetable. I'm not a good timekeeper. So, how many questions and approximately how long?
2 minutes.
Oh, it's eminently reasonable. We are about 10 minutes behind, so I'll allow in this circumstance, but on the basis we can move quickly because I don't want to keep the Commissioner waiting. Thank you.
Nor do I. Thank you, sir. Tēnā koe. I'll cut to the chase. You said in your kōrero that the law took the land and the law's taking our children, it stands to reason then that the law has to change. Would you accept that? And you also said, and I think you said, that the Crown Oranga Tamariki has this Trust Me plan. In light of what Kahurangi Lady Tuleti Moxham said, she essentially said we need a kaupapa-driven, Māori-designed kaupapa by Māori for Māori. Don't you think it's time that we put aside this Trust Me / Oranga Tamariki plan and we have a Trust Us / Māori plan?
Firstly, the Trust Me plan was in relation to the Independent Children's Monitor. If they think they're going to do a Trust Me, we got you plan, that's just not going to work. But in terms of the second part of your question, which now I've forgotten, you have to repeat, sorry.
Essentially, it's this. Don't you think it's time that we have, to reiterate what Kahurangi said, it's time for a Māori-driven kaupapa?
Yes, I agree. Because of the way the legislation has controlled much of the disadvantaged dispossession and disrespect for Māori over this period of time, I think it needs to be built in.
My last question, you said that whānau don't trust Oranga Tamariki and vice versa. My client, Mr. Timu, is here. He's the president of the Hastings Mongrel Mob, and in his evidence, he essentially says the same thing about his membership, that they don't come forward for the help they need because they see those people who are meant to be helping them as the very people that abuse them. Can you see why they aren't coming forward?
Well, as I indicated, and I think Judge Dugan alluded to it as well, there is so much. If I come and see you, and because I want some help, well, actually, I don't realise, but you're going to go and talk to everybody else. And so, you know, that's going to mean I don't trust any of you. So I'm not going to come because one of them is going to burn me. And so even if I build a good relationship with you, you have obligations to everybody else.
That's my 2 minutes. Thank you.
Thank you. Thank you again, Ms. Williams-Bly. Thank you for your evidence and for the mahi you have been doing. We're very grateful. Kia ora.
Kia ora.
Ms. Cassidy.
Ai, kia ora, sir. Tautoko au e o kōrero me te mihi atu ki a koe e te rangatira mo tau mahi ki Wainganui i tēnei āhuatanga. E ki ana te whakatauki i nā te mahi he rangatira, nā reira kua rangatira e koe i tēnei rā me o kōrero. Tēnā koe. Ka huri atu au ki te kai kōrero tuatoru. I'm calling the third witness for the day, sir, Judge Beecroft, the Children's Commissioner.
Tēnā koe, Judge Beecroft, and welcome.
Tēnā koe. Ki te whara i tūnei, ki te papa e te koto nei, tēnā kōrera. E ngā mana, e ngā reo, rangatira mā, tēnā koutou. Mihi mai, karanga mai, he pai ki te kōrero ki e koutou i tēnei rā. Tēnā koutou, tēnā tātou katoa.
Tēnā koe, sir. Can I get you just to state your full name for the inquiry and also just to confirm your current role?
Yeah, this is a rather reverse experience for me, but yes. Andrew Beecroft, Children's Commissioner, based in Wellington, Whanganui Aotearoa.
And sir, you wanted to make some acknowledgement today of...
Well, I'm here with my staff, and particularly can I acknowledge Dr. Kathy Irwin, our Chief Māori Advisor. We speak together, and I acknowledge my debt to her advice and input to our office.
And so you've provided a report to the inquiry?
I have.
And you'll have that in front of you there?
I do.
And it's signed and dated the 17th of July of this year?
It is.
So can I just get you to confirm the contents of that report is true and correct to the best of your knowledge?
Absolutely.
And so you would, your office also released a statistical snapshot regarding Pēpi Māori from the ages of 0 to 3 months in January of this year.
Correct.
And more recently, I think last month, the release of the report Te Kuku o Te Manawa, ka puta te riri, ka momori te ngākau, ka heke ngā roimata mō taku Pēpi. So just confirming that, sir.
Correct.
And perhaps during the time that you're speaking this morning, you can refer to those reports and highlight some of the recommendations and key points. So I'll hand it over you now to invite you to make some introductory remarks to the tribunal.
Could I start with what I might call a central submission? As we approach the 3 questions for this hearing, I've come to the conclusion that radical, fundamental, structural change for the delivery of care and protection services for Māori is the only answer. After 3 restructures and 14 reviews in the last 30 years, it is perhaps fair to suggest that the government cannot deliver effective care and protection services for Tamariki Māori. There must now be a by Māori, for Māori approach. In fact, as my chief Māori advisor informed me, the full rendition of that quote is by Māori, for Māori, with Māori, in Māori. That and nothing less, in my view, will do. That is the logic of the treaty. It's absolutely consistent with the worsening statistics, the decades of research, the reports of the lived experience of those at the sharp end of services delivered by the state. They all point in one direction and in one direction only, a by Māori, for Māori approach. No doubt this will mean real change for Oranga Tamariki. Perhaps the real question is, what is the state's irreducible minimum responsibility? Because clearly the state has a responsibility to ensure the well-being of children. But what is the state's irreducible minimum? It may well be that Oranga Tamariki should shrink. It may well be that early intervention, prevention, assistance and caring services should be provided by Māori. It may be that the role of Oranga Tamariki, for instance, should be a specialist, urgent forensic investigator of cases of serious abuse. These are all questions that our Part 2 report, which won't be available for about a month and still requires consultation, will address and provide detailed recommendations about. To say that the state is unlikely ever to be able to deliver effective services for Māori is no particular criticism of any iteration of state delivery, whether child, youth and family services, or Oranga Tamariki. It matters not. The fundamental point is the state has been and almost certainly will be unlikely to do the job. When and how and who undertakes this work is for Māori to decide. Surely that is a treaty-based approach. Iwi Māori, Māori organisations and iwi authorities will all need to be resourced and allowed to lead this work as is appropriate in their rohi, as resourced and as capacity develops. And you know, in saying this as my central message, this is effectively and exactly the recommendation of Pu'autoata too. I can't help but observe it would be great if all reports were this compact and this small. It's a clear and compelling message. I read one part of it. At the heart of the issue is a profound misunderstanding or ignorance of the place of the child in Māori society and its relationship with whānau, hapu, iwi structures. There are short and succinct recommendations. It's not a step too far to say that much of what was said in 1989 is being said today and has been said by the Office of the Children's Commissioner. Only a few years ago, the expert advisory panel on child, youth and family made a similar conclusion. in paragraph 62 of my submission. Paragraph 62. It's worth me reading from it. This is what the EAP said. Successive reviews of child, youth and family have failed to empower or deliver change for Māori children and young people. Sharing governance input to include Māori as a progressive forward step. Fundamentally, governance is about power, relationships and accountability. Who has influence, who decides, and how operational decision makers are held accountable. The panel believe it is unlikely the future development and wider system will achieve the required change without strategic Māori leadership, direction and influence. When the cries have been consistent and continuing, we now have the chance for a second revolution. I say a second revolution because in 1989 we had the chance for a first revolution. The then Children, Young Persons and Their Families Act delivered the very prescription, but it withered on the vine. Now in 2020 is our second opportunity, and many of us in this room will never have the opportunity again to get it right. A by Māori, for Māori approach now is the starting point. And I don't want to be, I put this respectfully, seduced into further optimism that somehow more patches on a leaky vessel, more amendments will bring about the change that 3 previous reviews and 3 previous restructurings and 14 previous reviews haven't been able to do. Why would we think now that further amendment and tinkering around the edges would do it? That is why I've come to the firm conclusion that I have. So if I see nothing else, that's the central message of my submission. There are 3 questions that the tribunal asks, and I am proposing that I address those 3 questions step by step. In the context that my role is twofold. It's to monitor and assess the policies and practices of Oranga Tamariki. So it's an independent role of monitoring and assessment. It's to help develop better policies. There's also a general advocacy role for the well-being of children. We have a role to inspect places of detention under the Crimes of Torture Act, which looks at cruel, inhumane and degrading treatment of those in detention. The office has an excitingly and challenging wide-ranging remit, but it's never been funded effectively to deliver it. In 2016, there were 3 staff with 1 supervisor responsible for monitoring the entire child, youth and family system. I mean, it was fundamentally and totally under-resourced for the role. I welcome the development of the new independent children's monitor. That is the right way forward. It needs proper resourcing, but it also needs to be independent, and it also, in my view, needs to have the power not just to check on quality and to tick boxes as to policies being adopted, but it needs the power to make recommendations and to speak publicly. And an in-house children's monitor, shorn of any public advocacy role, I think would be inappropriate, and it would be selling the system short, and it wouldn't be a child-centred approach. The first question asked by the tribunal, why the significant and consistent disparities between the number of Tamariki Māori and non-Māori children being taken into care? Why? The first thing to say, it is as bad as the statistics show, the disparities. They're clear in our report, in our statistical report. We believe we can treat that as a fair and accurate starting point. Waikato University assisted us. The Witness to Come assisted us. essentially the data published shows deep, persistent and increasing inequity in the removal of Pepe Māori under 3 months into state custody and for Māori children as a whole. How long can a thoughtful, well-resourced, modern democratic country like New Zealand tolerate these vast inequities? How long? Causes, I can only suggest, but the context must be to accept that Oranga Tamariki sits in a New Zealand that knows great disparities of wealth, educational and health achievement. It is fair to observe that poverty, alcohol, drug dependency and mental health issues are factors associated with but do not cause abuse and neglect. But those factors increase the risk. Māori are disproportionately represented where there is poverty and disadvantage. Until those fundamental issues are addressed by the community, the challenges for families and almost toxic stress will continue. And it's important, I think, to make that point. More specifically, there is a lethal cocktail at work of two factors: the enduring legacy of colonisation and modern-day discrimination. Modern-day discrimination consists, in my view, and the researchers, of personal racism, organisational racism and structural racism. To that, our Māori advisor adds epistemological racism, where Māori ideas and mātauranga Māori are considered secondary. All the aspects of modern-day racism and discrimination are demonstrated in our recent report, Te Kuku o Te Manawa. But again, they are wider than just Oranga Tamariki. In the justice system, in the corrections system, in the health system, in the education system, there are the same issues and the same personal, organisational and structural discrimination. But as for Oranga Tamariki, personal racism, there is the example in our report of a woman pregnant. DNA testing was required by the cutting of her hair. She said, please, for me it would be culturally inappropriate to do that. I could do a blood test, I could do a saliva test, any other test you recommend, but her hair was cut. The example of a mother being expected for fitness in terms of motherhood, and it was said while the house was tidy, the mattresses are lying on the floor. And her children said, have you not ever been to a marae before, to the social worker? Organisational racism, failing to see a baby in the context of whānau, hapu, iwi. Organisational racism in the second and subsequent child legislation. I just need to be clear. From my point of view, the second and subsequent child legislation actually is a very complicated and difficult section or series of sections that only refers to a very small group of children. It's only been used in a handful of opportunities or a handful of occasions. But this is the real problem. The assumptions and the shorthand second and subsequent child legislation description, I think, has significantly affected social work practice, so that it has become the default starting position that when a previous child has been removed, then it is up to the mother to demonstrate ability to love and safely provide for the child. I don't think that would be made explicit. But I think looking at the statistics and the sudden uplifts or the sudden increase in removals that took place right at the time when this legislation came into force, I think the only reasonable conclusion is the legislation, although hardly ever used, hardly ever relied upon, affected practice and thinking and approach. It is a pernicious, it is a totally unnecessary piece of legislation. It has done no good. It should be appealed tomorrow. It should be repealed tomorrow. Failure to engage with iwi and Māori organisations at an early stage. That is exactly what didn't happen in Hastings. Oranga Tamariki's own internal review showed a failure to engage early and to engage with iwi and Māori organisations. When that happened, there was progress. What is also a form of organisational racism is, I think, a turning back the clock to return to what might be called, the academics refer as a child rescue model. Social work academics talk about two models primarily, a child rescue model and a family strengthening model. In my respectful view, the expert advisory panel report in 2016 reads as something of a compromise between those two models. The Act itself reads as something of a compromise itself of those two models. A whānau strengthening model envisages early intervention, engagement with iwi and Māori organisations. It envisages significant wraparound support. It envisages strengthening and working with parents and whānau and hapu to provide an environment where a child can be kept safe. It's an attainable model. There are great examples up and down New Zealand where that is beginning to happen and has been happening. But when caseloads aren't capped, when social workers are under pressure, when they get into a situation too late, it is so easy to retreat to the child rescue model where families are pathologised and assessed, urgent decisions are made, sometimes without notice, and in the name of well-being, safety is prioritised over all else without exploring other options, and children are removed. And the assumption is, with an early removal, that there's no going back. And you heard Ms. Blythe talk about the development of attachment in the foster care situation. So why the inequalities? Why the inequities? That's some of the reasons. Systemic racism. Removals in hospital. Hospitals should surely be a place of health and well-being, not trauma and violence. Systemic racism. The role of the police in removals needs clarification. Who and when and how. I mean, academics write theses about why the inequalities. People will talk about their own experience, which is powerful. This report talks about lived experience. But I hope that gives a general overview of some of the reasons behind the disparity that exists, set in the context of an unequal New Zealand, where there is significant poverty and disadvantage, and set in the context where there is within Oranga Tamariki, as within any government agencies, ongoing racism and discrimination. And on top of that, policies and legislation which have not assisted. Question 2, what improvements to practice and amendments in the current new legislation may bring about change? I have to be honest here, I don't really want to answer that question, because practice and legislative amendments aren't the answer. They're not the full answer. In my view, they're merely points along the road to a different destination. That is, to full devolution, to a by Māori, for Māori approach. But of course, there are always improvements that can be made here and now, and they must be. This situation must not continue a minute longer. So the questions that you ask, yes, I can answer, but in the context of improvements are only waypoints along the journey to a different endpoint than we've ever had before. There's 3 things I'd point to in the practice and legislation that I think point to an improved way forward if they were implemented. The first is the adoption in the legislation of 3 principles that were never there before. They are explicit. And the policies and practices and services of the Department of Oranga Tamariki have to have regard to these 3 concepts: mana tamaiti, whakapapa of Māori children and young persons, and whanaungatanga responsibilities of whānau, hapu and iwi. It was interesting, when they were first introduced into the bill, they were expressed in the definition to apply only to Māori children. After consideration, that was, in my view, correctly rethought. So the definition, for instance, of mana tamaiti now reads, means the intrinsic value and inherent dignity derived from a child or young person's whakapapa, genealogy, and their belonging to a whānau, hapu, iwi, or family group in accordance with tikanga Māori or its equivalent in the culture or the child of the young person. So the 3 concepts, mana tamaiti, whakapapa, whanaungatanga, now are expressly directed to apply to all children. And I think that's an exciting step forward. It's a recognition and acceptance that such approaches would benefit all children. The question then is, are those 3 quite radical steps forward for a system in the past which too often practiced from a Pakeha set of assumptions, are those 3 principles actually being implemented? If they were, and if they were given life, entry into state care must drop. They would have to be. The Hastings case simply would not have happened if those 3 principles were operationalised and put into practice. They do provide, I think, an improvement in terms of practice. The second thing to say is, or to point to as an improvement, is that towards the end of 2017, a new practice framework was introduced for Oranga Tamariki. It had 8 principles. One of them was expressed as being whakamana tamaiti. It foreshadowed 7AA that had not yet come into force. So far, in our view, it has been delivered in a patchy and inconsistent way, with pockets of practice that have brought that to life. And we know of areas in New Zealand where that is happening, but I don't think it's appropriate for me to positively name and shame different areas, and they're just our office's view. But there are clearly pockets where there is significant improvement taking place. But as with this issue as a whole, there needs to be more national consistency, proper training, and organisational wide commitment. The last of the three improvements that you ask me to look at is section 7AA. I want to spend a little time on this because it's one of the most talked about sections in the Act. And if you've got my submission in front of you, it's set out at paragraph 71. I don't know if it can be put up on the screen, but it sets out the whole section. The first thing to say is that somewhat encouragingly, it says that the duties set out in this section are imposed in order to recognise and provide for a practical commitment to the principles of the Treaty of Waitangi, Te Tiriti o Waitangi. I mean, that's a good start. The question is, how well does it do that? And I guess when it first came out, I, like many, was quite excited. I thought there's something in here that's going to bring about, could bring about change. And while that's true, I've come to the view that it's a rather pale imitation of what the treaty might require, and it's pretty thin, and at most it's a basement of obligations that one would have thought it didn't need 7AA to say. I mean, I would have thought the sorts of things that are talked about here would have been implicit since 1989. And it's a bit of a shame on us provision in a way, shame on us for not delivering better. But I hope we regard it as a basement, not a ceiling. Some of the words in the section are interesting. If we scroll down on the screen, subsection 2, the Chief Executive must ensure, now you'll see in B, that's encouraging, policies, practices, services of the department have regard to mana tamaiti, tamariki, whakapapa of Māori children, and the whanaungatanga responsibilities of their whānau hapu and iwi. I mean, that's a very explicit statement. C is interesting. The Chief Executive must ensure the department seeks to develop strategic partnerships. It's interesting, the word isn't that the Chief Executive develops strategic partnerships, it's the Chief Executive seeks to develop strategic partnerships. What's mandated is the effort, not the outcome. I mean, maybe the wording was to guard against the imposition of partnership, but partnership by definition can't be imposed. I do think it could be rethought. Does the word seek need to be there? You can try and try and try, and as long as you've tried, it doesn't matter if you don't get there. You will see, for instance, just to keep the screen up there, in Roman numeral 4, provide opportunities for the Chief Executive to delegate functions under this Act to appropriately qualified people within these organisations. There's an interesting debate as to who determines the appropriateness of the qualifications, and do they mean tertiary qualifications or do they mean 30 years lived experience in the front line of a community? But whatever else, there is no parallel obligation to provide the offer of capacity building or to provide resources. It may be implicit, but nowhere is there an explicit obligation to provide resourcing to develop the, quote, strategic partnership, which is an interesting term and isn't a treaty term. I'm not quite sure what the word strategic adds to just partnership. In my view, 7AA could very quickly be rewritten to impose much more powerful obligations on the state with a clear commitment to ensure there's capacity, the offer of capacity building. I mean, you can't force capacity building on any partner, but you can offer it. and a clear commitment to provide an equitable share of the resources. But it's still only a step along the way to full devolution, to full by Māori for Māori. So I don't want to be seduced into thinking amending 7AA will solve it. I mean, there are some good examples. On January the 31st, I was in Gisborne where Ngāti Porou launched its strategy for Ngāti Porou children. And there was an explicit commitment that there will be no Ngāti Porou children in state care within 5 years, provided there are resources to build capacity for Ngāti Porou to develop its own services and support and assistance, and that there is a full transfer of state resources. Ominously, that very report noted that in 1989 there was exactly the same promise. But in the end, none of the government departments delivered, didn't transfer any resource. And the vision shrunk, and as I said, withered on the vine. So that, I hope, makes some observations about question 2. What is there in the Act that might lead to reduction of those disparities? And I think it's fair to say that if those 3 key principles were operationalised, if the practice framework was nationally and consistently rolled out, if 7AA was beefed up, rewritten, if what so many iwi around the country are saying they will do, if resourced in a proper way without the strings attached, then there's every hope to think there would be improvement. But let's make no mistake, at the moment, it's partnership only of a fashion. It's partnership where the power is still with the state. And even if you slide down there to, if you could keep going, that's very good. 3 and 4, one or more iwi or Māori organisations may invite the chief executive to enter into strategic partnership. Number 4, the chief executive must consider and respond to any invitation. The power is still entirely with the state. So in the sense that we assume step changes and tinkering is going to work, there are step changes and amendments here that are going to improve things. But the real question is, do we confront the issue of a by Māori for Māori approach where Oranga Tamariki reduces to an irreducible set of minimum obligations, and iwi Māori organisations, including iwi authorities, are properly resourced in their own time and in their own way to deliver on that new vision. So question 3, what more can be done in the future? I guess I've sort of answered it. It can't simply be any more a matter of small step changes of a 4th restructuring and a 15th or 16th review. And it's a natural human inclination, it seems to me, to think that this time, with this group of people, we're going to get it right. And I guess there have been other children's commissioners and other council and other courts and tribunals who've thought, yeah, we're optimistic, this time we can do it. But that's why I've said, with a slightly heavy heart, I've come to the view that I don't think we can ever, in that sense, do it. It's the paradigm change, Your Honour, that you talked about that can do it. But that said, there are some obvious issues that, in my view, clearly need change. They're only improvements. They're not the full by Māori for Māori approach I'm talking about. And it's sort of watch this space, because our part 2 will have a lot of more detailed recommendations, and I'm saying today what I've said previously, but there'll be more in our report. But one is, could the Treaty of Waitangi be explicitly incorporated into this Act? It's incorporated into the Conservation Act, and it's incorporated into the State-Owned Enterprises Act. Here's the difficulty if it is, because the wording would be something like every action and policy and practice made under this Act must be consistent with and reflect the Treaty of Waitangi. That would immediately make every decision made by every social worker justiciable in the High Court. And you could imagine the government might respond that such a provision would chill, if not paralyse, social workers. But equally, maybe the time has come to hold decision makers to that standard. It's worth considering, and a halfway house would be to say that if not every decision, then every policy, every framework, every funding decision should reflect and be consistent with the treaty. But 7AA, in my view, is a pale imitation of what could be achieved in legislation regarding fidelity to the treaty. The second and subsequent child legislation should be repealed. We should ban removals of pepe Māori from hospital, at least, or only if there are demonstrably exceptional circumstances. The Auckland DHB got a great memorandum. That's the trouble. There are DHBs that have quite different approaches, but in Auckland, as I understand the position, there isn't a removal in hospital. If there is going to be one, it's planned and it's organised, and the mother has the chance to spend a much longer time in hospital, and there's an orderly and a sensitive and a culturally appropriate, as best as possible, ending after 10 to 14 days when the hospital visit ends. But there's something wrong at the moment that hospitals, which should be, I would have thought, about well-being, can be associated with upheaval, trauma and dislocation. We need to clarify police involvement in removals. And I have to say that, I think Mr. Benyon adverted to it, when you count them, there are up to 50 principles in the Act. It requires a huge amount of wisdom and understanding and time to try and harmonise those principles. And I do think they're a bit of a compromise in terms of a bob each way as to whether we're talking about child rescue or whether we're talking about building and strengthening families. I mean, that's a very crude generalisation, and it would be worth hearing more from academic social workers about it. What I mention is there's one principle, for instance, in the Act that's easy under pressure to go to. It's in section 13. So the child or young person should be removed from the care of the member or members of the child or young person's family, whānau, hapu, iwi or family group. Only, a child should be removed only if there is a serious risk of harm or child to the young person. Now, under pressure, when there hasn't been good work in prevention and assistance and building the capacity of a family, that's an easy single principle to resort to and say we are about intervening when there's serious risk of harm. And it's a superficially plausible justification. And it's indeed what the wording says. A child or young person should be removed only if. It doesn't say must be. But there are so many other principles that talk about reducing that serious harm, providing assistance support, building whānau capacity, helping. And it's that conflict between the child rescue model and the whānau strengthening model. And our report to Kokoro Te Manawa, although the first report, it wasn't a quantitative statistical study of every Māori mother in New Zealand, but it was a deep insight into the lived experiences of a small group of mothers who had had long-term involvement with the state. I mean, their stories and their, what we have said, 6 key themes, areas for potential change, they point in their own way to future change. And we'll be talking about it. So in conclusion, I've tried, Ms. Cassidy, to give my central view to answer the question of why the disparity, and it is vast and it is at crisis point. Is what's in place since 2017 capable of delivering change? It is. Thirdly, what more should be done? A by Māori, for Māori approach. That's the only paradigm, in my view, now that's worth pursuing, and why wouldn't we?
Tēnā koe. Again, Commissioner Judge Beecroft, thank you very much for the clarity of your presentation. We're going to break now. Believe it or not, we're actually on time for about 40 minutes, and then we'll come back for questions. So thank you.
Thank you, sir.
Kia ora koutou, we're just about to restart, so if you can take your seats, please.
Ms. Cassidy.
So just moving on now after lunch, I understand that there's a few points that you want to clarify, and particularly in terms of the comments you made around explicit inclusion of te tiriti or waitangi within the Act. So do you want to elaborate on that, sir?
Yes, just to say, and the lawyers here...
Oh, sir, I'll just get you to...
The lawyers here will want me to acknowledge that, in fact, Section 4, which is the purposes section, refers to the treaty, and that what is done under the Act should provide a practical commitment to the principles of the treaty. My point is, the ordinary interpretation by lawyers is that doesn't incorporate the treaty into the Act in an explicit way, and it would need a separate section. And we have the Conservation Act and the State-Owned Enterprises Act as an example to do that. So what's there is a small step, but it's not what might be called the full Monty in terms of full incorporation. The second thing I was going to say is and to acknowledge that for an elder or an ageing Pakeha man, it's hard to talk about by Māori, for Māori. But I do acknowledge, and it's in our submission, that it's a better starting point to say by whānau hapu iwi Māori, for whānau hapu iwi Māori, and different iwi Māori organisations in different areas will be ready at different rates and at different times. So I'm not suggesting there is one national enforced model as if all Māori are to be considered in the same way. And I hope I say that in a sensitive and thoughtful way.
Thank you for that clarification, sir. I'll hand it over to the panel for any questions.
Kia ora anō, Commissioner, Judge Beecroft, thank you again. I'll start with a few questions, and I may zigzag around a little bit, if you could bear with me, between some of the more fundamental matters for change and some of the detail. But just, if I could just first start with your discussion in your brief of the first question we posed, the reasons for the significant disparity. And as I understand your evidence, and in particular your clear view that what's required here is a fundamental paradigm shift, if I can use that phrase, to a by Māori, for Māori end point. And as I've asked some previous witnesses, I just wanted to get your view on the whānau Ora Commissioning Agency's conclusion, which is quite similar, and using different phrasing, but it appears that by, if you like, a different route, you've come to a very similar ultimate conclusion, and their ultimate conclusion was that the state care of tamariki and pepe Māori, and in particular the uplift practices used, are never appropriate for the long-term well-being of Māori. And they go on to recommend the reallocation of resources in much the same way. So I just wanted to give you the opportunity to comment or clarify whether there was any significant difference, as you see it, in the conclusions that you're expressing. And I appreciate you've got another report pending. And where the whānau or a commissioning agency also has landed.
Yeah, well, they're two separate independent reports, but suffice to say I, in general terms, agree.
All right, thank you.
Although I could just say, this again is hard to explain in a nuanced way, but I think the issue is not whether removals will be required, but first of all, is it the state? And can it be done in a planned and appropriate way? And is the placement always the whānau hapu?
Yes.
Iwi, that's...
which I guess comes to that...
I mean, there are people in this room who've said exactly that. Of course, stepped in myself, I've heard, and removed, if that's the word, taken into care children in our whānau. But it's us who's doing it, and we recognise the need, and we're empowered to do it. It's not the state forcibly doing it.
Yes. And that I guess, comes to the point you made or posed, really, which is what is the appropriate minimum residual role, if I can put it that way, for an agency like Oranga Tamariki? And is that a matter that will be discussed more fully in the forthcoming report, part 2?
Yeah, I think it's one of the big questions. Yeah, what's the minimum? What's the irreducible minimum below which the state can't go, but consistent with the state's obligation for its citizens?
All right. And I guess our particular focus as a tribunal, and I acknowledge, your office and our tribunal have differing roles and responsibilities, but our particular focus is on what a tiriti or treaty consistent framework would look like. And so hence our interest in the work that you have been doing and in the very clear direction of travel you've signalled. At paragraph 20 of your brief, you talk about the data in your snapshot showing those persistent and increasing inequity in the removal of pepe Māori into state custody, and then go on to say, how well do the social work assessments increase the safety and well-being of pepe Māori? One of the impressions that we have gained from the evidence we have considered or read thus far is, and I think you described it as a crisis, this breakdown in trust, this breakdown in the operation of those agencies of state when they intervene in the lives of whānau. And I just, you would have heard the discussion I think I had with Ms. Williams-Blythe about that, well, what factors appear to be contributing to that breakdown in trust and the almost default reliance by Oranga Tamariki on the more coercive end of the powers available to them, which seems to be a feature particularly evident in the snapshot of the pepe Māori, and particularly in the last several years, which is an area we're endeavouring to focus on. So I wonder, if I really am just inviting you to comment on any views you have formed about factors that are contributing to, in terms of social work practice, in terms of those relationships that are leading or exacerbating those disparities? It's a big question, sorry.
So in a sense, it's all that I've talked about. But I would say that mistrust, almost a great divorce between the state, whose job is to provide support and confidence, and those with whom they're working, has broken down. That great divorce, that's been happening for decades. We've got to see it in a much wider context. It's not as if it's suddenly emerged now, or there are practices now that have suddenly exacerbated. I think it's in the context of a long-term breakdown in this area. I mean, there was the same concern about lands and rivers and sea in the 1980s and early 90s, which resulted in a paradigm shift. The challenge is here now. Of course, there are instances that can be pointed to right now, such as the effect of the second and subsequent child legislation, which actually, as I've said, is very rarely used. And it's very hard to use because it's so restricted. But the thinking has affected, I think, practice. There's issues such as I understand it, not an explicit capping of caseload for social workers. There's pressure on the system. There's an EAP report that I think was slightly unclear as to whether it was an out-and-out whānau building, whānau strengthening approach that should be taken, or a child removal approach. And I think there's not an explicit and clear vision within the state at the moment as to which of those, it's sort of a hybrid model. But I think under pressure, it's easy to retreat to keep a child safe, rely on the legislation and remove. But when that happens, it's often last minute, and all the things that I talked about happen, and it's often not to Māori, it's not to the same culture. And the sadness is that when a mother has had a child removed once, in a way that all of us as humans would understand, but is hard to articulate, a mother's so desperate to have a second child or further children to show that she can be a mother and wants to be a mother. And one of the great problems, I think, I hear all around the country from NGOs and Māori organisations, that when a child is removed, so is removed the funding. So the mother's left helpless, without support and assistance by the state, because the baby's gone. And almost certainly she'll want to have a second child, and that's understandable. It's a natural human instinct. But with the thinking of the second and subsequent child legislation, and almost a reverse onus in practice, you show that you are now capable, with no help or assistance having been given since the first child was removed. It's a desperately sad and self-perpetuating and self-reinforcing situation. And if the state, in the current paradigm, is to remove, then surely there's an obligation to provide ongoing assistance for the mother to ensure that what is likely to be a second time round experience is much better supported. And in a way, the Hastings example was that in microcosm.
Indeed.
Which is a long answer to your short question, but
no,
in one sense there are factors that have existed for ages, but we can point to some immediate factors as well.
Yes.
Where the balance is, I'm not sure. And I guess what I've really been saying is I personally think it's wrong to signal out Oranga Tamariki. It's better to say the state hasn't ever been able to do it in whatever iteration.
Yes. And I guess there are some, not limitations, but boundaries that we as a tribunal have to be aware of when we think about the role of some of those agencies, including the family court, in the, or particularly the family court, in the, as an actor in this in this space.
I understand your exquisite dilemma exactly.
So I'll leave that for now, but there is an observation you make at paragraph 34, where you're noting the poor outcomes, and then at the end of the paragraph, there is not enough information to say whether children are better off overall because of state intervention. I just was going to invite you to elaborate on that. Is that a comment on the adequacy of the data?
That's it. The previous Children's Commissioner, when he started the State of Care series, which we've continued, first report said we measure the inputs, we measure the resources we deliver, but he couldn't find a helpful or coherent set of measurements that showed what that achieved.
Right.
And as I understand it, Mr. Cook will have plenty to say about the ongoing lack of easy measurement of that.
Right.
Even the statistics that we wanted to get were really hard to get. And as I understand it, aside from OIA difficulties, it was essentially because they weren't there in the form that were easy to read and to understand. And that's long-term too.
Yes.
But given the state's responsibility and given the enormous resources put in, you would think we'd want to measure really carefully the achievements, the outputs. And that's what the office said then and is still saying. But I know that's what one of the things the EAP talked about. And I know that's got to change.
Yes. Thank you. Paragraph 63, 64 and onwards, you discuss the child rescue model and the role of whānau, hapu and iwi as coexisting in unresolved tension. Would it be fair to, as a generalisation, to say that the rescue model appears to have dominated in the last 5 years, or possibly for much longer, but
it's really hard to answer that because in the end, the answer is what's happening at the coalface, and we know there are patches where there's some pretty significant work going on, and we know that, but there are also big patches where it's very inconsistent. And even using the academic terms, child rescue model, whānau strengthening, can oversimplify it. I don't think it is that simple. I think there's always been an attempt to have a hybrid, and it's too easy to fall into generalisations.
Right.
And one might say that seems to have been what has happened, but it might not have been because of adopting a child rescue model. It might just be for other factors, but what the result is, you could say, does amount to a child rescue model, but I'm not sure that it was ever explicitly followed or intended. So I don't want to be too generalised, too simplified.
I think just a bit further on, you actually discuss in a bit more detail paragraph 68 through to about 70. There's a more complex and nuanced account there of of what you're just discussing. And I guess my question would have been better put in light of those, because you're acknowledging there those nuances and the various factors that might have contributed, including that emphasis on the earliest opportunity intervention. But I guess if I just rephrase the question as, the factors that might have been influential in perhaps pushing a rescue type or a conservative approach to the fore, so that it is sort of reflected in the uplift statistics, particularly of Pepe Māori.
Yeah,
It's quite appreciate that they may well be a repetition of dynamics and factors that we can see or trace back through the data at various stages for many years, but just wondered whether from the result of the work that you've done, there are any factors that are particularly clear or prominent in this matrix in the recent past, the last 5 years?
Second and subsequent child, non-cap social workers, risk aversion. I mean, I hear often, but Judge, don't you understand what you end up saying is, to social workers here it is saying we're damned if we do, that is removed, damned if we don't, removed. And I say, but that just reverts to a binary simplistic one or the other. I mean, what the cry under the current model is for expert, professional, early intervention, consistent social work that builds relationships and strengthens families. I mean, if that's all done, then there isn't the criticism under the current model. But it's so unsatisfactory to pose it as those, one of those two binary options. The criticism is for failure to really give life to all those principles.
Right. Thank you. Can you just elaborate a little bit more on the non-capped social work? This is the caseload problem, is it?
Yeah, that's something we want to talk more about in our report, and I don't want to give the wrong information.
Okay.
And I want to find out exactly what the position is. But I think for myself, I think it would be useful. It may be looking at the degree of complexity of the case has something to do with the capping. But it's been an issue for quite some time within Child, Youth and Family, and former chief social workers wrote reports on it. What it's hard for me to know right now is there. We want to find that out.
All right. Thank you. In your discussion this morning, you talked about, and I can't quite remember the exact context, but waypoints along the way to full devolution. In your second report, is that an area that will be explored further?
Yeah, to a degree, but I think one waypoint is the genuine partnership. So the 7AA analysis, it's really hard, I think, for one person to give a balanced analysis of that, because some would really applaud the fact that here's a mechanism to give effect to the treaty. Others would say, but it could have gone so much further. Why didn't we? Some would say, well, why was not Oranga Tamariki onto this straight away? Started in April 2017. Why sort of wait to 2019? But others would say, well, there are 4 strategic partnership agreements in place now. So it's getting the right balance, and it's a subtle balance, but I guess I'm of the view that I just wish it could have said more.
All right.
And could have been clearer about the partnership.
Yes.
And an equality of partnership.
Thank you. I'll stop there to give my colleagues a chance to ask some questions, which I know they have. And just thank you again for your report. We look forward to your second part of your report and wish you well for that mahi going forward. Thank you very much.
Thank you.
Tēnā koe. Thank you for your report and for your discussions today. And I must say, the things that you said before lunch have caused me to have to rethink what I was going to ask you. So, earlier today, you talked about the Crown not being able to be successful in this area of care and protection, and that's why you've formed the view that there actually needs to be a radical change. Yeah. So that was one question that I actually do want to ask you in terms of, are you suggesting this would only be for Māori children who came to the attention of the care and protection sector, or would it be for all children that you see this may be a valuable pathway?
Yeah, I've reflected on that. I think the purpose of this inquiry and our report, what we're saying is the starting point is for Māori, given that 69%, is it, of children in care are Māori. It's essentially a system for Māori. That should be the starting point, and this is the starting point for that issue. Now, I would like to think that what is good and principled in the recommendation for Māori would be good and principled for non-Māori also. But it is a separate piece of work as to what a system might look like for non-Māori, and I know that, and it's not something that our report has or will address, other than to observe, just as you have, that there is a question there to be addressed. Okay. But, I mean, just in the same way that the three concepts of mana te maiti, whakapapa and whanaungatanga are expressed to exist for all children, I mean, there would be hope that much of what, if the full devolved approach happens, that you would like to think, I would like to think, there's much in those principles that could apply for non-Māori too. But that's not the question we set out to answer.
Given your concern about the Crown ability to be successful in this area, can I infer from that that even if the legislation was completely pitched to achieve everything that you want to be able to achieve, it still wouldn't work out because of the fundamental capability issue?
Yeah, I mean, I guess this isn't meant to be from my own experience as a judge, when it comes to predicting future behaviour, the best guide is past evidence. Well, in 1989, I was there as a young lawyer. The sense of enthusiasm that act would just bring about a revolution was enormous. But it didn't deliver. Mm-hmm. So I guess my heavy-hearted conclusion is based primarily on 30 years plus of the past, and the good people who have been committed to bringing about change haven't been able to. And maybe in New Zealand we're quite a statist country. You know, we have a strong belief in the power of the state to do good, and by and large it does. But in this area, where there's a real clash of the state obligation and the Te Ao Māori worldview, I just wonder whether it's possible. That's what I'm asking.
Okay. I just want to turn to one of the comments you made in your brief about the expert advisory panel and that its recommendations weren't fully implemented. And this might be sort of crystal ball gazing a bit, but I did just wonder if you have any views on if the recommendations have been fully implemented from the expert advisory panel, is it likely that we would have a different picture now?
To a degree, yes. And I have urged different parts of government to say that was a massively resourced piece of work with about 82 recommendations. Surely 4 years on, it's time to go through them and say what's been done, what hasn't. That's our most recent government-initiated piece of work. Given that there are improvements that can be made now, and given, even with my reservations about that, we should do them, I think it's a really critical piece of work. What have the EAP recommendations, what's happened to them? And you sort of wonder, why would we spend so much money and time into doing that without having a review 5 years on, which would be next year? What has happened to those recommendations? Because that was a vast amount of work that was put into that.
I want to ask you the same question I asked an earlier witness about basically presumptions that are in play that you might be observing. And so I'll turn to that in terms of how those who are players in the system, whether they're in the courts or in Oranga, Tamariki, when they are discharging their responsibilities and decision rights, have you observed whether or not there is a presumption that the connection of the child to kin is a protective factor that is in the interests of the child's well-being?
Short answer, long answer. Short answer is, yeah. And our levels of placement of Māori children in whānau hapu iwi care is rising, and it's quite high, and I think internationally is higher than most other countries. So that's something to hang on to. That's not often said, because I understand that that's the case, and we could file something supplementary on that. So numbers of Māori in whānau hapu iwi care is quite high and increasing. The second thing is, in terms of observation, as is probably well known, I was never a family court lawyer, not a family court judge, never appeared in the family court. I've never had first-hand observation. My background was the youth court and the district court. So I can't, would be wrong of me to be just, but if you, our Voices report talks a fair bit about those assumptions not being shown. And these are mothers in that report, most, well, not the majority, the majority have had previous children removed, and they found very much a feeling that they were being assessed and judged on the past, not for what had happened now, and a feeling that connection to whānau hapu iwi wasn't as important as safety. But further than that, I wouldn't like to generalise.
I want to go to the process for subsequent children and just ask if in the course of the work that you've done, so what I want to ask about is the, we've been told about whānau not being properly advised that when they say, yes, we agree that this child is in need of care and protection, that it applies to others, you know, to future children. And so I just wanted to know how prevalent you have come across that in the work that you've done, and whether or not, in your view, it's an oversight that whānau aren't advised that this will be applicable to subsequent children, or if it's a deliberate omission.
Yeah, I think the starting point, if I can be appropriately respectful, would be for the tribunal to get some independent legal advice as to what the second and subsequent child legislation actually provides for. But it's right that in a situation where there's been an agreement or a removal of a prior child, and I think the wording is no, it's a pretty high bar, no, I can get it, it's an 18A, there is no realistic possibility. If the court has determined that there is no realistic possibility that the child or young person will be returned to the person's care, if that high bar is met, then that second and subsequent child legislation is triggered. As I say, it would be good to get some stats as to how often that legislation's actually been relied on. I think it's less than 8 in each year, very small numbers. So the issue is not so much the legislation itself, I think, but the assumptions that have been accepted
Around it.
Oranga Tamariki wide. Whether people would say that or not, because if you look at the stats, the uplifts really started to increase about the time that this bill was foreshadowed in 2014, enacted in 2016. And even Oranga Tamariki itself, in its own explanation of the stats, have said that could well be one of the key contributing reasons. So they've said it themselves. And the shorter answer is that because of that, mothers have told us that when they've had a second or subsequent child, they feel as though having had a prior child removed, even though the Section 18 provisions aren't being relied on, they feel there's an enormous hurdle to jump, and everything depends on them proving somehow that they are now capable. And if they've lost all the support because the funding goes with the baby, then it's very hard for them to demonstrate that.
And when they told you, that this was how it felt for them, did you get a sense that they knew that this would be the case after the first child was taken, that they knew that they would be facing the second child issue? Because one of the things that we've been told is they've not properly advised at the family group
Yes and
conference.
no, but there was an ominous sense that they were going to find it, they knew it would be hard to demonstrate that the child, that they were fit, to use OT's word, fit and proper to keep the child. So, I mean, what I'm about to say, I need to be careful about. I have no proof of this, and I have no first-hand evidence, and if I did, we'd want to do something about it. But what I hear as I travel around the country, speak to NGO providers, that there's a group of mothers who, having had a first child removed and are pregnant a second or subsequent time, have gone to ground and are essentially existing below the radar and not engaging with health services for fear of the child being removed. And that's not good for the mother or the child, who need health checks and engagement and that sort of thing. So I haven't had any demonstrated example of that. It's all hearsay, but that is what NGO providers say is one of the downstream effects of the thinking with this legislation. That if we're going to have a second child or subsequent child, then we need to be below the radar of the state.
But it's a very chilling effect, isn't it?
Absolutely. But as I say, I've got not one example to prove, but I've had many NGOs tell me that.
There was, sorry, I'm flicking between things at the moment. There was something that I did want to ask you about in your written brief that you sent, and that's about substantiated abuse declining. So we're getting more notifications, but fewer of those notifications are actually resulting in the abuse being substantiated. Is that right?
Well, it's right that there was a significant, almost massive increase in notifications, and I think rightly so, with the public campaigns, with the It's Not Okay idea, with the anti-smacking, with notable high-profile public cases about removal. I think the public's done the right thing, and health and police and education have done the right thing to follow up concern. But it actually hasn't affected significantly the number of substantiated cases. That may have been dropping slightly, but maybe it's a reflection of heightened public concern.
So the source of this
these increased number of notifications, you're seeing that they come from the public?
Purely hypothetical.
Okay.
I'm trying to surmise as to what might be the reason. I know there are protocols for the police now when they're involved with family violence. If there are children, to always notify Oranga Tamariki. So that would certainly have had a big contributing factor. But yes, notifications, I understand it, have hugely gone up.
Okay. So what I want to know really about this is when someone has had, a concern about them has been notified and it's been investigated in some way, shape or form and there's no substantiated abuse, what happens to that file? Does that file stay there as a red flag against that person, or does it actually go, actually there's nothing here to see, so this is off the books?
As I understand it, once on the books, always on the books.
Right.
But I can follow up with that, and we can follow up with that. That would be seen as responsible organisational record keeping.
Mm.
And a way to assess risk in the future, I guess.
Yeah. As long as you're satisfied that the notifications were brought in good faith.
All of that,
yeah.
I mean, you've opened Pandora's box, that question.
Yeah. Okay. We might just try and keep the lid on that then. And that's all I've got to ask for now. Thank you very much.
Thank you. Yeah, as I say, that second and subsequent child, it'd be worth getting an independent view as to what it actually means. But I'm quite sure that whatever it means or doesn't mean, it was unnecessary. You didn't need that legislation to get to the conclusion that you needed to get if that was required, intervention and removal, and it's had a totally pernicious effect, and it's done no good at all. It was entirely unnecessary. I think it was window dressing.
Sorry, I did just have one more question that just your last comment triggered my memory on. So over and above reports of concern, are there other ways in which Oranga Tamariki assesses risk of potential harm?
When there is a report of concern, yes, they go in. There's a huge...
Yeah. But other than, do they have a predictive risk model?
I could brief you on that, but they certainly have an assessment model, an assessment tool.
Yep.
Whether you call it predictive, I'm not sure. But I guess that's what risk assessments are, aren't they? That's what assessments are.
Yeah. I'm just really going to what might raise concerns for them outside of a formally reported concern.
That's the way in to the system. The way into the system is reports of concern.
Okay.
Which come from the public, health, education, police. And a significant amount come from health education. I think it's close to half. Then there's a separate stream of police notifications under the protocol. But all that, Oranga Tamariki could give you through the Crown in an instant. Yeah. That's all up on their website.
Okay. Thank you.
E te rangatira tēnā koe.
Tēnā koe, Professor.
My learned colleagues have covered off most of my questions. However, I did want to test something with you in relation to the third question we've put forward for this contextual hearing. And so bear with me as I try and make sure I'm going to articulate this right. Earlier in your, it's in your written submission, but it's something you talked about as well, and I'm making reference to the Independent Children's Monitor, and just trying to understand that relationship with the scope of your role and responsibilities as in relation to the Oranga Tamariki Act. And in very much in a Judge Beecroft way, your generosity of spirit to be supportive of that, despite having limitations of resources in your own commission, to open that space up for others. One of the things that I'd like to test with you is whether there should be another independent children's monitor, I'll put that in inverted quotes, in light of the work that you do, or should it be more aligned to, say, for example, an independent whānau monitoring panel group that works alongside you to support the ability to monitor the role of, monitor the Oranga Tamariki Act?
Good question. I can clarify. The government has signalled and decided that our Oranga Tamariki Act monitoring is going. Finished. There will be an act that repeals that. We're given all we've got until we're repealed and ended. Our other advocacy strategy rights policy, that'll continue to be strengthened, we're told. In the meantime, a replacement's been constructed in the garage, which is within Ministry of Social Development. There are people here involved in the building. That independent children's monitor is being built and developed, and that it will be cut loose from government, and the principled intention is to return it to the Children's Commissioner. Bigger, brighter, and better than ever before. But what is not clear is what will be the powers of that independent children's monitor. It will be cut loose from government, but will it have powers to make recommendations? Will it have power to do what I'm doing? Or will it be a more constrained monitor that provides annual reports to the minister and is assessing is there compliance with the new national care standards? Now that's an important debate that is going on, but no decision is being made. As to your question about whānau independent monitoring, ideally the independent children's monitor should be constructed in such a way that it itself is working in real partnership with Māori and has a very clear commitment to structural priority to Māori involvement in Māori monitoring, given that so many children in care are Māori. And that's an issue as well. And this is all part of the building and the MSD garage that's going on. So I welcome better resourced, better supported monitoring, but I'm cautious as to yet what it's going to look like. And I guess no government department enjoys being monitored by an independent watchdog. The concept's great until the dog barks. And I don't always get it right, but it's an uncomfortable but necessary relationship in a democracy. And we ought to be welcoming child-centred, independent, fearless monitoring that puts the situation and recommendations to the government. And I think that's crucial. Won't always be right, might be rejected, but it's there as an independent, community-fed-in process. And I think it's crucial. And why would we want to limit that? Uncomfortable and difficult as it might be for the government. But that's a watch this space.
I know that was extremely insightful, because as I read it from your papers, I was trying to imagine what in light of question 3, what kind of suggestions could be made in terms of developing a treaty-based approach to this. And so just thinking about your role as the Children's Commissioner and thinking about some of the earlier comments around the mana tamariki, whakapapa and whanaunatanga, how do you get whānau into that, or whānau voice into that as part of that monitoring system, perhaps to support you in terms of mana tamariki, and how do we give, I suppose, teeth? I'm hesitant to kind of continue on this because it's still a watch the space and it's a bit of crystal ball gazing at the moment, but maybe just something you also said this morning around the patchwork approach of fixing the vessel as opposed to redesigning the vessel from scratch. Do you have any concerns that this independent children's monitor might just be shifting that around, or it's just another patch in the broken waka vessel? You don't have to answer it if you don't want to.
Oh, as part of the Watch the Space ongoing debate, yes, of course I do. But everybody in this room will be able to submit to Parliament at a select committee when the bill is out, and we'll know it. All these things we're talking about will be out. We'll know it. We can make submissions. That's part of the process. I've just given you my view. And I'm not even sure yet what is planned, but I'm sure it's all being discussed and thought about.
Kia ora.
So I don't think I'm letting anything out of the bag. I'm just raising the issues that are going to have to be worked through.
Right.
And everybody here should be having a view on that.
Kia ora. Kia ora. Thank you, Judge Beecroft.
Just on that policy work you've just been discussing with Professor Higgins, do you have any idea of the time frame when that might lead to a draft bill?
Look, it would be churlish of me to say it, but I'll say it anyway. I was appointed in 2016 for 2 years, by which time this would all be done. There'd be a new independent monitor, there'd be a new structural basis for monitoring, and I'd be gone in 2 years and replaced by someone who could take it forward. Well, it'll be 5 years next June, and I'm still here, and it hasn't happened. But I'm hoping, all that slightly smart alecky comment, it's probably ungracious of me, I'm hoping next year we can have a bill that will know what's going on and then we can move forward. But work has gone on, but it's been much slower than was ever envisaged.
Thank you.
Next year, I'm really hopeful.
All right. Ms. Hardy, anything arising?
No, thank you, Judge. And thank you, Judge.
Thank you.
All right. Mr. Benyon.
If I could just pass briefly to Mr. Stone, who's going to me to the judge, and then we'll get into questions, if that's acceptable.
Te kai whakawā tēnā koe. Nā hau I whakamana tēnei kaupapa. E hehe ana mātou ngā roia kia mihi atu kā koe, nā te mea I mōhio tia whānau tia I te ao Pākehā me te ao Māori, he tangata pukumahi mo te kaupapa nei, ko te kaupapa nei te manaakitanga o mātou mokopuna Tamariki. So we just wanted to quickly acknowledge you and all the mana that you bring here. E te rangatira, tēnā koe.
Kia ora. Thank you, sir. I've just got a few questions, but of course most matters have sort of been cleaned out. Just on that last point, Judge, that you were asked about, or you talked about the independent child monitor. Do you think that office should be jointly appointed by the Crown and Māori to perhaps reflect the treaty partnership?
That's what we have suggested, yes. For instance, going forward, there could also be in my office co-commissioner, a Māori commissioner for children and a non-Māori commissioner for children. And I can't bring that about, but we will shortly be advertising, if it hasn't already been done, for an assistant Māori Children's Commissioner, because that's the highest, most significant appointment I can make. So it's not much use. It's a bit hypocritical if I talk about by Māori, for Māori, but my own office doesn't reflect that. So I'm doing my best, but it's far from perfect. But absolutely, the governance structures for the ICM, for the Children's Commissioner going forward, we want to go much further than the 7AA model for that. That's my view. We've got a chance to do something quite radical. It's really exciting. But I hope we don't just drift back to sort of an old wineskins approach.
Thank you. And just probing this issue that's come up several times today about what is it about Māori that needs particular focus under the legislation. Mr. Cook, who's coming this afternoon, has a comment that as an Indigenous populations where connections are based on whakapapa, the fertility of the Māori population and development of its children is central to the survival of that population. Would you agree that is a thing that is not shared by non-Māori in New Zealand? Because we have an Indigenous population, that particular factor is specifically Māori.
Well, the fertility rates would tend to suggest that, but further than that I perhaps shouldn't go.
Okay.
In fact, because I just don't know. It's not my specialty area. But yes, I mean, you can look at the fertility rate for Māori versus European, and it's significantly different.
I guess he's drawing a distinction with the state, or the New Zealand state, where immigration is a factor as well. But for Māori, that population relies on its children being developed within its culture to survive.
Absolutely.
Do you agree?
Absolutely.
Would you call that, say, a treaty matter or a treaty factor? Given the treaty.
Well, I wouldn't say it
guarantees?
wasn't a treaty factor.
Right.
I mean, if children are taonga, then it flows, doesn't it?
All right. The next matter I wanted to quickly raise with you is this question of support for Māori mothers at a point where there's a question about whether the child might be taken. And this morning we heard some evidence about the ability to pay rent, for example. And I looked in the Oranga Tamariki Act and I see that it's section 13D, one of these 50 principles, or 13E, is assistance and support should be provided unless it is impracticable or unreasonable to do so to assist families, whānau, etc., if there is a risk that a child may be removed. So assistance and support should be provided unless it is impracticable and or unreasonable to do so. And I just wondered if that was pitched sufficiently high. I mean, should it ever be the case that an inability to pay rent is a significant factor in a child being uplifted?
No. But, I mean, legislation-wide, that conditionality is very common. Unless demonstrably impracticable, unless clearly impracticable, unless patently unreasonable. The various formulations are there right through every statute the Crown drafts.
And I take it that principle within the Oranga Tamariki Act doesn't mean that there's funding to Oranga Tamariki to provide the payment for the rent. It just means they reach out to whatever other agencies are out there.
One of the EAP recommendations was nearly $500 million get removed from health and education and given to OT so they could attend to those sorts of things. Well, I'm certain that hasn't happened. So that's recommendation 1 out of 82 we know hasn't happened.
Thank you. And then just turning to the question of this subsequent children legislation and the information we had this morning from Ms Blythe that it even passed by them in terms of it getting enacted without them understanding the consequence or seeing it in some ways. I just wonder, and I think I got an answer that said that she wasn't aware of any particular treaty check or Bill of Rights check on these matters. When we're dealing with something as fundamental as Māori children and the treaty, have you or do you have any thoughts on whether there should be some higher level check, equivalent somewhat to maybe the Bill of Rights check that happens to some legislation? Some sort of higher level check, some sort of disclosure of that check where there's a possibility of it affecting Tamariki Māori.
Interesting you raised that because in an hour and a half's time I'm with the government talking about why would you not have a child impact assessment for all legislation? I mean, we've got a impact assessment for women, disabled, aged, I think Māori. When I raised that question, they said, oh, you mean just another interest group? I said, just another interest group. This is nearly 25% of the population that can't speak, don't have a voice, don't have a vote. I mean, isn't that the fundamental assessment we should be running over all legislation? Had that been done, I don't see how sections 18A to 18D could ever have been inserted.
Yes. Thank you, Sir.
I wish there could be a child impact assessment for all legislation. It would benefit all children, but it would benefit Māori as well. That wasn't a formal response, by the way, it was just in passing in conversation with government officials.
Sir,
If I could just
Sir, can I just ask a question? In his evidence in chief, Judge Beecroft did a wonderful analysis of racism, and it's not in his brief, but I'm wondering if that could be provided as a summary.
Yes, I think it might be. It takes Pualta too, but goes further, and Dr. Irwin added those for me: personal, organisational, systemic, and a fourth, epistemological racism, where Māori, a Te Ao Māori worldview and Mātauranga Māori is considered secondary to the prevailing wisdom of the state.
It's that fourth one, sir, which is the kaupapa Māori subsumation to Pākehā theory. I would love to have that on the record, please.
All right, so
Dr. Irwin has it, and we can submit it.
All right, and that document is part of the annexes, is it, to the, all right. Thank you.
I think I'm getting a nod.
Yes, all right.
Sir, I was advised by my learned friends during the break that apparently there is no such thing as second chair, and the only place we ever see second chair is in Hollywood. Well, we're here in Wellywood, sir, and I would be grateful if I could have 2 more minutes.
All right, we're about 5 minutes behind, so 2 minutes, Mr. Stone.
Sir, tēnā koe. I have to be completely honest, I didn't read all your brief, and there's a very good reason for that. The reason is because I had trouble reading it. I had trouble reading it as a Māori father, as a Māori uncle, thankfully not as a Māori grandfather, at least not yet. And I say all that because I felt a level of what we would call in Māori pukuriri. And I think in English we would call that anger. I think a more appropriate word would be repugnancy. I felt all those things because, as I said, as a Māori, it tihai hai taku nākau, I whati taku manua, it was scratching and pulling at my heart, and I felt my spirit breaking. In your position as Commissioner, given everything you have seen, and you've seen more than most, and everything you've heard, and you've certainly heard more than most, at some level, do you feel a level of disappointment, repugnancy?
Profoundly so. And indeed, in terms of challenges for our office, one's always careful to avoid overstatement, but it's either one of or the single biggest challenge that our country faces for societal well-being, for national well-being. If we take that seriously as Aotearoa New Zealanders, then that is a challenge that we can't shrink from any longer.
And when I was reading your evidence, as I was turning the pages, it didn't just yell out, it screamed out to me, breach after breach after breach after breach. And ultimately, our Judge Dugan will decide whether there has been a treaty breach. But in your opinion, sir, has the Crown let down our Māori people?
Yes, I was thinking Judge Dugan might say that's the ultimate issue for the court to decide, Mr. Stone, but self-evidently the answer is yes, from my opinion, only my opinion.
My last question. They're called youth residences, and some of them are given beautiful Māori names, but let's be honest, they're prisons, aren't they?
Yes.
Sir, thank you.
Kia ora, Mr. Stone, thank you.
There is a but to that, but yes, and fundamentally they are. But they've got education, they've got things that prisons don't have. They try not to be, but in look and in approach from the outside, yes, that's what they are. Custodial institutions, prison-like. Prison-like. I've got to say, I think it's the youth justice side of, we haven't talked youth justice, but there are more signs of hope in youth justice, I think. But that's been my background. But things are progressing in youth justice, and that's something to be grasped, I think.
I should just also say that at the end of our mahi, it won't just be me trying to make this call. It'll be my... I'll have the benefit of the wisdom of my colleagues. I understand Council assisting Commissioner Judge Beecroft may have a short question.
Just a few questions, sir. And only because we've talked quite a bit about the subsequent children, but I wanted just to put it to you that isn't it really at the heart of the matter in terms of a mother that has another child? I mean, the spotlight is on her, isn't it? It's on her, it's
Correct.
on her whānau. And when we think about the fact that it comes before the family court, which really was set up with the purpose to promote conciliation between whānau, and it takes that proposition that the thinking around there is the ability within anyone, any individual, any whānau, to make transformational change, and really the lack of understanding of that. And
Give
when
the
you
smallest example. The legislation provides what are called lay advocates, awful word, coined back in 1989, whānau hapu iwi advocates. That was a mechanism that was meant to be ingrained into court, youth court and family court. I know in the youth court we looked back and in 2003 we could only find 6 examples of it, and 5 of them were miscoded so it only happened once. But that's something that we can move towards. So there is a free government funded mechanism to have whānau hapu and iwi voice in every court hearing. No one knows about it and it's not been done, but it was there in '89. It was part of the vision that never materialised.
Yes, and I think when we think about that ability to make transformational change, and then we come back to what you said in evidence about the practice of social working and the impact of that section on the practice of social workers on the ground level. And I'm talking about, like you said, their thinking and how that has in fact impacted on the way that they practice, and it may not be in a situation where you're dealing with a mother with a subsequent child, but across the board. Would you agree with that?
Well, in Oranga Tamariki's release of stats last year, they said virtually those words, that the increase, the sudden increase, could well be attributed, words like that, to the second and subsequent child legislation. So in some way, it's influenced social work thinking, even unconsciously.
Yes. And I just want to move now to your thoughts about the way forward. Where do we go to from here? And you talked about the by Māori, for Māori, with Māori, in Māori, and you also talked about the devolution to Māori, and I thought that was an interesting word to use, and I just wanted to get some clarification from you, because the definition in a loose term is the transfer or delegation of power to a lower level. But we're not talking about, when we talk about Māori, we're not talking about the delegation of that power to a lower level, are we? We're talking...
No. 7AA talks about delegation of functions. I guess I've reflected myself that me saying revolution by devolution rather implies it's at the initiative of the Crown to give power for looking after children that Māori might well say was always ours and not yours to give. And great if you want to have your revolution, Judge, but actually it was always ours in the first place. Don't you get that? So that's a fair debate that I've been challenged with.
And your by Māori, for Māori, in your view, does that, just so I can clarify, would that look like a parallel system? So you would have a pathway or a huarahi that would be by Māori, for Māori, Māori children running parallel to the current?
I mean, I do think, and it's not being evasive, that one would hope that iwi Māori organisations up and down the country could be involved with that discussion and what it looks like, where notifications, where assessment, where intake goes. There may not be a single model or two parallel. Even the two parallel question assumes two separate models. There might be a variety of different models that iwi come up with in their own way and in their own time. So I don't want to be too prescriptive.
Kia ora, sir. Koera, noi hoa ku kōrero nā reira, I runga I tērā ka mihi atu anō ki a koe te kaiwhakawā a mō tō anga whakamua a te whakaputa whakatakoto i o whakaaro rangatira. Tēnā koe.
Tēnā koe.
Anō e tautoko ana ahau ngā mihi kua mihia. Thank you again for your evidence and also for the frankness of your answers. It's much appreciated, along with the depth and scholarship of your reports thus far. We look forward to the next instalment, and thank you very much for the assistance you've given us today. Kia ora.
Kia ora. Kia ora.
All right, Ms. Cassidy.
Yes, sir.
Thank you.
So I call to the stand Helen Lay. Tēnā koe te mārei kura. Could I just get you to state your full name for the record?
Helen Margaret Lay.
And you have provided a statement to the tribunal, signed and dated the 16th of July 2020, this year?
Yes.
That's correct. And you have that copy in front of you?
Yes.
Can I just get you to confirm that the information contained in that statement is true and correct to the best of your knowledge?
Yes.
And before I move into your opening remarks to the tribunal, can I just get you to just basically summarise your roles, experiences and roles that bring you here today?
He tika ki te mei ki te mana whenua o tēnei roi I te Tiatiawa, Taranaki, me Ngāti tō rangatira, tēnā koe I te kai wakawā, me nā mareikura, te rōpū wakamana I te tiriti o Waitangi, nā roia, nā oanau hapu iwi, tēnā koutou katoa. I'm a mother, a nanny, a pauarahi for Te Pūtaitanga o Te Waipounamu, the Wāna Water Commissioning Agency for the South Island. Before that, I had the lifelong privilege of working for I te kahurangi, Dame Tariana Turia, from 1999 to 2015, as Chief of Staff for the Māori Party over some of that time and a senior advisor in the office. I was a member of the expert advisory panel for the modernisation of child, youth and family in 2015 and was subsequently invited onto the Māori design team for Oranga Tamariki since March 2018, carrying the kaupapa of Wānau Ora onto that group. I am a member of the Hauora Alliance for Te Waipounamu, a national disability support systems transformation group, and also a trustee on the board of Pillars, Positive Futures for the Children of Prisoners.
Thank you for that. And can I'll just hand it over to you and invite you to make some opening remarks.
The title of the collection of stories that we shared in the Māori inquiry into Oranga Tamariki was taken from the words of an iwi leader. Being in the battle, te mura o te ahi, is a place of chaos and confusion, a place for soldiers. It was a concept that resonated with me, taking me to my days on the expert panel in 2015. During that year, we heard too many stories of children waiting for someone to care, feeling as if social workers had let them down, were on holiday, were unknown, chaos, confusion, conflict, a feeling of desertion and alienation. At the Manurewa SIF's office, we were told of children outside the 20 days who fall off the enrolment roll for schools. At Wakataka Pōkai, of the 324 young people in residence, a devastating 85% of these rangatahi were in remand, a glorified holding pen. At Te Oranga in Christchurch, we met a 16-year-old girl. She had been there waiting to be found for 18 months. After 16 placements, they still could not find a home for her. When we asked her as to her wakapapa, we discovered that the father side of the wānau had not even been approached. Children in care told us themselves that discrimination, stigma and prejudice were part of their lot.
Who are the kids that don't go to the rugby club? Who are the kids who smell? They talked about the humiliation of a social worker turning up to school in the police car, or the shame of not being able to stay at a mate's place because their home had to be vetted first. 5 years later, just last week, I was at the Christchurch East office of Oranga Tamariki, listening to the voices of whānau involved in the intensive intervention project. This is an exciting model. It provides wraparound support to whānau as soon as they are identified at risk, making sure that the whānau voice guides their design. They describe their experience as being out on a rocky sea in a lifeboat when along comes Oranga Tamariki in a speedboat, picks up the children and speeds away. One of the stories I remember most vividly from the 2015 review was of one 7-year-old girl who thought she was in care because her parents didn't want her. She believed she was to blame. She knew no different. I drew on her experience in talking with Hannah O'Regan at Te Runanga o Ngaitahu. These were in the days before the strategic partnership, the days before Oranga Tamariki. We talked about how we could create a life story book to document in detail the story of these children's lives. Not a care plan, which goes on the record and lists placements, or a court order which describes the custodial arrangements, but a book which recorded the main people in that child's life that they could take with them if they were to move from home to home. Together we imagined a treasure trove of photos of whānau members, of memories, the story behind my name, the day I was born, my first smile, my first laugh, foods I loved, my first footprint. That book was called Taku Waka Pā Kākono, My Vessel of New Beginnings. Change can happen. It can happen quickly when there's a will. All it took was leadership to act, to place the interests of children in the context of their whānau. It represented all that I had hopes for when I accepted the invitation to be on the expert panel and later the Māori Design Group, from Te Mura o Te Ahi to Taka Waka Pā Kākono. That every child had the right to be cherished in the essence of who they are, for their stories to be known, their champions talked about, that every whānau is embraced for their potential, celebrated for their strengths, believed in, supported to take up the greatest opportunity possible to raise their children in love, that loving arms are wrapped around our most vulnerable. That life story book began with a karakia written by Paulette Tamati Elif and Amelia Sterling, which likened the process of birthing to the swelling, breaking and crashing of waves. What we have seen in the evolution of child welfare systems in Aotearoa has been like that cycle of waves. At times we tread water, at others it feels like a virtual tsunami of headlines that erode our hope, that cause us to wonder how far we as a society have come. Puao Te Atatu emerged in 1988 and gave resounding hope that the Māori child is not to be viewed in isolation. The committee concluded that the technique must be to capitalise on the traditional strengths of the wider group. If it is to get support of the people, it must come back to the whānau base, and when I say that, it must come back with all accountability. They are really important words, the strengths of the wider group, the accountability of the whānau base. Waia Tariana used to talk about her childhood at Pūtiki Pā being likened to being under the supervision of 1,000 pairs of eyes, each of them watching out and over, accountable, devoted to the best interests of the child within the context of the whānau base. The Children, Young Persons and Their Families Act enacted this vision into statute in requiring a Māori child to be seen within whānau hapu and iwi. It challenged the legislative distancing of Māori from the culture and conventions. Yet 27 years later, when I was on the expert panel, such were the strength of support from social workers for the Daybreak report that almost every hui we went to, they would break into the waiata, anei rā aku ringa. As the judge said before, in a little book packed full of promise, it held great hope. My statement to the tribunal was written out of that hope, a hope that we could get it right for that 7-year-old girl who thought it was her fault she was in care, for the teenager at Korowai Manaki who said all he really wanted was to walk outside on the grass, for the caregivers who told us in the Māori inquiry that they felt that they were being shafted, stonewalled and disrespected. It's like we had to fight or beg for everything. Yet my experience, like our witnesses before me, has been that those waves of despair and promise are swelling, crashing, breaking. I believe the spirit and authority of Puaotearoa is imbued in the current policy and legislation, but the challenge is, how do those words be upheld with resourcing and implementation? There have been too many disappointments along the way. The 5 key themes from Puaotearoa have dominated the last 3 decades: lack of accountability for addressing disparities for Māori, legislative barriers for Māori, insufficient support for tamariki, rangatahi and wānau, inadequate workforce cultural competency, lack of coordination and collaboration. We are still a long way off addressing what the 1988 report put so eloquently, that institutional racism is the outcomes of monocultural institutions which simply ignore and freeze out the cultures of those who do not belong to the majority. I think an example that best represents this is the difference between the interim report of July 2015 of the Expert Advisory Panel and the final report of December 2015. In the July report, the panel adopted 4 paramount principles to design a new operating model. Those 4 principles represented a fundamental shift that heralded a bold approach to design. The 4th of those principles, on page 117 of the interim report, said, make sure the importance of identity, belonging and culture is emphasised throughout the design. The future design must address what children told us, that their sense of identity, belonging and connection to their culture are vital to their well-being. The design work should not treat this as just a standalone work stream, but rather as an integral aspect of the design. Tragically, however, the coupling of the words in that concept, the intimate relationship between identity, belonging and connection to culture, didn't last through to the recommendations of the final report. We hear about a care identity, we hear about respect for culture, but it is couched in the context of what the judge talked about as child rescue. The only time those exact words are stated is in the foreword to the report. At each stage, the emphasis will be on encouraging community-based solutions alongside tailored formal supports to maintain loving relationships and create and retain a sense of identity, connection and belonging. Yet as the Youth Advisory Panel to the 2015 expert panel had told us, identity is not just where the child comes from, it's not just what the culture is, it is everything that makes them who they are. So why is this so important? I think it cuts to the heart of this inquiry. It represents the philosophical disjunct between what some may call the child rescue aspect and mana tamaiti, wakapapa and whanaungatanga. It is that notion of challenging the fact that a child is placed with a mother or placed with a foster caregiver, and then the Western philosophy of attachment and bonding prevents that child being reunited with their wānau. In our report, Ko Te Wā Wakawiti, It's Time for Change, wānau spoke passionately about the changes that are needed to transform their system to a place where tamariki can be truly cared for and protected. In Te Waipounamu, we are told regularly, wānau first every time. Fight against the constraints of a Western attachment theory, hold true to that which is right. And I think back to the inspiration of Professor Sir Mason Dury, who close to 2 decades ago told us that success for a Māori child is not isolated to academic scholarship alone. In Ngā Kāhui Pou, he told us what defines success as Māori. as Māori means being able to have access to te ao Māori, the Māori world, access to language, culture, marae, tikanga and resources. If after 12 or so years of formal education, a Māori child was totally unprepared to interact within te ao Māori, then no matter what else had been learned, education would have been incomplete. This is the contradictions that I think have been coming through today. Our vessel of new beginnings, taku waka pākākano, will always fail to sail, or worse yet sink, if we keep patching it up and pouring resources into the flags and the sails and the paddles without looking deep into the waka itself. What is it that will keep all of our whānau afloat, that will enable them to navigate through life's difficulties and to stay connected, secure, protected and strong? How are we growing their capacity to steer their own waka? What support are we giving whānau to see the snags ahead and navigate a clear path forward? Late March in this year, for our annual Te Pūtaitanga Symposium, which was scheduled for the day that lockdown happened, I had planned to bring to Aotearoa the author of From Pariahs to Partners, How Parents and Their Allies Changed New York City's Child Welfare System. David Tobis nails a simple argument that unless they are in extreme danger, children do better with families than they do in care. In the early 1990s, almost 50,000 children were in New York City's foster care system. In 2012, there were fewer than 14,000. The radical change that occurred was driven largely by a movement of mothers whose children had been placed in care, who fought to become vital stakeholders in a system that had previously viewed them as pariahs. These parents, who had once been at war with the welfare administrators, overcame extraordinary difficulties and took on the system, coaching other parents who were going through what they went through. They became orators and organisers, advocates and activists, how to fight against practices that too often leave families victimised. For me, it was whānau ora in New York clothing. Oranga Tamariki has done some innovative and inspiring investments. It's introduced 32 new kairaranga whānau. In the south, we've seen the value of the partnership with Ngāi Tahu. We have seen significant value from the korimaku training of whānau ora navigators. We are very proud of the developments of Te Kaika in Dunedin and Wakatū Marae in Nelson for Māori to be Section 396 providers for training of caregivers. But there is still a gaping hole in our waka which must be repaired, and that must be in resourcing, investing and believing in the power and potential of whānau. I leave the last word at this point to the final note in the Māori Inquiry, a statement signed up to by our distinguished, dedicated and daring leaders, the ilk of Dame Tariana, Dame Iritana, Ta Mark Solomon, Sir Mason Jury, Dame Naida, Dame Areta, Dame June Marihu, Lady Tureiti, Sir Peter Sharples, Sir Toby Curtis and Meripeka Raukawa Tate. There is a strong economic case to make substantial revolutionary change to the current system. It is time to listen to the voices of whānau.
Thank you for that. I want to move you, before you've addressed the three focus questions that the tribunal has asked to consider, but before we do that, I'll refer you to pages 4 through to 6 of your statement. And in that part of your statement, you talk a bit more about the role of whānau ora and its role in terms of continuing to play a huge role with whānau and uplifting whānau. And then you also talk about the involvement in terms of the proposed bill back in 2017 and work that was done there. So do you want to just, before we move into the first focus question, do you want to just summarise?
Just to give some context to the wakapapa of whānau ora, in 2009 a task force led by Professor Sir Mason Jury travelled Aotearoa with his team looking for solutions to strengthen whānau capability. There were common themes throughout that consultation that whānau told them, particularly the need for whānau ora to demonstrate a Māori heart, to ensure local representation and decision-making, minimal bureaucracy, sustainability, adequate resourcing, a research and evaluation component, and quality relationships between whānau providers and iwi. The report concluded, if there is a single conclusion to our deliberations, it is that the potential within whānau has never been greater, and unleashing that potential will not only bring benefits to Māori, but will add greatly to the nation and to the prospects of future generations. It's that passion that my statement is inspired by. It also reiterates the mission of the 9 iwi in Tuai Pounamu who put their hand up to invest in thriving whānau. They wanted to focus on strengths, not to be obsessed with needs and deficits. They told us, don't focus on the status quo, invest resources in those who are struggling, empower whānau to care for their own. And so in the submission in 2017, 3rd of March 17, to the Social Services Select Committee about the coming Oranga Tamariki Bill, we argued for adequate resourcing to provide for guided family decision-making, to invest in whānau contact tracing, to assist whānau to develop a stronger understanding of their own strengths. We said that much had been written about the high levels of re-abuse that occur when children are returned to kin care, but we saw that as entirely unsurprising, given that whānau haven't received the equivalent of professional development, respite care, parenting education, and resources to support them to surround the tamariki with all they need. We endorsed a shift from welfare to wellbeing. We asked that Oranga Tamariki provide for cultural competency as best practice. We noticed the considerable evidence about the importance of adequately funding FGC, and we placed our faith in mana tamaiti, wakapapa, and manaungatanga.
And so moving forward now and come to that first focus question that you've addressed at pages 7 to 10 of your statement. I could just get you to turn there now. And if you could just speak to some of the main points that you want to highlight there.
I think that no matter how strong the policy and the legislative context is, it's a bit like the book that I referred to that Hannah took up, it isn't until you have the principles and commitment of individuals to keep focused on leadership that change can happen. And I do want to acknowledge the role of the Māori Party in advocating for the introduction of Section 7AA. It was a great honour to work alongside Horiana Irwin Easthope and Tania Williams-Blythe as we tried to put together Section 7AA to try to articulate a gold standard which would be essentially about letting whānau design their own answers. Having an independent Māori voice in policy terms is vital to ensure that that legislation was shaped, that a line in the sand is put between goodwill and actual implementation. I think the second point, alongside of Māori leadership in both the policy and political territory, is about the value of precedent. In 2019, Kāhui Legal provided a range of Māori Crown partnership models, including Te Awa Tupua, Te Uruwera, the Waikato River, Tūhoe Service Management, Canterbury Earthquake Recovery Authority. It was vital to have those precedents in practice and in legislation because it gave confidence to the prospect of a more treaty-just transformation. I've been particularly impressed by the Tūhoe example, which I put as Appendix 4 in my statement. It sets out clearly the aspiration and the determination of Tūhoe to manage their own affairs to the maximum autonomy possible in the circumstances. And I remember Tamati Kruger once saying, no matter how many, whether you have 2,000 or 5,000 social workers in Oranga Tamariki, Tūhoe has far more because each of our whānau members cares for thousands from beyond them. I want to also, I guess, expand on the issues around leadership and precedent, because in the midst of the expert advisory group history, there was a fierce and personalised battle, which brings to the fore everything we've talked today about contradictions and compromise. It raised issues around credibility, authenticity, voice, authority, integrity, and mandate. You might recall the headlines were rampant: only Māori to represent Māori, Māori words not enough for children's welfare. Mihi Ngārangi Forbes had an expose on Native affairs, and the focus was around where is the Māori representation in the panel. The claim was that there was no Māori representation in the expert advisory panel. Of course there was. Former Police Commissioner Mike Bush of Ngaitirangi was one of the foundation members of the panel. However, the focus in that time became on me, including questions on my bloodline. And there were some interesting conversations around what experience I had to be on there to represent Māori, which I wasn't put on there to represent Māori, but that was the nature of the debate. And so before long, Peter Douglas from Ngāti Maniapoto and Ngaitahu was appointed on that panel to address the lack of Māori representation. I think it's a really important point in our evolution because it was a debate around DNA and individuals, more so than around kaupapa Māori and philosophies. And I think as individuals on the panel, Mike, Pete and I had different views about the importance of identity, connection and belonging to the well-being of Tamariki Mokopuna. There was a definite disjunct between the majority of the panel, 5 members of the panel who focused on safety and a healthy home, and I was putting forward that safety and a healthy child has to be seen in the context of identity, connection and belonging. It's not enough when we talk of Māori representation to just talk about one individual having that take, to talk about Māori bloodlines, to talk about DNA. It has to be about commitment to the kaupapa and tikanga that have shaped our nationhood, that are the foundation upon what we know of as Aotearoa. We have decades of scholarship and a formidable repository of lived experience. We think about people like John Rangihau. In Te Waipounamu, we have an incredible history of mātua wāngai with people like Whaia Marumaru Stirling, Matua Terry Ryan, Whaia Molly Luke, Auntie Kiwa Hutchins, Dame Toa Aroha Rereti Crofts. There's an expansive list of people and experiences which provide us with a knowledge base from which to move forward, and we ignore it at our peril.
Thank you, Helen. I just want to remain in this part of your brief because at page 9, this is probably a good segue into the report, Te Wā Whakawhiti. And just to confirm that you were, Te Pūtahitanga, you were involved in some work into that report. If you could just talk about that a bit more and perhaps also just outline some of those key things that come out of that report.
The chair of our board for Te Pūtahitanga o Te Waipounamu is Mark Solomon, who is also a member of the Māori Inquiry Governance Group, chaired by Dame Nada Glavish. Our research team, led by Dr. Golda Verona, convened South Island-wide regional hui. Over 100 wānau members attended those hui in Murihiku, Otapoti, Ototahi, Te Taipotini, Wakatu and Wairau. We had in-depth interviews to supplement an expensive survey. I think the themes that came out are very clearly about the voices of all of those who are impacted by the system of care. We hear from pā morihu, those who were taken into state care as tamariki. They talked about the impact of being in care, anxiety, depression. After years of abuse between the ages of 3 and 15 into every home that she went to, we heard the story of Atawhai, whose lived experience made her determined that her son wouldn't be removed for her. She became a resource much like the New York scenario for her community. We heard about a link in whakapapa being lost when a child is uplifted, about siblings being split and being marked for life. We heard from Pa wānau, those directly affected by the removal of their children. Those stories around cop cars outside the house, the heavy-handedness of the police, the mistreatment of a son in care and his subsequent suicide. 1,000 pages on file around sexual abuse, about running away. We heard from Pa Wāngai, those who are wānau caregivers, who said there was one of the participants, Matua, who said, when talking about the care of his mokopuna, it doesn't require a lot. It's all the direct questioning instead of making a connection first, the relationship. We heard from Pa Kaitiaki, Pa Kaiarahi, Pa Rongoa, the stakeholders who surround wānau, those who are leaders, who are social workers, who are health professionals, who are practitioners. I think it was referred to before about Matua Oranga and Dame Anne Herkis, and I want to really emphasise that in Christchurch, simply because funding dropped or stopped for Matua Oranga, it didn't stop the practice, and that to this day you could ring up Auntie Kiwa or Tau Aroha, and they'd know the homes to go to, they'd know the people to talk to, because such is the commitment to that concept. So it is still very alive and well.
And thank you for that again. I just, let's move forward and come to the second focus question. So really this is about the changes, you've talked about whānau Order's involvement there in terms of the bill, but the changes from 2017 and reducing that disparity. So you've outlined in your brief, you've touched on and talked about strategic partnerships or agreements, in particular with Ngāi Tahu and Te Pūtahitanga. Would you like to outline some of that for the tribunal?
Yep. The strategic partnership is with Ngāi Tahu, not with Te Pūtahitanga, but it was the first iwi to sign up to a strategic partnership, and so I have been very optimistic about what might be able to be achieved with that. I think back to what we defined strategic partnerships in the Expert Advisory Panel report. We talked about joint planning and mutual trust, clear governance processes, transparent performance metrics, reporting, collaborative risk management, issues resolution, multi-tiered relationships, information exchange. So it was very explicit that it would be a meaningful relationship. There has been some investment within the Whānau Order Commissioning Agency. I think the North Island Commissioning Agency has a strategic partnership. We have had some funding to support an initiative called Mokopuna Ora, which is about supporting whānau to decide what it is that they want in order to keep their children safe and happy. That might be gaining driver's licences or early childhood qualifications. They are designing their own dream. They didn't need the language of co-design. They created a context for every child to thrive, whether it's Te Horapa in Canvastown, in Nōku Te Ao in Christchurch, or with Awarua Whānau in Bluff. We've received investment for one FTE, a Whānau Ora social worker, who is an amazing social worker, Mamairoa Nata Stevens. She's based at the Christchurch East site, but I'd have to qualify that with one social worker navigator, and we have 100 navigators, and of course there are many more thousands of social workers, so that ratio and that ability for the amazing Mamairoa to be able to affect that change is limited. She has credibility amongst whānau and the professionals. She's our go-to person, but as powerful as she is one amongst a sea of social workers, and what we need is a sea change. I think the focus that I'm most determined to get across today is a shift from services and programs, from intervention pilots and service prototypes to investing directly in whānau if we are to achieve the Section 7AA vision. There are still far too many non-kin placements, despite the partnership, despite the pilots. I'm very hopeful in Dunedin for the promise of Te Aki Taoka, which prioritises a state of living, mata ora. It's the first iwi Section 396 provider in Te Waipounamu. And for a number of years, we had no Māori or iwi Section 396 providers in Te Waipounamu, which was a significant issue for whānau caregivers. Donna Matahaere Atariki has been a driving influence in Te Kaika, and it has been about that village of care, building relationships, providing care and necessity, support, skills and knowledge. It is about that notion of it takes a village to raise a child. But I guess for me, the key issues is that while there are some starting waves of optimism, we need to be vigilant. It is vital that the annual report is scrutinised by all. It is vital that the independent monitoring holds the agency to account. And one good site doesn't abdicate the responsibilities of all.
And I think that's another good segue into the final part of your report, where you just do address the third focus question, which is really forward-thinking and what, if any, changes in terms of legislation, policy and practice. Do you just want to talk about, maybe summarise the main points that you want to make there?
The most important thing which has come out of the Māori inquiry, one of the themes, is around tino rangatiratanga solutions, that whānau with lived experience need to drive the solutions collectively with whānau hapu and iwi. In Te Waipounamu at our hui, navigators were described as a reliable source of wraparound support. Whānau told us, you don't have to struggle to explain to them, you don't feel judged. The mana of your whānau, they remind you of it, and you don't feel ashamed. Another one said that whānau ora navigator has helped our whānau to get our tamariki back. They said that she had knowledge of the system, Oranga tamariki and family court, but I think it's because she had knowledge of our whānau. Another kaumātua revealed that he spent the best part of his lifetime helping whānau who wanted to know about their wakapapa, because he knew that their well-being depended on being connected to their people and their land. The issues around permanent orders, the fact that the majority of Tamariki Māori, the majority of Tamariki affected by permanent orders are Tamariki Māori, is a significant concern. The same with special guardianship. That there are 35% of the placements up till November 2019 were with non-whānau and 13% with other, which is undefined. We have to, I guess court orders can be seen as granting ownership, and it's really important that we don't privilege that over that connection to mana tamaiti wakapapa and manaungatanga. I am heartened by the mana tamaiti principles, that there's whānau hapu and iwi participation in decision making, preventing entry into care, preferencing placements with whānau hapu or iwi, and identity connection and belonging, as well as returning home or transitioning into the community. That translates into the Māori cultural framework, which has mana tamaiti, manaakitanga, wakamana tangata, mana whenua, mana motuhake as part of the framework for the organisation. And every paper that goes to the Māori Design Group has to be assessed against those 5 standards, that we uphold and protect Māori rights and interests, we hear and act on the voices of Māori, we ensure equity, be reducing disparities for tamariki Māori, we have regard to mana tamaiti, wakapapa and whanaungatanga, and we value the Māori evidence base. The fact that those principles are used as a gauge for whether the paper will succeed and go through to the group, I think is really important, because many of them can be turned back.
And so we've just got a few minutes before we head into the afternoon adjournment, but maybe before I hand you over to the panel for any questions, are there any final remarks that you want to leave us with?
I said in my statement that for my partner and I, our children are the greatest blessings of our life. From our first baby born, we have prioritised their wakapapa as Ngāti Rangi, as the wakapapa that connects us all. My partner and our 4 babies are Uri, I had the privilege of carrying and giving birth to one of those. We wanted our children to know by name their cousins, their aunties, the tributaries of their awa, the reverence for koro ruapehu. We felt keenly our responsibility and our obligation to connect them to the essence of their heartbeat, to sing their waiata, to know they will always be linked to home at the karakia of the 7 o'clocks. We know too that despite our passion and our dedication, there will still be connections that aren't as strong, whakapapa not as well known, relationships not yet developed that they have an inherent right to. When I have seen their disappointment or the disconnection to those whom they have a genealogical birthright to, I have shared their pain, their vulnerability in ways which cut deep. But the answer, every answer, lies not in linking them into an intensive intervention pilot or to a social worker or to Voices Wakarongo or to a memorandum of understanding. All of those initiatives, no matter how significant, are but a substitute for the greatest solution of all, which is wānau. Tariana used to have a simple saying that hung in her office, wānau, we may not have it all together, but together we have it all. Our reason for being, our purpose and priority, our buffer against adversity, our platform for aspiration and hope, the source of our greatest anxieties, but also the foundation and promise for our future. We must not let wānau wait any longer for solutions that are within their own making, to be born of, to be part of a common thread that binds them to a grand whakapapa together. That continuum of whakapapa is perpetually linked to mana tūpuna, mana whenua and mātauranga. Let us steer our own waka with the support of wānau ora navigators to help us when we're stuck, with the inspiration and the healing power of wānau around us, of aunties and uncles to guide us or growl us, of nannies and korals to love unconditionally, to show us the way, of nieces and nephews, mokopuna, to give us multiple reasons to believe in the possibility of and potential for every child. What we need most is investment in wānau themselves. It is everything we could hope for to embark in the right way in taku waka pā kākono, our vessel of new beginnings.
Tēnā koe, is it Mrs. Lay?
Lay.
Tēnā koe, thank you for your evidence. I'm going to hand over to my colleague first. Thank you.
Tēnā koe me o kōrero whakamārama kia mātou mo tēnei kaupapa. Thank you very much for walking us through your submission. And a number of my questions have been answered. However, just to be consistent, you may have heard me ask Lady Moxon about the discrepancies in funding, and you have drawn on a quote from Kahurangi Tariana Turia's book around a very long history of discrepancies. In your experience in working with Oranga Tamariki, has that discrepancy changed or is that still continuing?
I would have to say it's still thwarted by some of the barriers of bureaucracy, and that wānau who have an idea about wrapping support around wānau, if they're not an accredited social sector provider, they're not able to access that funding. There are processes by which, if you're recognised as a social service provider, you're first in the queue. But for the 260 wānau entities that we invested into Waipounamu, they're not providers, they're not program deliverers, they are wānau looking after wānau. And it is a significant barrier to be able to invest in their transformation.
So Lady Moxon's made a comment in her brief around the foster parents. Would they be classed in that category?
What we see is a discrepancy between those who are wānau and those who are classified as foster parents. I think one of the issues that, in terms of the training, why we fought for the Section 396 iwi and Māori providers into Waipounamu was that there were whānau caregivers going for the training and being turned off the training. So that's when that happened in 2016, 2017. That's when we reached out for the kōremako training for our navigators, and also to try. We initially got some support from Te Rōpū, Āwhina and Porirua to help us pave the way to iwi and Māori providers for caregiver.
I'm just going to jump a little bit to page 15 of your evidence. In there you talk about 60% of all applications for special guardianship are in the South Island, and you make a reference to the strategic partnership with Te Rūnga o Ngaitahu. Just wondering whether within those, the resourcing that goes with processing those, does 60% of that go to the South Island?
I wouldn't think so.
So it's not relative to the number of applications. Would you be able to proffer a comment on how it might be distributed, or?
I think that whole disproportionate overrepresentation of Māori children going into non-kin care, going into special guardianship, going into permanent orders, is an issue that the Māori Design Group has asked for further exploration from Oranga Tamariki. It's also an issue that I had elevated to Te Rūnga o Ngaitahu, so I know that they are also looking at that issue within the context of their strategic partnership, but I don't have an answer.
No, that's Kate's boy. Might save that for next week. Thank you very much. Kia ora.
Kia ora, Anō. The strategic partnership with Te Rūnga o Ngaitahu, can you recall when that was entered into?
I think it was, sorry, it's, July 7th, 2019.
All right.
Well, April 2017. April
2017.
No, sorry, 2019. July 7th, 2019. It took 2 years to get to that point.
All right.
Yeah.
And I have quite a large question, which I'm struggling to reduce to a small question, but it just comes from the fact that you have worn a number of hats, and you have quite extensive experience in seeing various matters operationalised, or the practical rollout of initiatives. And you mentioned a number of them in your discussion with Ms Cassidy, and in your brief, those pilots like Mokopuna Ora and others. So are those examples, have they arisen out of the strategic partnership, or are they?
No, they're whānau order initiatives.
All right.
So since the strategic although the 9 iwi of Te Waipounamu are our stakeholders, that's the reason that we're in existence. Yes. The strategic partnership with Oranga Tamariki is explicit between Ngaitahu and Oranga Tamariki.
All right.
So the Mokopuna Ora are initiatives that we have been able to achieve by knocking on the door of Oranga Tamariki and saying how can we best protect our whānau from their children being speeding off in the speedboat. Yes,
my large question really comes back to your knowledge of and your mahi with the Whānau Ora Commissioning Agency and ko te wā whakawhiti. And looking at the action points at the end of that report, and in particular action points 1 and 3. So action point 1 broadly is supporting whānau, strengthen whānau capability and capacity, and 3 was build on the call from whānau for by Māori, for Māori, with Māori, solutions for long-term sustainability. That's why it's quite a big question, but from what you have seen in Te Waipounamu, interacting with the state agencies and securing funding or resourcing for initiatives that do work, if we're looking to these recommendations in the report and to those kind of action points, and they're quite specific and on a number of fronts, what kind of time frame is, in your view, realistic for implementation? If in an ideal world you could secure the political commitment from government for these principles, and so perhaps just sticking with Te Waipounamu for now, do you have any views on how that might work going forward, and in what kind of time frame, assuming you've got both political commitment and the associated resourcing?
So just a preamble to that response. We are absolutely, there are multiple authors, of course, to the Māori inquiry. The first recommendation around building the capacity and strengthening the ability of whānau to be self-determining, we're totally in support of. Our focus as a commissioning agency is, however, about whānau determined, whānau centred, more than it is about Māori providers organisations. And so we don't use the phrase by Māori for Māori because our whole focus is on whānau. In terms of how long that might take, in the book Crossing the Floor about Whaia Tariana, she refers to an example with Matu Rata at the early days of looking at could a Waitangi tribunal be established in 1975, and scores of lawyers were saying here are the impediments by which this cannot happen, and he stamped the table and said find a way, and it happened. And so I think, in answer, Sir, to your question, we find a way. We can invest in whānau this afternoon. They are not constricted by tiers of bureaucracy, and there are multiple opportunities for whānau transformation to be resourced if only there are eyes to see that and ears to hear what whānau bring to the table. And so that's the great test and opportunity for whānau ora. We've been 10 years in existence. When will the nation be ready to place faith in whānau to be able to determine their own solutions and create the loving, stable homes couched in a context of identity, connection and belonging that all of us want?
Thank you. And thank you for your evidence, and thank you also, I just acknowledge also Dame Tariana and those here in support of you, and for all the mahi you have done over many years in various capacities. So we might just break, because I know it's been quite a long session and a long day. We'll take a short break. Mr. Benyon, did you have, you had a few minutes, I think you indicated, for questions?
Perhaps one question, but very little, I would have thought.
All right. And Ms. Hardy?
No, thank you, Judge.
All right. Actually, we might just go to Mr. Benyon so you can relax.
Thank you. Thank you very much for your evidence and all the roles that you've filled with. I see Dame Tariana, of course, tēnā koe, tēnā koutou, tēnā kōrua. The question I had was just around your strategic engagement initiatives with iwi, and it was really about the fact that I see at page 15 of your evidence, you've got a statement there, 60% of all applications for special partnership are in this guardianship are in the South Island. Your strategic partnership happened on November 2018, so do I take it you're still at the beginning of addressing some of these concerns, or has this special guardianship issues rolled out and been a problem even though you're in the strategic, or you've been working hard on engagement with Oranga Tamariki?
So these applications are not specific to Ngāi Tahu. So Ngāi Tahu is of course a significant iwi within Te Waipounamu, around 35% of the Māori living within Te Waipounamu. There are the other 8 iwi who hold mana whenua status, and of course Mātai Waka. We are working with all in terms of the context of whānau ora, but the answer is that even with the strategic partnership with Ngāi Tahu, even with the commitments that we've been making, there is this disproportionate overrepresentation of Māori in permanent orders in the South Island, which we're asking the question as to why that's happening. We have an excellent working relationship with the Christchurch East site that is involved in the intensive intervention. Very good work happening in Blenheim, in Te Kaika and Dunedin. But what about all of those other sites in the South Island, and what's the history and the experience there?
All right, and just two other quick matters. One is the all of the strategies and ideas for consideration on pages 18 and 19. I take it that all of those are doable within the current system. It would just, there's nothing, no legislation required. They could all actually be rolled out now.
Yes.
And I was wondering about your first one. Fortnightly monitoring by the office should be reported to a Māori design group, just to spot what's coming up between the offices. Do you think something like that, if it had been in place, might have alerted us to the growth in Pepe being taken into care in the last few years?
I think so, if there'd been a closer monitoring right from the onset of the Māori design group.
And do you know if any Oranga Tamariki officers have had these strategies in place in the past?
I don't know that, sorry.
Okay. And just, sorry, lastly, on this strategic engagement with iwi authorities, does that suggest there might be some disparity in areas where iwi are not settled and don't have the iwi authority capacity to bring to strategic engagement?
I think
Are we going to get some unevenness because of that?
I think definitely. Those who are in strategic partnerships will have an advantaged relationship with Oranga Tamariki. Those who are not in settlement or those who aren't in a strategic partnership don't have that same status. So there will be different levels of a relationship with Oranga Tamariki depending on the nature of your engagement.
And do you know if anyone's done any study or thought about, have you seen any stats on orders or orders taking children in areas where there are iwi authorities versus areas where there are not?
I haven't seen that.
Okay, thank you, that's all I had.
Thank you, Mr. Benyon. Thank you, Mrs. Lay. Thank you very much. We'll break now for 20 minutes, so a little bit after past. Kia ora, anō koutou. Like you all, we have noticed it slowly getting hotter and hotter. So if our council, our guests, witnesses wish to disrobe in some form, go ahead. All right. Mr. Benyon.
Yes, thank you, sir. Just before I set off with Mr. Cook, I did notice this morning that when I introduced myself, I failed to also note that my junior, Miss Davidson, the hardest working junior you can imagine, is behind me, and my apologies for not introducing her.
All right. Thank you, Mr. Benyon.
So, Mr. Len Cook is the next witness, and just to note that he provided an original affidavit, A17, but you have in front of you now A40, which is his brief, which attaches 2 papers that he's prepared, research papers. That's A40A, and you should also have in front of you A40B, which are summary notes which he provided yesterday, and I understand hard copies were provided to the registrar this morning.
Mr. Benyon, just to clarify, we have the speaking notes before us. The supporting papers, are they that you're referring to, are they the supporting papers attached to the last brief, Mr. Cook?
Yes,
All right, yes, we have those. Thank you.
Yes, that's A40A, I think, and there's 2 papers part of that. So, Mr. Cook, if you would come to the stand and just so you confirm you've prepared those pieces of evidence for the tribunal? Yes. Okay. Now, if you just present your summary, and I understand you're going to, rather than just read through that summary, you're actually going to speak to it. Is that correct? Yes.
My brief is primarily about District of Maori, so they will have a bit of a chilling effect, Mr. Chairman, on the heat that you've got. I guess what the 2 papers I produced, one is essentially a history of Maori and the justice system from 1860 to the present time. And the second is one which draws a little bit more on my experience in public administration, where I've got the temerity to write a little bit about accountability and legitimacy of a public agency. Can I say my background is I'm a statistician. I have been the head of the statistical offices of both New Zealand and the United Kingdom. I was a member of the Royal Commission on Social Policy, where I worked with Professor Mason Dury. I bet my last role is, in fact, chairman of the board of Subaru, the Families Commission, where I had the pleasure of working for 4 years with Kaharangi Tariana Turia. I've also been involved quite a bit in various aspects of Maori statistics over 30 or so years. Can I say, I guess one of the most important conclusions I want to make, which challenges, takes a comment from Judge Beecroft when he made a comment that past is a most important guide. Well, I would argue that for Maori, in fact, the dynamics of the Maori population over the last 150 years means that each cohort has to be treated quite differently. If you think about it, in 1890, the Maori population had 40,000 people, and it was its lowest point. And that was when my grandfathers, by the way, were born. The Maori population in 1920 had grown to 50,000, and that was the beginning of a huge demographic dynamism in terms of growth, fertility, and periods when mortality rates began to decline. When I was born in 1949, I was the start of the birth of the largest cohort that Maori have seen in births. That cohort of school children that finished being born in around 1966 was twice the size of any other cohort. Because of urban migration, 4 times as many Maori children were in urban centres of New Zealand than we'd ever seen. And at the same time, the Maori age distribution had changed so much that that cohort in 1966 of children under 15 was half the Maori population. And I guess I make those point that those 4 elements of where did you live and movement, the age mix, the volume and the growth are all in each decade of Maori have been differently very important. And the critical thing, I think, is that for that cohort of children born from 1960, late 50s onwards, they experienced the largest amount of institutionalisation in the custody of the state of any age group of Maori. There's one minor exception, which is 20 to 25-year-old Maori males in the mid-1970s. But that particular cohort, and I make that point because it's so big compared to other cohorts, at every stage in its later life, as it's gone through schooling, work, it has actually challenged, when there have been institutions that have had to relate to it, its capacity to deal with it. And of course, if I just focus for a little bit on the extent on the prison system, for example, there has been some people who make the observation that it was the urbanisation of Maori that led to its connection with the justice system. Could I make the point that between 1961 and 81, the rate of imprisonment of Maori adult males never changed? That if you take the imprisonment of Maori males aged 40 and over, between 1956 and 1996, it never changed. It was only when the cohort that we institutionalised so much reached the age of 40 that we actually saw that. I guess I just want to make the point that in many ways, for Maori children, their institutionalisation is almost more dependent on their birth year than their behaviour. And so as I make the point, every cohort needs to be seen as a little different. What I have done in my substantive paper, the one that is headed, if I can, that's about the connection of Maori and the justice system, I've charted each of about 20 periods where the connection between Maori demographic change and the justice system or the child protection system has had an effect on Maori. One point, if I would like to make, is that some of the first information we've had about the connection of Maori children and the child welfare system actually only arose 15 years after the Child Welfare Act of 1925 and 1940, where one study by an academic allowed to have access to the child welfare data just pointed out that we were taking roughly 4 times as many Maori children at each age in front of the children's court as we were non-Maori. In 1967, the Child Welfare Division then started a survey. They surveyed every boy born in New Zealand, born in 1957 until they were aged 24. And that was where we have very, very rich statistics that we don't have now on the engagement of Maori with the welfare system. For example, basically 1 in 14 Maori boys were in the care of the state, and that can be anything from a open institution through to Borstal. We use Borstal detention centres as places as well. I think 400 kids under 16 were in those places at their peak. That rate, about 1 in 100 Pākehā boys and about 2 in 100 Maori girls around that time. And we've got excellent statistics on the entrance to the children's court each year from the 1950s right through to the 1980s. So we have got really quite excellent information on those disproportionalities. One thing we do know, sir, is that when a child came before the children's court, if they were non-Maori, 10% were given a custodial sentence. If they were Maori, the children's court, 20% of them were given a custodial sentence. And the Hun report, which, while it is criticised in a number of aspects by Maori in particular, actually has one of the richest analyses of the statistical position of Maori from the 1930s to the 1950s, and it itself also identifies more richly areas where disproportionality existed in the justice system. Can I talk just a little bit of the issues of administrative counts? A lot of my initial submission was on the counts presented originally by Oranga Tamariki. And that was the prime source of their evidence, you might recall, as to whether, in fact, this tribunal should be interested in Maori. I'd like to make the point that, in fact, counts, administrative counts, actually primarily tell us about institutional workloads. After all, and as do the courts, counts of people in prison or the people coming through courts, to have an understanding of how the people involved in these counts are connected, it's important to relate this information to the demographic position, the age distributions and Maori populations at the time that they are in these institutions. Unless you relate them back to the base populations, then you don't have a sense of any element of proportionality. And by proportionality, I mean the share that is Maori versus non-Maori, or if one takes the Maori population alone, the share of it which is in that particular institution, so that you might judge whether that share itself is in excess. For example, right now, 1 in 64 Maori children, 16 and under, are in the care and custody of Oranga Tamariki. 1 in 400 non-Maori children, and if you leave aside whether you are interested in non-Maori children, the question you might have is 1 in 64 more than you would want to have. We can also measure disproportionality by a concept of an excess. If we took the non-Maori age distribution in terms of, say, imprisonment or institutionalised and child welfare, if we applied that to Maori, how many extra people in that institution? So when I make that calculation for, say, the prison system, I find that there are 5,200 extra Maori males who are in prison for 3 months or more on remand or sentenced than there would be if Maori had the same age distribution, if the imprisonment rates at the same age applied to Maori. So I guess I'm making the point that measures of proportionality, there's a variety of them, and if you might be interested in the proportion which is Maori compared to non-Maori, you might be interested in the extent to which you are happy with the proportion of the Maori population in itself which is in that particular condition. And I guess I partly make that point because if we look at the most significant change that we've ever had in the institutionalisation of Maori in the care of the state, that followed Poati Atatu. In 1987, we had about 5,800 children in institutions. At the peak, a few years before that, there were 7,200. And as I say, the share of Maori were about 7 times higher, about 1 in 14 Maori boys. After Poati Atatu, the number of children in the care of the state went down to about 2,800 by the mid-1990s, according to the yearbook. It's very hard to find these figures. And we know from one study that existed about 1997 that the share of the proportionality of Maori to non-Maori went down to about 2.2 from 7. So Poati Atatu and the arrival of the Children and Young Persons legislation had quite a dramatic effect, not only on the number of children in care, but on proportionality. And it's only when you start looking at the statistics from about 2006-07 that you see that position that was reached in 1989-90 being reversed. If I can add a couple of little comments. Earlier on it was suggested has the balance of why people come into care changed. In reading carefully the social welfare study or the child welfare study of children born in 1957, and that probably represents well that whole cluster until the late 80s, children tended to come into care overwhelmingly because of their own perceived delinquency. And what was interesting, by the way, Maori boys came into care generally at age 13 and 14, and non-Maori boys at age 16. So the mix of children that we took into care was generally younger Maori boys who probably had a lower threshold of, I'm not sure whether badness is a judicial term, but bad madness compared to the Maori boys. Since about 2004, we've seen not only a remarkably sharp rise in notifications to MSD from the public, this I think was stimulated by some moves by the ministers on the day. We've also seen from analysis by the Treasury when they've looked at births born since every year since 1991, that the number of babies who have come to the attention of of the child welfare services at that time, whichever one it was, has increased from about 3 or 4% in 1991 to well over 20% by the time the last figure I saw was about 2008, 9 or 10, and that was about 20%. So there's a continued ratcheting up of the observation in the system of coming to care. And the third thing which I sort of have absolutely no knowledge of the justice system or the law, but if I can say, there is a piece of the law which is offences against the administration of justice, where from around 2002, the number of Maori women between 20 and 30 who went into prison for those offences started increasing by an extra 50 to 60 a year every year. So we did something in the administration of justice around that time. So there are some, these are just sort of things, as a statistician, can I say, there are more things around the edge that when you put them together, they indicate that someone should do some serious work looking at it rather than come to any serious conclusion. But I would say that there is enough there to think that there is something in the way in which the system has shifted how it operates. Can I make another point on the statistics used by Oranga Tamariki? Since 2017, Oranga Tamariki has produced its statistics based on entries to care. Until 2017, MSD and all its predecessors made its prime statistic the number of children in care. So one you might imagine, if you're an economist, is a stock and the other is a flow. At neither time do we actually get to see the exits. And I would argue that if you want to understand the administrative process, you actually need both. Because it may well be, although children are reducing coming into care, that they are actually staying in care longer. The second thing, which is an interesting question, is that although the focus of this tribunal is on babies, what is interesting in the last couple of years, the number of children 14 and over who are being taken into care has reduced significantly. And I guess the Children's Court...
Sorry, Mr. Cook, I'll just intervene there just to correct you. Our focus, the Children's Commissioner's report is focused on pepe or babies, whereas our brief is a little wider on Tamariki Māori, which would include, so just if it helps.
Right, thank you.
You can refer to those older cohorts as well, because that is within our scope. Thank you.
Well, the tribunal may be interested in what has happened to why are we taking less interest in 14 to 16-year-olds when I think most people who are a parent or grandparent would suggest that 14 to 16-year-olds now have not dramatically become better than they were a decade ago. That's a little thought. The analysis based on disproportionality, I think, has some limitations in that as we get quite low numbers of non-Māori coming into care, and we have seen a decline in the incidence of both Māori and non-Māori coming into care. In fact, disproportionality can have increased and disparities can have increased, even though there is actually a decline in the incidence for Māori of coming into care. And that's why I guess I make the point that one needs to look at proportionality as also being the proportions. Are you concerned with the actual, from a point of view of Māori, is the proportion of Māori actually, is the number coming into care in itself of concern as much as the relationship with non-Māori. I did mention, the one thing I possibly missed in talking about the 1940s is that the same study done by Phillips for the Institute, the Council for Education Research, it was preceded by another study by the Council for Education Research in 1940, which found that there were no Maori among the 2,500 children in the children's homes run by religions. In that report, it makes great note of the point that up to that time, it was believed that Maori children who were otherwise in those places were looked after by whānau. So both those reports are quite interesting in the sense that they paint a picture before the urbanisation of Maori was very strong, and they indicate to you the connection with the state.
Sorry to interrupt you again, Mr. Cook, but just before you leave that point, could you just clarify that last point on the religious institutions? There were no Māori in
1940,
yes.
There were 2,500 kids in institutions, both such as run by the churches. 7 of the large establishments were surveyed by this guy Matthews, and of those 2,500, there were no Maori reported to be in those institutions.
And then you went on to say, because it was assumed that those...
The report states that it was, the writer of the report says that he understood that Maori children were looked after within their whānau.
All right, I'm with you. Yeah. Thank you.
I guess one of the ironies of this extraordinary change in 1989 is that we've got almost no data in the following 10 years about what happened. The computer systems of the Ministry of Social Development sort of started to blossom in the late 1990s. But although we had this extraordinary change, and we can see it in the gross numbers, we know very little about the actual shift except from 1 or 2 periods of how much that affected Maori and non-Maori. And I think this is a real frailty of the information system that you've got, even for this tribunal, because here you've got an extraordinary change of the sort that Judge Beecroft was talking about as possible, and yet we never bothered to learn from it. In fact, if I can be slightly cheeky, I would say the analysis by the state generally in almost all its areas of the justice system is far richer before the late 80s as it has been since. And this is an important point. And I think if I can say what the disproportionality I'm talking about in a group, rather than statistically or in comparison, that's when you might see it in a wider political and cultural context as arising when the number in a group or a share of that group experience a situation that's focused on individuals, but it actually causes the group itself to experience something that changes the group itself. And I think that's an element of disproportionality that may in fact be more important to you than the mechanical measures of disparity, which I myself have given to you, or that you've received from both the Children's Commissioner's Office and Oranga Tamariki. Because it certainly, that is the dimension of disproportionality that I would have to say must have, and Donna Hall will know more than I would, the Rangiho report, because the disproportionality that it faced had been there for 40 years. I think also it's interesting why it's important to look at that overall level. There are times, and you might recall the Honourable Bill English made a point that there are times when what we do to a population is a moral and fiscal failure. And I think there are times when we should take the rate of what we're doing for Maori, such as say 1 in 64 in care, and if 1 in 64 of the total population of children were in the care of the state, firstly, could we afford it? And secondly, morally, would we want that to happen? And so I think one of the other judgments that you might want to look at is, were Maori the whole population, then would you want this to happen? If I might comment a little bit on the area where I was displayed a little bit of temerity in writing about legitimacy, I one concern I have, and I think it comes through a little bit in the collection of children's commissioners that we've had, is that the establishment of Oranga Tamariki, and Helen Lay referred to that one of the intentions was to be a loving place for children. With the utmost of respect to everyone, I don't think the state is a hell of a good place to be loving. And in fact, I think it might have been better if Oranga Tamariki had been set up acknowledging that for the state to be a parent, it's the hardest job it will ever take on. And if it's the hardest job for the state to take on, it therefore means its means of accountability and legitimacy have to be much more robust, much more demanding, much more intrusive on the agency than almost any other area of government. In fact, in my paper, headed Accountability and Legitimacy, I would suggest that Oranga Tamariki hasn't yet crossed the threshold of being third grade at that yet. The fact it never published any official statistics on what it's doing for 2 years, and the only information we got out of it was by Official Information Act inquiries by Emily Cadell from the University of Otago, is not a great sign. There are many other areas where it simply hasn't yet delivered on the forms of accountability that we would expect it to have, and even the forms of accountability that its predecessors had. I think that with that sort of really tough role, I think we would then be much more honest that the outcomes of the organisation won't always be positive, and that there will be times, of course, the other time when a life might be saved. And I think not only the staff of Oranga Tamariki, but the public at large must be able to own what is done by the organisation and how it is done. And I think legitimacy is actually much more difficult to demonstrate than accountability. For public service, accountability is dominated by a focus on cost efficiency, with less focus on the way citizens are dealt with. But legitimacy requires trustworthiness to be in practice, and particularly for independent third parties. Legitimacy that cannot be demonstrated by independent third parties or by processes established by independent third parties will not actually stand up to the test of public oversight. So I think that's and this includes the science behind practices. And you're possibly aware that one of our most distinguished, an older statesman, someone who I think does meet Judge Beecroft's version of ageing, and since I'm older than the judge, I took slight umbrage at his definition, that Professor Taylor has written a wonderful book on 60 years of child welfare, the science behind child welfare, right from the time when we started electrocuting kids, right through, and just a reminder that the science and received wisdoms of what we do with children can be quite variable. For example, we're all aware that between the late 1940s and the early 1970s, 87,000 babies were put into closed adoption, and a huge majority of them were children taken under, shall we say, some sense of obligation from teenage mothers. Because, of course, in those days there was no such concept of a solo parent except in very rare situations, and it might have been as a consequence. So 87,000 babies were taken. In the peak year, there was roughly 4,000, but on average there were 2,500 babies taken a year for 35 years. Now that was 5%. So 5% of babies born for 35 years were taken by the state. This was done with the connivance of the churches, who generally, for example, I know if you're a girl in Dunedin, you went up to Bethany, not because I'd contributed to that, but there was a whole series of places that were known where people went to. So, and the interesting thing from a point of view of Maori is that often the birth certificate, if it were a Maori father, was not identified. So the concept of whakapapa was completely removed from those children. The next wave was, of course, started in the late 60s when we institutionalised the number of kids we did. We didn't, of course, just do it to children, as you'll probably know. We took people into mental institutions. We had an enthusiasm of the state to institutionalise our population. And that really shifted. It took till the late 80s before we shifted it. But again, that institutionalisation in particular, as I've discussed before, had a huge impact on Māori, because it came at a time when you had this amazing demographic bulge. And so that was an important point. I do think that the interaction between the family court and Oranga Tamariki isn't particularly transparent. And yet the family court is a really important leavening influence on what the Oranga Tamariki does. We should surely know about why cases aren't rejected, why not individually, but in summary. We have excellent statisticians in the state, and it should be not beyond them. We have excellent statistics from the district courts. Other courts in New Zealand give us great riches in how they deal with the population, and that is not the same with the family court. It's also to note that the Children's Commissioner, in his first report, was able to produce a range of statistics that might have been considered to be well within the reach of Oranga Tamariki to have produced many, many months before. And I think, again, this is an obligation that an agency has as a state. I took the liberty in my first submission to use the Official Statistics Code of Practice for Official Statistics, the protocols, and analyse how Oranga Tamariki compared in each of about 20 items. Since I introduced the first Code of Practice 25 years ago, I thought I might know a wee bit more about that than most. And to be quite frank, I found them quite seriously wanting. And that's written down and able to be analysed. I don't think it'll excite most people to raise. I think the second thing which the Children's Commissioner did that was immensely important is he raised the visibility of mothers. And given that mothers are part of the transactions of the state with children, again, one would have thought from accountability points of view, we ought to know who are the mothers. This is particularly important for Māori because Māori women tend to have their children about 10 years younger than non-Māori women, than Pākehā women. And therefore, if you have a threshold which both is interested in the age of mother, and given that also if people are going to formalise their unions, they probably tend to do it after they've had children than before, or increasingly these days. So therefore, for simple tests of age of mother and relationship, then Māori women will tend to come up on those tests much more quickly. So it's useful, as I mentioned, that whatever reason that children leave the care of their mothers, where it's the large-scale adoptions, or the enforced taking of babies now, it's important to note that MSD did some excellent work in the 1980s on the impact on mothers' health of being separated from their children. And one of the components that they write in this invaluable study on adoption at that stage, on the large-scale adoption, is that when a mother did not know where her child went to, they, in their international survey, made the point that for many mothers, it was worse than having a child die. And I think there's an element of where the mother, one would expect the mother to be a larger part of that. Can I quote another Children's Commissioner, John Angus, who made an excellent submission to the Productivity Commission, and he made the point that when we think about this relationship between the state and children, the state always tends to think of it as the prime vehicle first. And it tends to forget that for every child that the state takes in the care of children, grandmothers take 2. And if I can remind you that we now have about 29,000 pairs of grandparents who actually look after grandchildren. I think another Children's Commissioner, Russell Wills, noted in his 215 annual report, 250, that in fact he was appalled at the fact that the child welfare agencies at that time had no idea where somewhat over 80% of the state wards went to once they turned 17. Now, not a heck of a lot of parents know absolutely nothing about where 80% of their children go to. Just a final a couple of comments, because I've talked a bit more, Mr. Chairman. I think that the common rules and obligations and tests that are applied to Māori have often been based on analyses from, say, statistical surveys, where Māori are a very small component. We've got very few studies. The Growing Up in New Zealand study in Auckland, for example, has a significant share of Māori in the population, so we can learn in the same way as we can about Pākehā women, their evolution through their first 20 years. The other studies, the Dunedin and Christchurch longitudinal study, have very few Māori in them, so they tell us very little. Many of the surveys that Statistics New Zealand runs don't have a particularly large share of Māori in them to tell us about them. And often, therefore, we're dependent on the knowledge the state has acquired. And so when the state analyses Māori through its own records, we have to remember that it only collects the data that are needed for the administration of its laws. And so what the state collects totally ignores 100 years of social science and other scientific thinking and conceptual thinking about human behaviour and how it should relate. So I guess I just want to make that final point. And to conclude, I guess my comments as a statistics are really reinforcing the point that we cannot understand what is happening with Māori children without understanding the demography, the population, and studies that do not place Māori in each decade in the context of their demographic history and the cohort they're in are really giving us sometimes a little bit of misleading information. Sorry for taking so long, Chairman.
I did think Mr. Cook should just clarify one matter there before we proceed, but because I saw some puzzled looks. Mr. Cook, when you were talking about imprisonment and 5,200 extra Māori males in prison, can you just take us very quickly through that point again?
Okay, there's about 6,200 Māori males currently in the prison system, either for 3 months or longer on remand, or in a sentenced situation. I added remand because, as you know, the period on remand has gone up on average from about 4.5 weeks to 9 weeks in the last 20 years. So remand has become much more of a sort of a home. So if the age-specific imprisonment rates that apply to 20 to 29-year-old Pākehā males, 30 to 39-year-old Pākehā males, 40 to 49-year-old Pākehā males were applied to Māori males, to Māori males that in the total population at the same rate, then instead of having 6,200 Māori males in prison, we'd have about 1,000. So there's an extra 5,200 that have come in because of the different rate of attendance in the court. And we can see over decades how much that 5,200 is made up of different age groups over time, and that shifts. But that's a little more detail than you probably asked for.
Right. Thank you. And you'll have some
I'm sorry
questions.
to try and make statistics exciting at the end of the day.
You've got some questions from the panel.
Thank you.
Tēnā koe. I don't actually really have a question, but I just do have a comment. It probably just comes off something you said. I work in a university and have for the last 25 years. I have never come across anyone quite as enthusiastic as you to describe statistics. So I just want to thank you and really appreciated the papers and submissions you put in, and keep those energy levels up. Kia ora.
Kia ora, thank you. I must agree. I must agree. I'm sorry, I can't find where it is in here now, so I'll just talk to what I was wanting to ask you about, and that's you've made some comment on the state being the parent, and that it's the hardest job it will ever do, and questioned whether or not children come out of state care with the state as their parent, whether or not it's had any benefit for them. So is it possible to work that out? Do we know?
With the databases that government has now been establishing, we can see where children go to. My main focus in the paper I wrote was really looking at the cohorts at large. And when you look at that massive increase that occurred in the 1970s and how it's followed through, it's very clear that taking so many children into the care of the state did not help that cohort as a group at all. It increased their level of later engagement with the justice system quite extraordinarily. And interestingly enough, that's confirmed by you look at the later cohorts. So, for example, the rate of taking into prison of 17 to 19-year-olds and 20 to 25-year-olds has declined quite considerably over the last decade. So those children that would have been born or not taken into care between 1990 and the mid-2000s are actually now showing very, very low rates of imprisonment. Now, these are all cohort, looking at groups as a whole, but that's how I would say is our best evidence. And I think one of the interesting things we have now, as I mentioned, the fact that we're in an unusual situation now, that 1.6%, 1 in 64 children, are currently in the care of the state, which is now higher than the share of Maori males 17 to 19-year-olds in the prison. Now, that's the first time that's happened since the 1970s. So we've got a crossover, and I guess my point would be this is a really important time to try and understand exactly what you're talking about, the connection between being in state care and your later life course, because we've reached a critical point in both the increase in the share of Maori children in the care of the state, leave aside because whether they're staying in there longer or coming in, but they're still there, compared to what has been clearly very effective in other parts of the justice system, and whānau and other, who you actually associate with that, I don't know, maybe there's something in the water for kids when they were born 25 years ago, but something has happened which has led to this really substantial decline, which we need to hold on to. And all I'm saying is, from my observations, at looking at statistical trends, you're at an interesting moment where there's a risk element, and it's a really important time to inquire.
Thank you. Thank you.
Kia ora, Mr. Cook, and thank you also. It's certainly been, well, it is very interesting. So you needn't worry about your topic. But just on that last point, the risk moment you're just describing, could you just elaborate slightly on that? Well, there's two related questions really. So the nature of that, the risk you're describing, and also given the inadequacies in the data collection practices currently, well, that you've observed within Oranga Tamariki, how long, if you tried to move to best practice, or at least to your tier 1 or tier 2 basic statistical requirements, how long would it take to implement that change to produce proper, reliable data on what's happening with Māori cohorts coming into state care?
Mr. Chairman, can I say some of this is simply about a better analysis, richer analysis. And I'm not employed by anyone, and I can produce a more comprehensive analysis than they can. Then, with the resources that Oranga Tamariki has, then the skies are much closer than what I do. That they can do. There's also very rich resources in the interdepartmental data infrastructure that can be deployed. We've started to see some stuff coming out of Oranga Tamariki, and I guess my concern is it could have come out voluntarily a lot earlier. I think also it's, in many ways, organisations produce information because the people at the top are curious. And it's my experience in public sector management is that the curiosity of the people at the top sets the tone for where the people in the organisation, the scientists as it were, have an expectation that they will deliver responses to curious questions. And I think the difficulty when the curiosity comes from outside is institutions, and I've watched it, I mean, I've been in my own institution occasionally has had its moments where people become very defensive and themselves reduce their engagement. And so I think what really part of the process that Oranga Tamariki has to go through is being prepared to be much more richly challenged, even though it is tough if you don't think you're doing the job you think you're meant to do, because it will gain much more out of it. I mean, my experience in New Zealand is that as public servants tend to be not at all as well challenged as they could be, compared to, for example, my life in the United Kingdom, where anything we did had 4 or 5 people pulling it to bits. And I think we need a much richer challenge community. If you look at public health, where we have an extraordinarily rich public health community. So even if the Ministry of Health gets rid of all its epidemiologists, as it did, we're still saved with the COVID-19 crisis because we've got rich academics. We're not really in the same situation in the justice sector where we don't have a rich, we've got a few people like Emily Cadell and a number of others who are make amazing contributions, but we need a richer outside community as inside. But to do that, these agencies have to themselves do research. And the model that Oranga Tamariki's predecessors had in the 60s, 70s and 80s was almost world leading, and we have lost that. They should be pushed into getting back there again.
All right. So at your February affidavit, you talk about the data that you were able to get from Oranga Tamariki wouldn't have met the basic requirements of Tier 1 stats. But yes. You're just saying a moment ago that, and that came out through OAA or
yes.
reluctantly, but you said deeper analysis or analysis could be done. So have we got 2 separate issues here? One is the quality of the data gathered and kept, and the second one is a transparency problem because it's not what such data as there is not being made available in a form or at all unless to external parties or unless under OAA or as a result of government request or inquiry.
Well, given that the history of the organisation was a focus on children, I suggest it hasn't yet geared up its systems to tell us as much as is needed now about mothers, given that they have become a focus of the activities that Oranga Tamariki initiate. And that should be much more visible. As I mentioned, we should know the demography, the ethnicity of mothers.
Right. And do you, as far as you understand, we don't know because that data is not being collected or it's not being disclosed?
Sometimes it is collected on case notes, but not aggregated in the systems that the organisation has. I can't tell you precisely why particular things aren't measured. I do know that the Children's Commissioner, for example, has produced some data. For example, they produced some information about the share of mothers who had their children removed as babies who had had previous connections with Oranga Tamariki. I think the figure was about somewhat over 40% for Maori mothers and 32% for non-Maori mothers. Yes. Both figures are obviously very high. So that came out, I think, out of a specific study. But it's the systematisation of a collection of a more comprehensive lot of information that the organisation clearly needs to do. But secondly, it needs to use better the information it already has access to.
All right.
And then thirdly, it needs to analyse it more usefully for people that deal with it.
All right, thank you. You also referred to the, I think you used the word opaque, the relationship between Oranga Tamariki and its processes and the family court and the outcomes in the family court. And you said that I think that better information and there was better quality information and data available from other parts of the district court, or the district court more generally, but not the family court. Do you know why that is so?
No, I suppose you could presume that the nature of confidentiality of the transactions of the family court leads it to have a different view of what it can present than the district court. That would be the only reason I would speculate. But that shouldn't stop the court producing aggregate statistics.
That's my question, so the outcomes or the nature of the applications and the outcomes of the applications, anonymised, shouldn't be an issue, should it?
No.
And ethnicity, also in aggregate terms, shouldn't be an issue either, should it?
No.
No. And do you know, I don't know whether you do, but do you know whether equivalent data is being collected through the family court as with its the other branches of the district court?
No, I don't.
All right. You made what I think is quite an important point about legitimacy and accountability and the different kind of lens you'd bring to each of those questions. So if we're looking at, say, legitimacy as a question in relation to the uplift or the taking of particularly of babies into Māori babies into state care, we had some discussion this morning about the primacy given to what's been loosely called a rescue model, so intervention, and the assumption appears to be that the outcomes for that baby are going to be better because it's saved from, as I think Ms. Williams-Blythe put it, you've cut out the problem, which is the whānau. That's the approach. But as far as we understand, no measurement of the outcomes for those children is done in terms of the outcomes, or no data is collected about whether they do in fact do better under state care. Is that correct in your understanding?
As I understand it, yes. And can I add to that point? Unless we do that, this system will be driven by two types of extreme events, where, for example, after the Kahui twins incident, suddenly in 2008 we took an extra 1,000 kids into care and reduced that number back over the following 3 years. We've now had the incident in Hastings, which has generated at the other end a degree of angst in the other direction. And it seems to me at the moment, without this type of information that I'm suggesting in terms of legitimacy as opposed to accountability, this system will always be driven by extremes. And if I can add a point of Maori woman, if you think about it, a woman who is 20 and having a baby now has probably got no less or more capacity to relate to a state institution than they've ever had. However, right now, the Maori mothers are likely to have a grandmother or a great-grandmother who was part of that group that went through the 1970s, mid-80s and extraordinary rate. Now, if the grandmother or great-grandmother didn't, then sure as hell their neighbour or whānau. These effect of the 70s was a community shift, not an individual shift. And so I think Oranga Tamariki has also got to think of its legitimacy in terms of a degree of distrust of itself that it inherited. And the assumption that it was a new ministry starting with a clean slate is sort of fine, but not really. I mean, most of us, or at least when you get to my age, you have parents that went through the Depression. And, we lived for the whole of my life until they died. I heard of the Depression. So therefore I can see how that sense of the trauma, the impact, carries on through in extraordinary ways, not to everyone, but to a good group of people. And I think that aspect is completely underrated or undervalued in the operations at the moment, in that sense of legitimacy. It is a hard job Oranga Tamariki has taken on because of its history, yet it doesn't appear to have thought enough about that. I'm not speaking, by the way, as a well-organised statistician, but slightly more loosely as someone who's been involved in public sector management, and therefore somewhat more challengeable.
You did mention towards the end of your introductory comments that with the data sets the government is now building, there is potential for better outcomes or analysis. Can you just clarify what that refers to, and does it also include Oranga Tamariki and the issues we're addressing?
There is better analysis of pathways because for the first time we have the ability to keep an individual's experience and follow it through. What is important to recognise the limitations of that, though, is that the only information that you are gathering in that is the information the state requires to administer its laws. Whereas if we were to have, for example, a statistical survey, as we do in the justice sector on crime, then there's an element of criminology theory there in the sort of questions that people are asked that certainly the state would not normally ask.
Which arm of the state is currently gathering that data, or is it several?
Statistics New Zealand, through its integrated data infrastructure, pulls together data from quite a wide range of agencies, including Oranga Tamariki, the prisons, justice, and inland revenue, health, for example.
All right. And so for our focus, we were, while we're looking at the Oranga Tamariki and its predecessors, we're also trying to have a focus on 2015 to the present. That work that Statistics New Zealand is doing, is that still under development, or is it?
No, there's no reason why the tribunal, for example, couldn't initiate its own inquiries and expect one of the agencies that is responsible for you to manage that. They should be able to get any data you want out of the integrated data infrastructure, or any study that you particularly want to initiate.
So the integrated data infrastructure covers all core Crown agencies?
Yes.
Courts?
Yes, it covers courts. Yeah. In fact, I've done a study where I've followed every person born since 1981, and I can tell you their cumulative experiences through the justice system by ethnicity and gender, right through to 2017, that someone in the Ministry of Justice did for me, for example. And so similar sort of inquiries, it's a very powerful tool and is available to the courts as much as the public sector, I would expect. All
right, and from your understanding of that tool, and just again looking at the period 2015 to now, when we're specifically looking at the taking into state care of Tamariki or Māori children, not just babies, would your expectation be that the quality of the information that might be available from not only Oranga Tamariki but from the justice sector, including the courts, that there could be additional and better quality information than we currently have before us through the Children's Commissioner's report, for example, but also available from the family court, for example, in terms of outcomes? I know you've identified issues about the opaqueness of, but would it be a fruitful line of inquiry for us to ask the question?
It would certainly be a fruitful investigation, because also the 2018 census, for example, is integrated in that data set. But it will be limited by the recording habits of agencies as to whether that data has been put in a sufficiently systemised data system in its own right to be integrated into the Statistics New Zealand system. But it is an immensely powerful infrastructure.
Thank you. All right, I think I'll leave it there. Sorry, my colleague has one further question.
I don't know if this has been covered, but earlier today we heard one of the witnesses talking to us about particularly babies whose father is not recorded on the birth certificate. So do you know if, for example, there was a very recently born child who was going to be taken away and the father was not listed on the birth certificate, how is the ethnicity of that child determined?
I can't answer that question.
Okay. That's fine. Thank you.
Ms Cassidy.
Just two questions, Sue.
We
Maybe.
have- We have some questions. Mr Benyon led, and I've been given 2 questions to lead from other council from across all that further amplification. Didn't seem right for him to do it, so if I could have leave at an appropriate time for those questions to be put.
All right. So we'll finish with the tribunal and Ms Cassidy's questions. I'll then check with Crown Counsel and then come to you, Ms Sykes.
It was just one question, and I'm just taking note of paragraph 21 of your paper that you went through, just around Indigenous populations where connections are based on whakapapa and how that's central to survival as a people. So that's the background context. But when you talked about that 10-year period from 1989, around the time of the release of Pu Aotearoa, where there was no data, and wondering if has there been a comparative analysis, perhaps with other countries where Indigenous peoples are, and the state collecting data that you're aware of?
I do know that in Australia, for example, the collection of Aboriginal data has been generally very poor, and of course they weren't even included in the population census of Australia until 1966 because they didn't get into their constitution. The British have only collected ethnic data since 1991. I can be sure of that. The Canadians have had ethnic data, but then again, there has been quite a lot of issues in terms of in different Indian bands, for example, in terms of no longer wishing to connect with some of the information gathering of the state in Canada. So there's been quite a few different issues. New Zealand, in a way, I think you'll find has the richest information about its different ethnic communities and about Maori, for example, than any other country. Of course, earlier on, if you went back to the 1920s, people used to go around, often policemen, and say, here's a whānau, there are X hundred people in it, and identify their iwi, and we would identify just simply numbers. And we collected ethnicity by biological shares until 1981, and then since 86 we've both asked for self-affiliation, but also were you a descendant of a Maori? And then from 91 we asked your iwi. So I would say genuinely that New Zealand has, or the United States has some very good information too. The United States and New Zealand probably have the richest ethnic information of those so-called Anglo countries.
Thank you, Sue. I've no further questions.
Thank you. Ms Sykes, how long?
About 5 minutes. It depends on the exuberance of the answers from my friend, but it's a general proposition, and it relates to paragraph H of page 2 of your brief. And we're just wanting to explore as part of that, you identify in the algorithm tests, for instance, mothers are likely to be younger and have more information about wider whānau connections. Does that mean gang connections also? And these are the kinds of information that's assisting them in making these predictions as
Ms
to the
Sykes, could you just put
suitability?
your microphone, sorry, a bit closer? Thank you.
So it's
Can you just
page 2, paragraph H.
Oh, right.
Are we in the first or the second brief?
Sorry, it's in the July brief, Sue.
That's this,
A40.
A40.
Thank you.
I have difficulty with my own papers.
Okay, so the propositions you put today are that certain information that's provided makes predicting of a suitability of a mother in particular based on whānau connections. Would that also include gang connections?
It could do, yes. It could do, yes.
And in your discussions as to why numbers increased in despite the 1989 immediate drop of Māori children taken following Pu Aotearoa, One of the key questions being asked by many claimants is, did that increase also have a connection to the socio-economic factors, for instance, the mother of all budgets, Rogernomics and its impacts on Māori families, the unemployment rates, and the general state of whānau well-being as a consequence of state policies of privatisation that impacted on Māori families? Would that also be an important context to be taken into account as to why those numbers dramatically increased during that period?
The numbers before 1989?
Yeah.
Before that period, if you think about it, we actually had a very large migration into urban settings and employment by Māori, men and women, until the economic changes in the late 80s. And you could therefore assume that in fact, the economic position of the ordinary Māori was probably the best it has been. Yet at that time, we had the highest rate of children coming into care and the largest number. When we ended up, ironically, with the 1990s, the mother of all budgets, as you put it, in fact, that was the period when we had the lowest number and the lowest disproportionality of Māori in care. So in fact, you could say that it is both the demographics and the policies of the state and their administration that determine each generation of kids in care rather than the economic position of households. Having said that, Oranga Tamariki in the last 3 days has released a report where they have analysed using the data that they've got in much the same way as the prison service does, where they have argued that where there is disproportionality, it is overwhelmingly explained not by their activities but by the socio-economic position of the people that are selected. I think there's a real difficulty with those analyses in that it sort of assumes that the state has got a whole lot of tentacles that are unrelated to each other, and that in fact the prison service and child welfare service are special little arms here, and I think there's one danger in those analyses. It possibly allows those institutions to think that therefore they have no contribution to disproportionality. And yet it is one element of how I would argue that those type of analyses are just one part of the mix of studies that you would want to carry out if you wanted to answer the question that you've raised. I think it's such a difficult question. There are a number of ways you could address it, and they may give you different answers. I've just given you 2 different answers.
Okay, then can I go in terms of the questions of data sovereignty and the protection of whakapapa? This is the last question. And the sharing of information, as you've said, between Inland Revenue Department, police. It happens every Tuesday in Rotorua at 9 o'clock. Police, social welfare, health get together to say which families are at risk. Isn't there a concern about the protection of some of that private information about the whakapapa of those families and the impacts of how sharing that information actually impacts on the rangatiratanga of that whakapapa and who owns it?
Can I say, I don't have a yes or no answer, but I think it is something that we ought to very seriously regard as something that ought to be regularly considered and thought about. Can I say, when we first introduced an iwi question into the census in 1991, when we published the results, we had huge concerns about whether this was the role of the state or not. And when we first produced those results in 1991, we only gave the results to the individual iwi that it was related to. The difficulty we found is that in some iwi, the individuals that received the data regarded it as private. So in 96, we changed it to shift the obligation to be much more, but Stats has never produced iwi comparisons. And I think that issue of where should the state be is something that is probably contextual and of the time and ought to be regularly challenged.
But isn't the question, where should the protection mechanism be if that information or that data is being used, if we go back to your paragraph H, to make the assessment of the suitability of the mother and her whānau, particularly where they're cross-referencing or cross-fertilising it with her ex-partner or the father of her children she's now living with, or her brother who's in trouble but not her.
haven't
So
you got...
where is the protection mechanism
Yeah.
for that to occur?
You've got two questions there, haven't you? One is this, how much is whakapapa an item that the state should regard as having possession of? And the second is, how does the state run its artificial intelligence mechanisms, and should they be open? And I think the second question is one that there should be guaranteed transparency and systems for their continued validation in their operation. We should not have non-transparent mechanisms that replace individual discretion in how they operate.
And if we had those mechanisms, we'd still get reliable data in terms of the questions following on from His Honour, in terms of trying to find trends and reasons for the uplift of children or the numbers in state care over decades.
Well, you've got a lot of information now without having whakapapa here.
And that would be sufficient still.
You're taking me into areas where I'm not sure that my competence in either the justice system or child welfare is actually helpful.
Thank you. I have no further questions.
Thank you. Ms. Hardy, I think I neglected to check in with you. My apologies. Did you have anything?
No, I assumed I was following Ms Sykes and no questions, sir.
That's good news. Thank you. Thank you, Mr. Cook. Thank you very much for your evidence. It's been very helpful. And you're free to stand down. I just want to acknowledge all of the witnesses who have appeared before us today. It's been a long day, but for us, a very valuable day. So just recording appreciation for the insights that have been shared by all of the witnesses we have heard, and for the work of counsel who have assisted the witnesses, and for Ms Cassidy also, thank you. Sir John, ka tukunu atu ki a koe tarakau ki whakakapi tā tātou nohoanga I naina? Or...
mai tō inga tapu kei rungi tēnā tiana o tātou mai I te mutu ko tēnei rā. Reire kia tau kia tātou katoa te āta whai o tō tātou riki riko Christ. Ne te aroha te atua, te whinga tahitangi te wairua tapu ake. Amen.
Amen.